Check 1 2. Hey, hey.
My brain is.
So welcome to the September 26, 2022 Zoning Board of Appeals special meeting of the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I am now going to do a roll call. I'll start with myself, David Murch.
Greg Dean.
Tom Hennessy.
Fred Miller.
Pete Lockwood.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you're unable to see or hear. The board works from a published agenda and will be considering tonight's items in the following order. Call to order. Number 2, old business, specifically deliberations on the following matters tabled on August 30th, 2022, administrative appeal, re-notice of violation issued 3/10/2022, applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine. And we will have public hearings on the following matters tabled on August 30, 2022, administrative appeal, re-notice of violation issued 1/28/2022, applicant Erosion on behalf of Management Controls LLC, and the administrative appeal re-notice of violation issued 3/10/2022, applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine. Both of those are for location 28 Whitetail Lane. And then we will have adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board decides on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearances this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, their address, and affiliation with the application, either being for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board has formally adjourned. Any discussions not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside of the meeting. So as we've gone through our call to order, we are now moving on to old business. And again, deliberations on the following matters tabled on August 30th, 2022, an administrative appeal, read a notice of violation issued on 3/10/2022. Applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine LLC, Robert Durant, member and manager. Location 18 Fernwood Road. Description: administrative appeal from notice of violation. So, Attorney Wagner, you have been assisting our board with these matters. If you would sort of further assist by kind of taking us through these next steps.
Sure. Good evening, everyone. Just a quick heads up, I'm working on a laptop remotely, so I don't have my normal size screen, so I'm actually going to be switching through. So if you're used to me being able to read your facial expressions to respond, you'll just have to shout if it looks like I'm not looking at you, because I'm probably not. So with that, the remaining item of business for this appeal, the 18 Fernwood for Big Lake Marine, at the last meeting, members Murch, Lockwood, and Miller opened and closed the public hearing and reached a tentative decision to deny the appeal in part and grant the appeal in part. And I have prepared a written decision summarizing the findings and conclusions that the board made, and I circulated that earlier today. So my recommendation is that for this, for reviewing this and voting on it to issue the final decision, on this appeal, we keep it to just members Murch, Lockwood, and Miller. Is everybody on the board okay with that?
Yes.
Yes.
Okay.
I just had one question, Attorney Wagner. Do you want us to catch any typos or
Sure. Yeah. Please go ahead.
nothing of big content? Just
No, understood. I was under the gun on that one, so I apologize. And I certainly appreciate you flagging those, and I'll, as we have before, make any changes and circulate that around tomorrow so it can be signed.
Even if it's merely typos, I can fix those tomorrow for you and have
Okay.
come in.
I appreciate that.
Then it's to you,
I appreciate that.
of course.
So have the members had a chance to read the draft decision?
I did read it, review it. It had one correction that I believe needs to be made. It was for item 6, where violation 7 should be vacated. That was a 2-1-0 decision. Specifically, it was talking about the clearing and removal of vegetation under 3 inches within 100 feet of normal high water line. That was the one where I did believe that the town had provided enough evidence that the appellant had cleared the vegetation. So
Okay.
that was the decision.
Did I accurately capture the vote on the next item, number 7, where I have it as the 2-1-0?
Yes, that one's
Okay, so both of those were 2-1-0.
outside of that. I didn't notice anything else.
Any further comments or corrections from the members?
I have nothing. Yeah, Steve, if you could just kind of, in item number 7, violation 8, if you could just take a quick look at the second to last paragraph where it says, a minority of the board finds that the town did not submit sufficient evidence to show it was BLM that was responsible for obtaining the permits. I'm just wondering why it was worded that way instead of a majority of the board did think, I'm just curious the way that the vote went.
Sure. The intent was to just reflect the views of Chairman Murch and his reasoning, but I agree. I could state it in the from the perspective of the majority and reword it.
I'm fine. I just wanted to make sure I understood it.
John, did you have something with this? Just from the typos perspective?
there was, I'm trying to find it. There's 1 or 2 that deal with the vegetation. And I thought when I read this the first time through, the word violation was there where vegetation belonged in the paragraph.
Okay, I will make a note to run through that. Appreciate you flagging.
Oh, yeah, I see that as well, Tom.
Stephen, would you like me to just fix those 2 minor things tomorrow?
No, I'll run through it, Sandy. I
Okay.
appreciate that though.
Of course.
So if there's nothing further, then I would suggest a motion to pass the decision as written, subject to those modifications.
So moved. Do I have a second?
I'll second it.
Do we have any further discussion? All those in favor? David Birch, yes.
And Miller, yes. Lockwood, yes.
All those opposed? All those abstaining? Greg, here's your chance.
Are we supposed to abstain?
Yeah, why don't we'll mark you as abstention, sure.
So that's it.
Okay. So that's everything on that matter. So I turn it back to you, Mr. Chair.
Take over. So moving on, public hearings on the following matters to live on August 30, 2022. Administrative appeal, re-notice violation issued 1/28/2022. We also have a follow-up administrative appeal, re-notice violation issued 3/10/2022. Both of these were tabled. So I need a motion to take these both off of the table.
So moved.
Seconds.
Second,
For the conversation, all those in favor of taking these off the table, David Rich, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Ed Miller, yes.
Pete Lockwood, yes.
So the first one we will address is the administrative appeal from the notice of violation issued 1/28/2022. Baby Rajan Esquire on behalf of Management Controls LLC, location 28 Whitetail Lane, description administrative appeal from notice of violation. So again, Attorney Wagner, you've been great to assist us as we go through these. Can you sort of lead us again through the process? Where should we take it?
Sure, thank you, Chairman Murch. So we'll follow the same process that we have on the prior appeals. So this is a de novo hearing. The board can must accept new evidence. The applicant has the burden. You undertake your own independent investigation of the evidence and law. And I suggest that we take the issues step by step as raised in the written notice of appeal and as framed by the attorneys, and I'll guide you through that. We've already established a quorum and we're back to the full membership here. And I'll represent that you have jurisdiction for this, and the appeal has been timely filed, and the applicant has standing. I assume the board agrees with that. Seeing yes.
Good.
Okay, so as we have before, if anybody has a conflict of interest or bias they would like to discuss or raise, or any objections based on conflict of interest or bias, those should be discussed now.
Nothing.
Okay, and the record will note the prior conflict that was raised previously. So as before, the sequence of presentations will begin with the appellant without interruption, followed by questions by the board for the appellant, and then questions by the town and other parties for the appellant's witnesses. And then we'll turn it over to the town and follow that same order. So with that, Mr. Chair, I recommend you pass it over to Attorney Rachin.
So, Attorney Rachin, it is our pleasure to hear what you have to say.
Great, thank you. Good evening, everyone, Mr. Chairman, members of the board, fellow council. As you know, my name is Leah Rachin, and I am here on behalf of Management Controls. Just as a threshold logistic issue, I just wanted to make sure it's been written in all of the decisions, and I think that all of the parties, council, agree that the record for one case is the record for all. And so to that end, I did submit earlier today, just so that we have everything consolidated into one repository of information, the record of all of those documents that at least from my clients have been submitted in the prior appeals, and also those that I will be relying upon today. So I just wanted to make sure first and foremost that folks received those, and that those are, you know, I understand perhaps that as we go through that there may be some objections to that, but they'll be handled as we go. But I did want to confirm that everyone received those records, or documents, I should say.
I did, yes.
Just to clarify, this is the, you're referencing the DWM law share link that was shared?
Correct.
Okay.
Yep. And that's more for the purposes of Sandy actually to keep the record. I didn't add anything to what was already before the board, but I also included those things that I will be discussing today. But when I'm screen sharing, I will have those documents also readily available so that I can walk the board members through as I go. Okay. All right then. So turning to the merits, obviously this is not the first time that we have met. You've heard lots of testimony, you have heard lots of argument, you've reviewed lots of documents. But I think it's really critical to emphasize before we get into the meat and potatoes of what we're doing tonight is that we're dealing with whitetail. And whitetail is a very different property than Fernwood. And so I would ask of you to keep that firmly in mind. As far as the differences, and I think actually those differences are well reflected in the document submitted by the code enforcement officer himself, that the bottom line is that the original state of this property and all of those before pictures, you will see that this property already had extensive riprap on it. And so this, as I said, it's a different property, different considerations. The other thing I think is very critical to bear in mind is that, again, the code officers before pictures very much demonstrated there was an existing beach on this property. Another piece that is different from Fernwood is that only a portion of the shorefront here on the whitetail property was impacted, and less than 100 feet of that shoreline was affected, whereby there was actually a permit by rule that was sought for that portion of less than 100 feet. There's another small stretch, and we'll be talking about this as I go through, but that there was existing riprap, and all that was done essentially was to add some riprap on top of the existing riprap, which in essence is really maintenance of the existing riprap. And finally, it's also important to note that a very large portion of the property and the shoreline was not disturbed at all. So again, different property, different factors, and I would just ask that you be mindful of those things. Excuse me. And so, as is the case with our prior appeals, I just want to talk about there's some themes here at play, and I'll round those out a little bit more fully, but just to set the stage. The first, of course, is that this notice of violation was issued to the wrong person. We've talked about that before, and I'll get into it a little bit more. The second, of course, is the duplication of the various violations, and it's our submission that it really is just a blatant overreach and an attempt to increase fines, both collectively as to the number of parties who are being tagged for the same violation, and also even within the violation itself, you'll see that there are numerous violations that are actually related to the same exact activity, and the same exact provision of the shoreline zoning ordinance, which is purported to be violated, is cited for multiple violations. And so I know you've heard this before, but I just wanted to reiterate that this is clearly a tremendous amount of duplication that is unnecessary here. The next piece, and we'll get into this more as I examine the witnesses here, is that the evidence simply does not support a conclusion that a number of the alleged violations actually occurred. And we'll get into that as we move through. Another thing to keep in mind is that the notices of violation, all of them here, that's just a characteristic of any notice of violation. In addition to outlining what the alleged violations are themselves, another critical component of that is to talk about the corrective measures or corrective actions that will be required. And it's important to understand here that almost immediately when my client became aware that there was a violation, they reached out to the DEP, to the town, talked about how, okay, we need to remedy this, and in fact, hired an expert to do that, who submitted several after-the-fact permits to rectify. Again, we're not admitting that there were in fact violations, but in order to work with the town and to make sure that we were addressing concerns, did that. For whatever reason, the town found that particular expert's submissions to be unacceptable, not in any way conceding to the fact that that's the case. Again, in an effort to satisfy the town that we were taking all necessary steps to have a property that was in compliance, retained another engineering firm to submit an application for the restoration work, for various after the fact permits. Again, that was rejected. So we have been trying at every turn to meet the town's expectations, and at every turn we have been rebuffed. And so I just wanted to make sure that that was also clear for context. So back to the argument of the wrong person, okay? I'm going to bring up, am I able to, can you allow me to screen share, please? Can I do that?
Chair's perspective, yes. You are,
okay.
You certainly do.
And are you able to see these submissions here?
Yes.
Okay. And so right here, I just wanted to focus in on this. The document you've seen before, but it bears emphasis that this, as you will see, is the contract between Big Lake Marine and my client Management Controls, and this is with respect to the White Trail property. As you can see, the very first entry, the very first requirement of this contract that is that Big Lake Marine will obtain all necessary permitting from the town and DEP. That was an extremely important criteria for my client. It was clearly specified right up front. It was the primary obligation. And as we know, unfortunately, we're here, that was not met. And it's also critical to understand that my client reached out to who they thought was the premier shoreline contractor in the area. And here, are you able to see my screen here? I just want to make sure you can see that this is an excerpt from Big Lake Marine's website. You can see that? Yes, okay. And so clearly what we do, Big Lake has become the premier waterfront service company and offers a variety of services. So relying on a contractor who's the premier waterfront service company, and again, the first thing of what they do, permitting services, state and local. So again, just to emphasize that my client reasonably relied on the contractor to, in fact, secure these permits. Excuse me. So the second argument that we have talked about before, but I also want to make sure that we talk about it again, is the duplicative nature of the various violations. I'm going to stop sharing my screen for a moment. As with the Fernwood property, the NOVs relating to Whitetail are replete with examples of overreach and duplication. And when, as I said, look at both collectively and individually, that it's very clear that, the town is attempting to get fines for, to exponentially increase the amount of fines that they could get by essentially duplicating, duplicating violations that in fact really should be consolidated. And we've talked about this before. I'm going to say it again. Why does this matter? It's really important to understand that we're not here simply just to parse an NOV. The reason why we're here is because the stakes are very high. As you are maybe well aware, the town is threatening fines in excess of, at this point, I think it's $2 million. And according to the town, those are accruing every single day. We disagree with that, but yet that's the town's position. And so, that's why we're here. We want to basically make clear that this attempt to artificially inflate both the number of violations and the extent of these violations, and especially by refusing to even entertain our after-the-fact permits, which were the very requirement of the corrective action, is just really problematic and very much unfair. And so that's the context in which we're dealing with these issues. And I want to make sure that everybody's aware of that. And so I can go through at this point, and actually I think for purposes, I may just hold this off to our summation as to the consolidation and what the request is there for consolidation. That probably is the most efficient way of going. But the third thing that we want to talk about is, as I said, the fact that some of these alleged, in fact, many of these alleged violations are not, in fact, violations, and the evidence will show that, hopefully, and then we submit it will throughout these proceedings. And so what I'd like to do is actually call the first witness to go on and basically put on evidence as to why the notices of the violation and the alleged violations simply are not substantiated.
Sure, that would be fine from the chairs.
Okay. And so in that regard, I'd like to actually call Alex Soroy as our first witness.
Yep.
May I proceed?
My perspective, yes.
Thank you. And so, Alex, can I call you Alex? I know we've been doing this quite a bit. Are we there yet?
Sure
can I call you Alex?
Yeah.
Okay.
I think so. Yeah.
Okay. Thanks. And we know you are the code enforcement officer.
Yep.
And I think we did talk a little bit about your educational background, but just refresh our memory if you would.
Yeah, I'm a state certified code enforcement officer.
And as far as your undergrad background, can you discuss that?
I have a bachelor's in communications.
And do you have any degrees or certificates in environmental engineering?
I do not have a degree in any type of environmental engineering, just through the state certification process.
Okay. And how about, same question for, what about surveying?
Same answer. I don't have any degrees or anything in surveying.
And what about geology?
Nope.
And civil engineering?
Nope.
Okay. And so can you tell us a bit about when you actually first became aware of the work that was happening at the Whitetail property?
Yeah, October 14th, 2021.
And how did you become aware of that?
We received multiple emails, the first of which from Alexis Savavlos from DEP, and the second from the deputy fire chief.
Okay. And what was the concern of the fire chief? I'm not sure we've heard about that before.
Yeah, they actually drove by the property on the fireboat later on in the afternoon.
And from a fire safety or emergency services perspective, is that something that they were concerned about? It was more just a heads up, this is happening.
Yeah, I think they noticed it, and it was clearly something that didn't seem right in their eyes.
Okay. So you noticed, I think you said you got some emails on the 14th of October. When did you actually attend at the property?
I believe, without having it in front of me, the dates in front of me, I believe it was October 26th.
Okay. And who was there with you?
We met with DEP, both Jeff Kalinich and Alexis Savavlos. We also met with, at the same time, Rob Durant and Nathan Whalen from the Portland Water District. I believe that was everyone.
Got it. Okay. And so when you did go on site, what equipment did you bring with you, if any?
Equipment, I think I probably just had my phones. That was probably it.
Okay. And have you ever obtained a survey for this property, the town?
I'm in receipt of a survey of this property, which was given to us by either the property owner or his engineer.
Okay. And are you referring perhaps to, I'm just going to bring it up. I'm going to share my screen if I can. You able to see it?
Yeah.
Just so we're talking about the same thing. Is this the survey that you're referring to?
I believe so.
Okay, I'll make it smaller. And in fact, it's not just a survey, but this actually indicates that it was approved by the town's planning board as a subdivision plan. Do you agree with that? I'm scrolling up here. There's a signature
Yep, that's
block.
the subdivision plan. Yep.
Yeah. And so it's both a survey. Can we agree that it's both a survey and the subdivision, an approved subdivision plan?
It does appear to be, without reading all the notes, but it looks as though it is.
Okay. All right. Thanks.
There's also a more recent one that I've seen since, that shows the shorefront prior to the work that's been completed, and then it also shows a shoreline after the work that was completed.
Okay. All right. So when you were at the property that day on October 26th, I think you said, with all those folks from DEP and Durant and his representative, did you actually consult a survey of the property that day? Did you have a survey with you? No,
we didn't. I didn't have that. Then the survey I just mentioned the subdivision plan we had on the file, but the survey that showed the normal high water mark prior to work and after work, I think I was just given that like 3 or 4 months ago.
Okay, thank you. And then when you were actually drafting your notice of violation, did you have that survey plan, the 2007 plan with you?
Yes, yeah. We did review that before issuing the NOV.
Okay. All right. And when you actually were preparing to go to the site, did you do any preparation? Did you speak with anybody about, what it was that your task was, or?
Can you be more specific? I would say yes, but I don't think that's the answer you're looking for.
Okay. Well, I guess let me drill down a little bit. So with whom did you speak in preparation for that meeting?
I think I spoke with my assistant, Chris, and my town manager. I think we also may have, I can't remember if we spoke on the phone with folks from DEP or not prior to, I can't remember. I don't think we did.
Okay. And to the extent that you can recall, can you tell me a bit or the board especially about the substance of those conversations?
Just that, we felt it was based on the photos, it was a very serious violation. And it was definitely one that we were going to need to likely retain legal counsel for. And we may have, I don't think we did speak with the attorney prior to, because I think we had inspection photos when we spoke with the town's attorney and realized that there was a conflict. So yeah, that wasn't prior to that site meeting.
Okay. All right. And so were you able to determine when work actually commenced? And Durant was there, correct? I mean, he was on site. Did you get a sense of when that work commenced?
Well, no, what I do know is the before photo taken from the drone was taken in August.
That was,
so I know.
let me just be clear. The drone photos, that was taken by the Portland Water District, correct?
Yep.
Okay,
Correct.
so fairly soon. If those were taken in August, you attended on the property or heard that there was some work being done in October. So fair to say, so at some point in September, early October.
Yes. Yeah, I would say that's fair.
Okay. And do you have any sense of how many days it continued?
From what I can tell, work stopped at least by the day that we visited the site on October 26th.
Okay, but let me just be clear. You had said that you had been told or been notified by folks on October 14th. You attended on the 26th. Are you aware, do you believe that any work was conducted between October 14th and the 26th?
I do think so, yeah.
And what leads you to that conclusion?
Just based on the photos that we received from DEP and what the site looked like when I visited it on the 26th. When we got to the site, it looks as though it basically does today. Nothing's changed from that day. I don't believe any work's happened since, but I don't know that, I don't know that work didn't happen between October 14th and the 26th is what I'm saying.
Fair enough. And just to put a finer point on it, when you became aware on October 14th that this work was happening because you were notified by others, did you reach out to either the property owner or Durant to say, hey, hold the phone? Or you obviously had some communication because you had to set up this meeting on the 26th. Can you tell me about that?
That was the conversation. It was, definitely need to hold up. There's no town permit and we need to meet on site ASAP.
And when was, do you have a sense of when, as between the October 14th and the 26th, that conversation happened?
I don't know off the top of my head. I could look, but it was pretty quick. Either on the 14th or the next day. It was pretty quick after that.
Okay. And at some point you issued what we could call a verbal stop work order, basically stop.
Yeah. And
can you pinpoint roughly when that was?
I believe it was that week, the week of the 14th.
Okay. Okay. And that stop work order has remained in place?
No, there has been a demo permit issued for both properties.
I understand. I should say, when you say demo permit, just to clarify, that was with respect to the house, internal to the house, correct?
And the hot tub area for Fernwood.
But nothing with respect to the riprap, the stabilization work, correct?
Correct. Yeah.
Okay, all right. And I think you said, and you'll correct me if I misunderstood you, that since that you basically said stop all work in that the shoreline area, that has been abided by, correct?
Yes.
I think you mentioned you did not take the before shots. Everything in your submissions with respect to your exhibits, to your notice of violation, all of those photos, as far as you know, were taken by the Portland Water District, correct?
The before photos are all from the Portland Water District. Yes.
Okay. And when you and then a lot of the after photos that are so called in your notice of violation, and I think in the slideshow, those were all taken by you?
Either by myself or submitted to us from DEP.
Okay. And the ones that were taken by you, did you actually make an effort to take them from the same angle, same perspective as those that were taken by the water district? No,
I actually hadn't seen most of the Portland Water District photos that first time we were on site.
Okay.
Actually, I was given it that day. Nathan gave us the drone photo that afternoon.
That day, meaning the 26th?
Yes,
correct. Thank you. Okay, understood. All right, and so just as a general proposition, I'm not talking about this notice of violation, I'm talking about notices of violation generally. That's the world you live in, right? Is it fair to say that the purpose is at least twofold? First is to very clearly identify for the alleged violator the violations, basically what they did wrong. Basically say to them, hey, this is what the problem is, right? Is that a fair characterization? And then the second equally important part of those notices is to identify what they have to do to correct those alleged violations. In essence, how they can come back into compliance, correct?
Yep.
Okay. All right, so let's go to the notice of violation, start working our way through that. And I'm gonna share my screen if I can. Okay. So just with respect to this first violation, violation number 1, and this is for filling an earth moving in more than 10 cubic yards, correct?
Yep.
And I'm reading from this notice of violation that basically the premise here is that there was a significant amount of soil disturbance, correct? Within 100 feet of the normal high water line?
Yeah.
Okay. And what efforts did you make to actually determine where that normal high water line was?
Observe change in vegetation. Visually is what we would look for in a situation like this. That normal high water mark would usually be set by a state licensed surveyor.
Okay. But you didn't have it. So you were doing it by visual indicators. You didn't have a survey yourself, correct?
Yeah, that 100-foot distance that I am mentioning is based on the water line observed that day.
Okay. All right. And how did you measure? How did you measure it out? Did you actually use any equipment, or it was all just visual from your perspective?
The approximate distances were measured through just the measure app on a cell phone.
I'm not familiar with that. Can you walk me through what that means and how you use it?
Yeah, so basically any iPhone has a distance measurement tool included with it that's not 100% accurate, but is usually pretty close, within a foot at least. Okay. And for situations like this, it's a quick, easy way to get an approximate measurement.
Okay. And tell me this, we're dealing with volumes of material like loam and riprap, correct? So tell me what did you use to actually measure the amount of, a supposed loam and riprap? How did you come up with that calculation that was more than 10 cubic yards?
I just based it on 2 inches. If someone had gone along and just pulled back all the grass, which was basically what was done on whitetail, all of the grass was ripped up to the left of the house and along the shorefront. If you take a 50 by 50 foot area at 2 inches deep, that exceeds 10 cubic yards.
And how do you know it was 2 inches deep? Did you measure?
Definitely just kicking with my toe in the ground. That's how much moved around. I think it's pretty clear that Just with that alone, they exceed it. And then you add in all of the riprap that was deposited on site and the mulch that was put on the berms, around the banks. They probably well over, hundreds of cubic yards at that point.
Did you, so you didn't actually measure, you said you toe kicked, right? What about with the riprap? Did you toe kick the riprap?
No, I definitely didn't, but I think it's pretty clear based on the height of that riprap and the length. Those numbers could easily be added up to calculate based on the diameter of the rocks that was added, that they greatly exceeded 10 cubic yards.
And you had mentioned how they had ripped up the lawn, and when we're talking about the lawn, I'm just gonna let me go to some of these exhibits here so we'll make sure that we're talking about the same place. So bear with me. When you're speaking about this ripped up lawn area, is it this area? If I'm looking at the house from the water on the left-hand side, is that what you're talking about there?
Yeah.
Okay. And so are you aware that that is where the staging area was for all of the equipment that
Yeah, that would make sense.
And so basically just traveling back and forth in that area could possibly damage. And I'm looking at this lawn area. It's certainly, at least from my perspective, you've got some blank patches here. This is just, it's certainly not a manicured lawn. Would you agree with that?
Yeah.
And would you agree that by, basically using equipment that's going to possibly damage some of that area, but it's not an actual act of physically ripping up the lawn? Is that fair to say?
I don't know. If you look at the after photos, it looks pretty well graded to me. I mean, I'm not seeing any large ruts. I don't know if you could point to any that you're seeing for where equipment may have been parked. There's also a very significant difference when it comes to the rules on what's allowed when there's a permit issued and not. If a permit had been issued for this activity, it's possible they could have used it as a staging area, and it wouldn't be necessarily considered a violation at that point.
Okay, and I'm looking, again, I'm looking at your Exhibit A here, where this area is, and I see, there's still plenty of area. I mean, if you look, can you see where my cursor is here?
Yep.
So we've got leaf litter, we've got, looks like little pieces of lawn here and here that are just coming up through.
Mm-hmm.
Would you agree with that? You agree with that?
Yeah, I mean, I think you could see that if you look hard enough.
Mm-hmm. But you can see it, is what I hear you say.
Yeah, I mean, the issue is if you look back at the NOV, this particular violation is not as much about volume and disturbance. It's really more about this activity taking place without an approved erosion control plan, which I think is the real issue here. Is this work should have had an approved erosion control plan in place, permitted or not, and they did have erosion control on site, but there's no approved plan.
So let's talk about that for a minute. You're aware that various PBRs or permit by rule applications were applied for, correct?
Yes.
And part of that, and this is the one, actually there was 3 for the different properties. So let me get to the one for Whitetail. Okay. So this was applied for, and part of the description talks about how there's erosion control measures per DEP requirements, correct?
Mm-hmm.
And you see that right here on the form?
Yeah.
And I believe in the notice of violation, we talk about best management practices for erosion control that are based on DEP's regs. Is that correct?
Based on the Maine Erosion Control BMPs for Bureau of Land and Water Quality, Maine Department of Environmental Protection.
And
March 2003.
Would those not be the same best management practices that would have to be used in conjunction with a permit by rule?
Could be. I'm not sure. I don't enforce NERPA, so I'm not exactly sure what it is they look at, to be honest.
Okay, so it is fair to say that, with respect to that permit by rule, that they were following erosion control best management practices in conjunction with that permit.
Yeah, but the section in the ordinance, I guess if I'm going to disagree, doesn't say that, you know, they just need to get a file for a permit by rule. The town wasn't ever given a copy of this erosion control plan that they had prepared at the time of this, particular violation taking place.
Okay.
And I think that's the difference here for us.
And just following up on, I think there was some testimony in past hearings about, in part of your materials, there were some pictures of silt fences kind of not rooted down into the riprap, and that were possibly, not secured sufficiently. Correct? Do you remember that?
Yeah.
But I think you had said that work had stopped, and those pictures were taken after the work had stopped. Correct? So that could have just happened when folks weren't there every day after the work had actually stopped.
I would go to page 16 of the NOV, where there's active work taking place on site, and you can see there's a section where the silt fence is on the ground, about 25 feet or so from which looks like an excavator.
Can I just ask, Alex, so everyone's looking at the same thing. When you say page 16, I don't have pages, I have exhibits. So
yeah, it would be exhibit E. Yeah, this photo right here.
Right. And when was that photo taken?
That I'm not sure. This was one of the photos that was given to us from Alexis. I would assume this was taken on October 14th, the same day she took the photo of Fernwood. But here you can see this is the time where we would want the silt fence in place the most, because you've got all that soil on the bank. And if we got a substantial afternoon rainstorm, that's all headed into the lake.
Okay, but you don't know, I think I heard you say you don't know exactly when that picture was taken, correct?
Yeah, I'm not necessarily understanding why that would matter, I guess, is what I'm saying.
Okay. All right, let's move on to the second violation number 2, okay? So essentially, the violation number 1 is filling and earth moving of more than 10 cubic yards, correct?
Yep.
Violation 2 is the same activity, filling and earth moving of more than 10 cubic yards without a permit, correct?
Yeah, correct.
And so it's basically, in essence, it's the same activity we're talking about with respect to violation number 1.
Yep. I mean, essentially, we just did that to. I like to do that to make it easier for people to break down the areas of the project where activity is taking place. So this is, again, in that same activity. However, the first section was for the lack of the erosion control plan. The second section is actually the violation for doing the work without the permit.
Okay, so when you say section, we're talking about the section of the notice of violation, not the section of the shoreline, right? Just to be clear.
Section of the shoreline zoning provisions specifically that they're in violation of. Okay.
But all right, so it is, I heard you say it's the same activity. And, I already asked you lots of questions about violation number 1. You are aware of your obligation to tell the truth with respect to the answers. And you testified truthfully with respect to those questions I asked you, correct? And so if I were to ask you similar questions based on the same activity for violation number 2, would your answers be the same?
Would they be the same? Is that what you said?
Yes, with respect to.
Yeah.
Okay, and so I'll move on then, so we don't have to. So with respect to violation number 3, this is piers, docks, wharves, bridges, and this is with respect to the boat launch. Okay, and so I'm going to direct your attention to Exhibit B, which is the photographs that you submitted in support of your allegation that the boat launch was expanded. Correct?
Yep.
Okay. And so in that regard, I just want to make sure that this heading relates only, this violation number 3 relates only to the boat launch area, correct?
Let me just take a look. Yes.
Okay.
That is correct.
All right. And so we're not talking about construction here. We're focusing, I think your words were expansion or enlargement, correct?
Yeah.
And so there's an acknowledgement implicitly that this was a pre-existing boat launch area, and you can see it here. You know, you see that area here and here.
Yep.
Okay.
Yep.
And did you determine the high water line relative to this violation?
No, the high water line would have been determined on site, just visually, and that would be probably best displayed by the after photo.
But you were
Before.
saying you did it in the same way. It wasn't by measuring. You didn't have a tape measure. It was by
Correct.
visual inspection, correct?
Yes.
Okay. And the violation itself, going back to it, it talks about expanding or extending, extending over or below the normal high water line, correct?
Yeah, expanded at or below.
Okay. And so how much was it expanded over or below the normal high water mark?
Well, the language there is expanded at or below. So we know it was definitely expanded at the normal high water line that we, inspected the day of, which is clearly shown, I believe, in the before photos where you see two pallets end to end, and then the boat launch that exists.
Alex, I'm sorry, I'm not following. Say that again. In the before photos where you see what?
Yeah, so if you look at the boat launch, if you want to call it that, in the before photos, it was a old wooden structure that was.
And you're referring to this, which I have my cursor on, correct?
Yep, which looks like two wooden pallets, end to end, and what's there now is no longer wooden. It's made out of riprap.
But is there anything? I don't think in your notice of violation you made any distinction about materials. It was just the expansion of the area, correct?
Yep, the use.
Okay. And so, as I said, we're talking about a use that's extending over or below.
At or below.
At or below.
Not over.
Okay, I'm sorry. I think the language is over or below if we're looking at the language, but we don't need to.
Yeah.
But I'm trying to determine, in your notice of violation, you talk about how it was expanded in this way. So I'm trying to understand by how much, exactly how much was it expanded?
I would say it's approximately 16 feet wide now, and was, from what DEP and myself have been able to determine, probably no wider than 8 feet before. Unfortunately, we don't know exactly how wide the previous wooden boat launch was because it's no longer there.
So you don't have precise measurements for how big it was at the time, correct?
We don't have precise measurements for how big it was.
I'm going to object to that. He just testified, and you can't contradict his testimony because you don't like it.
I'm not aware I was actually doing that. But bottom line is, I had asked him what was the degree of expansion. I heard him say he did not have measurements from before. And so by definition, it's difficult to understand how far it's been expanded.
He said he estimated it was 8 feet.
I believe we actually used this photo right here. This is the one that Jeff Kalinich and I had actually talked about because we looked at the stairs. There's no way that set of stairs to the left is any larger than 6 feet or 8 feet. And it looks to be just slightly smaller than that, boat launch. So by that, we figured there's no way this thing was any larger than 10, and we figured it was probably around 8.
So let me just, I need to catch up with you, Alex. So you're talking about this set of stairs here, correct?
Yep.
And you estimated that to be six feet or so?
We figured it was no wider than 6. And that's based on, average aluminum dock stairs like that, or no more. No, usually 4 feet. 4 feet's the allowed width. So we said, okay, maybe they're 6.
Being generous, 6 feet, fine. So we're going to move along to here, which is the expanse of the boat launch already, correct?
Yep.
I'm not sure how you're getting. We don't need to dicker around this, but the bottom line is, You did not have.
Well, I mean, I do think it's important. I think what you're trying to say is we can't prove that it's been expanded. Is that what you're trying to say?
I'm not trying to say anything. I'm asking you questions about what your measurements were based on.
Yeah.
About
So
how it has expanded.
okay, so then to answer that question, we based it on photographic evidence from the site previously existing prior to the work. We used our opinion based on the stairs and what looked like a rowboat we figured at the top of the dock, and use that to kind of estimate what we believe.
That was how you were scaling it out, so to speak.
Yeah, unfortunately, we were never invited to the site prior to the work being done, which had we probably could have, but we weren't, as you know.
Okay. And these drone photos, right? These are the drone photos, the before ones, correct?
That's a drone photo. The photo we were just looking at actually was taken from the water by a Portland Water District intern. I believe that was 2000. Can't remember the year, 2014, maybe that one. But this is the drone photo. This is August, yeah.
And they don't come with any scale or anything like that. So you're just making your best guess, essentially.
We actually may be able to do that. I can find out about that. I know the company has specific GPS coordinates on everything.
But right here, right now, you don't know, correct?
No.
And when you were issuing your notice of violation, you did not
know. No, just based it on like I explained a minute ago.
Okay, fair enough. All right. Moving on to violation number 4. So once again, this is based on the same provision of the ordinance, the land use table. Talks about piers and docks and wharves, but in this case, we're talking not about the boat launch, but the shoreline itself, correct?
Mm-hmm. Yeah.
Okay. And I'm just going to go to that table. Bear with me here. Okay. And so we're talking about this section here. This is the land use table, correct? And this is the provision 17 that we're talking about. And so just from a conceptual standpoint, when we're talking about land use tables, the point of these is basically to talk about, basically it enumerates, it's a list of the various kinds of uses or structures that either here are allowed, not allowed, and then it specifies who the appropriate authority is to grant a permit in that case, correct?
Mm-hmm.
Okay. And so subsection 17, it references piers and docks and wharves and bridges and other structures and uses, right? Extending over and below the normal high water line. I don't see it saying the shoreline itself is a use or a structure. Is it your submission that it is in fact a structure or a use?
Let me just take a look here. I want to see where you're at.
Sure, right here.
And this is in 4, right?
This is section 14, table of land uses. This is what you, it is violation of 4, correct?
Yeah, so what we're looking at here is the area where that boat launch previously existed has been expanded, and this is where you were getting to a second ago, below the normal high water mark as we found it. And
so Alex, let me just stop you there. I want to be real clear on this. Are you saying that the only aspect of the shoreline that's been expanded is with respect to the boat launch?
For this particular property, yes.
Okay. So just again, to clarify for the record, it's your statement that the only area of shoreline that has been expanded in this area is with respect to the area on where the boat launch is located, nowhere else.
Yeah, I'm fine saying that for this. I don't believe that I have, any other evidence other than the boat launch at this point.
Okay, so let me just look at, we're just broadening the lens a little bit here, literally. So this is the shorefront here of the whitetail property, correct?
Yep.
And so it's fair to say it's heavily riprap already, correct?
Yeah.
Okay.
Yep.
All right, and so it's really only this area that you're talking about?
Yeah, actually, you got your mouse on it exactly.
Okay, perfect. Thank you. Just give me 1 second. I'm just looking at my notes here. And could you tell me, again, I'm looking for precision here, how much was the shoreline at that boat launch area actually expanded in your view?
Yeah, so if you exactly where your mouse is, you'll notice that the shore has a kind of a jog in. There's kind of an S bend here. You can kind of see from where the dry rocks meet the wet rocks that there's a curved line.
You're talking right here.
Right there. There's a little pocket right there. Exactly. Now, if you go down to the Exhibit B after photo.
Okay. This one here?
Nope. Down one more. Right here.
Yep.
That jog is no more. There's now a straight line that goes across where the silt fence has fallen onto the ground. Exactly, actually.
So can I ask a question? Just humor me, because math and spatial relations are not my forte, okay? But if you have a straight line, as you have shown that we're looking at right here, correct? As opposed to a jog of a shoreline, that's a U, wouldn't that U necessarily be longer? And so, in fact, this actually shortens the shoreline? Doesn't expand it?
I guess if you're talking about length, but if, for example, let's just say this property owner owned up until the normal high water mark, for example, and they decided to fill in some of the lake so that it was straight across. Now they own more land up to the normal high water mark instead of that, small section of area being water. That's what I would call expansion. They're not making it any longer. Actually, our shorefront definition is pin to pin, so the jogs don't really matter.
But shorefront, I thought, is defined as the normal high water mark, right?
Our shore frontage in our ordinance is from corner pin to corner pin.
Right, but you didn't talk about shore frontage in your notice of violation. You talked about shoreline, expanding the shoreline, correct?
Yes.
Okay. Let me just get there for a second. Okay. And the definition section, I'm just going to go to the definition section in the ordinance.
Yep.
Shoreline, the normal high water line or upland edge of a wetland. And so I guess what I'm trying to ask you is how exactly and by how much the shoreline in that area was expanded.
Well, I can't give you an exact amount, but I can tell you based on the photos submitted in the exhibits that the S curve is no more, and it's now a straight line, which means something had to get filled in. Okay.
All right. I'm going to move on here. And I think actually some of my questions may not be necessary because I think your testimony has clarified that you're not talking about the entire shoreline, but rather limited to a certain area. I just want to make sure.
Well, hold on one sec, Leah. I just want to make sure that we're talking about the same thing here because I'm talking about, when I say that, I'm saying they only filled in or expanded that particular portion. I'm not saying that they, didn't do, unpermitted stabilization of that entire, riprap shorefront. I don't know if that's what you're trying to get.
Well, yeah,
I don't know.
I'm glad we're clarifying here because to me, there's a difference between expansion of the shoreline and unpermitted stabilization. What I'm making sure.
Yeah, that's why they're two separate violations on the NOV.
Okay. All right. Yeah, and you're talking about number 8 is what you're talking about. Okay. All right.
Yeah.
All right. Let's move on then. So we're on to violation number 5, which is the creation of a beach, right, without a permit. Yeah. And so I'm going to your exhibit about that creation of the beach. And actually not creation, it said construction. Reading your language, it says construction of a beach, correct?
Mhm.
Okay, and so looking at Exhibit C here, this is the before photo, correct?
Yeah.
And here are the after photos, correct?
Yep.
All right. And so you would agree with me that there was a beach already there, correct?
Well, I wouldn't necessarily say there's a sand beach there. I would say there is the shore front with a lot of large rocks and boulders that have been removed.
Okay. And I'm just going to direct your attention to Exhibit D of your raw materials. Again, this is the before shot.
Yep.
And I'm looking at that area of what I would call beach. I see sand and I even see beach chairs. Do you see those?
Yep, and then I see some rocks under the chairs, it looks like. And I don't see those rocks anymore. I don't know if those were removed. It looks as though they're gone. They weren't the dark color that's currently there. They weren't the,
I'm sorry, I didn't mean to cut you off, please.
go ahead.
And as far as beaches go, fair to say that beaches are not static, that they change over time, that sand gets deposited or rocks can fall or move.
Yeah, you could say that.
And do you have any evidence at all, aside from the supposition, that those rocks were not, aren't there any more because of, not from natural causes?
I would be surprised if they were removed by natural causes.
Okay, so I'm going to just show you some pictures that I'm representing to you that were taken yesterday, and I was out at the property and I took them. And this is again that same beach area.
Yeah.
That we're looking at. Okay, and so when I compare those shots taken yesterday, see how we have a bunch of rocks here?
Yeah.
And again, rocks here, same kind of rocks that you had shown on your before pictures.
Mm-hmm.
So it's basically same area, stretch of beach, lawn chairs, people are enjoying it as a beach. And
So where were those in the drone photo?
Where were those in the drone photo? I'm sorry.
Yeah, I guess I'm wondering why you can't really see those. And actually, if you go to the exhibit, the photos that we took on October 26th, I'm wondering if we can see those rocks that you see there at the bottom of the stairs in that photo.
I'm not sure you can, but I think that's the point you would acknowledge, is that beaches change. They're not static.
Yeah. I mean, it almost, to me, just looking at these, seeing these new photos, it almost looks as though someone put some sand on top of rocks, and that sand maybe washed away over the last year. I mean, that's just what it looks like.
Right. So because beaches change, it's a dynamic situation.
Yeah. I mean, yeah.
So I'll go back to your before and after shots for the beach, okay?
Sure.
And how large was that beach before?
I would say that's probably about 20 feet. I haven't taken a tape and measured it, in width.
Did you use your app on your phone to measure it when you were out there?
Width, no. And I wouldn't bother to measure how deep it is, because it changes throughout the summer.
Okay, so you didn't measure it before?
No, and I'm not saying that it's spatially, length and width. I'm not saying it's any larger that way.
Okay. And I think one of the points that you raised in the notice of violation is that it was constructed without a permit from DEP, and that was problematic, correct?
Yes.
And I understand from your testimony today and prior hearings that you've been working fairly closely with DEP regarding alleged violations, correct?
Yep.
And are you aware of any violation that the DEP is asserting with respect to alleged construction of a beach?
No, I'm not sure. I know that DEP issued, a notice of violation. I don't have that in front of me, so I don't remember if that was one of the violations or not.
If I submitted to you that it was not, would that be surprising?
No, because that notice of violation actually came from Alexis at NERPA, and it was Jeff Kalinich, in Shoreline zoning, that actually suggested to the town that this was a violation of beach construction.
Okay, but as far as you know, there's no violations in that regard from DEP.
Yeah, if you're saying that, then I say sure.
Okay. All right, let's go to violation number 6. We're making our way through these. Okay. So this is with respect to vegetation removal less than 3 feet in height, correct?
Yep.
And I'm just reading from your notice of violation. It says categorically all existing vegetation less than 3 feet in height have been removed within 100 feet of the normal high water line, correct?
Mm-hmm.
Okay, so let's move through various segments of this property. And I'm going to go to Exhibit B here. Okay. So this is, I think you said, this is taken from the water. And this is the area, I think, is it fair to say that's directly abutting the Fernwood property, correct?
Yep, yep.
And can you point to me exactly where the line, do you know where the line is between where the property line is?
I don't know.
Okay. And do you know how wide essentially the Whitetail property shoreline is?
Not off of memory, no. I mean, I know there's a property pin that we were pointed out when we did our inspection. I don't know if that is the actual property pin, but I was led to believe it is.
Okay. And there is a survey, and I'm just going to bring it up here so we can all have a look here and talk about where that setback is, the 100 feet setback, right? And so your submission is that, you know, all vegetation within this 100 feet setback was removed, correct?
Yeah, and I guess, you know, just in the interest of time, I know what you're getting at, and clearly all the vegetation within 100 feet wasn't removed. But to say that there wasn't a good amount of vegetation removed within 100 feet would be, you know, a little ridiculous, at least in my opinion. So I think we can move on to the next one.
All right, well, I'm going to ask a few more questions in that regard. So I'm looking at the house here, right? That's where the structure is, that's the house. And this 100-foot setback certainly goes behind the house, correct? So there's a good area all through that is within the 100-foot setback, correct?
Yep.
Okay. All right, so let's go back to your exhibits here. And so I'm looking at, this is from the water, this is Exhibit D, and based on that survey, you'd agree with me that this whole area right here to the right, we're looking at the house from the water, that whole area right there, that's within the 100-foot setback, correct?
Yep.
And that none of that has been removed, correct? Do you agree with me there?
Yeah.
In this area here, I see all sorts of shrubs and vegetation and lawn and trees. None of that's been removed right there?
Correct. Yep.
Okay. And again, I'm going to just pull up the pictures taken yesterday. This area, that's been left undisturbed, correct, as far as you're aware?
No, I don't think so.
So is it your submission that this whole, all of the shrubs could have grown back within that period of time?
Yeah, it's possible. I mean, let me just look real quick and see. It's been a while since I've been over to that side. Yeah, I mean, are you saying, what are you asking? Can you ask that again? I guess I didn't really follow the question.
Well, you would, I think in your own violation, you had said that all vegetation within 100 feet. And that looks like it's pretty firmly established and has not been removed.
Okay.
If you're unsure, then I'll just move on to the next area. And so this is the area where you'd alleged that all of the vegetation had been removed. And obviously you can see here that that lawn has grown back in, but here again is more shrubs, trees, that is within that 100-foot setback. Would you agree with me there?
Yeah, that's pretty close, but
And similarly, this is right behind the house. And I think this is just from another angle, but again, vegetation clearly still intact that was not removed within the 100-foot setback. Correct?
Can I ask a question to clarify? And so are these photos you're pointing to, these photos you just took today?
Yesterday,
Yesterday. Okay, so these are photos you took yesterday.
I said that was the case, yes.
Okay. I'm just trying to connect it up and understand what you're doing here.
Yeah, and I'll be clear. I did take these yesterday, but I think it's important to establish, and that's what I'm attempting to do, and I think I heard the code officer agree, that none of this area has been disturbed at all.
yeah, thankfully, yeah.
Okay. Just bear with me 1 second. So Exhibit B. And I think you had said that sort of all the shrubs and such had been removed from that area, correct? And these photos are taken in the autumn. I'm
Yeah,
asking you that.
Yep, these were taken in October, yeah.
Leaves on the ground. Okay.
Yeah,
And so
almost a year ago.
Got it. And so this Exhibit D, right? Again, it shows that these shrubs, granted, you can't see them as well because they're deciduous, but there's still shrubs here. Those have not been removed. Their leaves are removed, so they're not readily evident. But you'd agree with me that those shrubs are still there and intact.
In
Would you
this
not?
photo, yeah. Yeah, in that photo they were.
Right, but you took that photo, correct?
Yep.
Okay. And my understanding is that one of the concerns about removing vegetation really is because it hastens the erosion and sedimentation of the lake or the resource. Is that fair to say?
Sure, yeah.
And my understanding also is that you've been to that property several times, correct? Or
yeah, 3. Yep.
3 times. And so on any of those 3 times, were you able to see any visible siltation or sedimentation in the water?
In the water? I'm not sure. No, I
Wouldn't you have looked?
no, not necessarily.
Okay. And that protection of the resource is in fact one of the governing principles of shoreline zoning, correct?
Yeah, I mean, don't get me wrong. I mean, I'm not saying that we weren't down at the shorefront. What I will tell you is we walked down the first day we were there on October 26th, down where the jetty was, and it's all mud. I mean, but to see, you know, it all floating out in the water, you got to remember it gets pretty rocky down over there. So it had all basically washed up on shore at that point.
So you didn't see any sedimentation in the water or siltation in the water, what I think I heard you say originally.
I will say, yes, I did, because I'm walking in it. So yes.
Second, I'm just moving through here. You had mentioned the jetty, right? When we were talking about, you were just mentioning the jetty, correct?
Yep. Yeah.
And my understanding, that jetty is certainly not on Whitetail. I meant to be specific and direct my questions to you about, did you witness any siltation at Whitetail?
Yeah, I mean, we walked out right down that whole stretch. I mean, it carried all the way over to the boat launch.
So your comments are not, you said the jetty, but you're saying you saw siltation along all the way to the boat launch is what you said? Is that fair?
Yeah, let me see if I can find an exhibit to better describe to you what I'm talking about. Yeah, so the after photo on Exhibit D, you can see the jetty far off in the distance. We walked down along that entire shorefront from the jetty actually to the boat launch, where you can see the silt fences fallen down, where the large rocks are. That was all mud, like walking on a mud flat. And it was a mix of all sorts of different things, compiled in that one spot.
All right, moving on to violation 7. Again, this is essentially the same removal of vegetation less than 3 feet in height, but without a permit, right? So it's the same underlying conduct as violation number 6, but focused simply on the absence of a permit, correct?
Yeah.
And I'll ask you the same questions I did before, that you obviously understood the obligation to testify truthfully, correct?
Yes, I think it's very important for people to understand you can remove vegetation less than 3 feet in height within 100 feet from the water with a permit.
And so bottom line is, if I asked you the same questions about this violation based on this activity, your answers would be the same.
Yes.
I don't need to duplicate. Okay. All right, let's go to violation number 8. And this is about stabilization without a permit, correct?
Yeah.
And would you agree that if shoreline
Excuse me.
stabilization,
I have a question. You haven't actually filed an appeal regarding violation 8, have you? I
I know that violation 8 is certainly in our notice of violation, talks about the need to consolidate. And I will say also that if past is prologue, and it should be, that all of these arguments certainly have been, made, and that I think there's a recognition that the notice of violation is essentially, in essence, like a notice pleading like a complaint. And so, yes, there has been reference to violation.
No, I'm talking about your appeal.
Yeah, I am too.
You said notice of violation.
I'm sorry, notice of appeal, I should say, or the administrative appeal.
I guess I don't understand what the appeal is for violation 8 because it isn't there.
Well, perhaps hopefully the questions I ask will make that more clear, as will my arguments at the end.
I guess, so, Mr. Chairman, to the extent there is an appeal as to violation, I ask that it be dismissed. The ordinance requires that a notice of appeal state the basis on which the appeal is and why it should be granted. There is no explanation as to why violation 8 should be vacated. To the extent there is an appeal relating to violation 8, it should be dismissed for a failure to comply with the ordinance.
Mr. Chairman.
I want to just offer some insight here for us.
I'm sorry, I didn't hear you, Mr. Chairman. Are you asking for Attorney Wagner to weigh in on that?
Yeah, if I didn't say that, yes, Attorney Wagner.
I just didn't hear you properly.
Sure. Well, I think just Attorney Richardson, did you have a response to that argument?
Sure. Yes. I mean, in the administrative appeal, we talked about the need to consolidate various provisions. And throughout these proceedings, I've made it very clear that one of the reasons for that is that and this argument I know has been made on several occasions, that had they secured a stabilization permit as required, as stated that they should have done in violation number 8, had they done so, that would have subsumed so many of the alleged violations with respect to earth moving and tree cutting and vegetation removal. And so, yes, we definitely have mentioned, we certainly have taken exception to this violation throughout these proceedings, because it's verbatim to what has happened in Fernwood. The board has addressed that in prior proceedings, and I don't understand why it would be any different here.
I'd like you to point to your application for an appeal where violation 8 is appealed. I don't see it.
I'm going to bring that up. Just bear with me if I can. Trying to find it. One second, if you just bear with me. about on page 4 of the February 28th, 2022 administrative appeal that was submitted. And I'm sorry, I don't have it bookmarked here. But talking about how violations number 8 and 9 cite the exact same provision of this, the shoreline zoning ordinance. They're fashioned as 2 separate violations. And so that's just been consistent with the submissions from the outset. And it has, in fact, been identified as a basis for appeal.
So I just want to understand. So on page
And I think
3,
let me just finish that thought, Eric. I'm sorry. And I'm having deja vu here, frankly, because I think you raised the same exact objection in an earlier proceeding, same objection, and the board did not sustain it, and they moved forward to make the analysis on this issue.
so no, you can turn that right around to you. All the violations alleged against your client were all upheld. So why are we doing this? I mean, that is a circular argument that doesn't work. I'm entitled to raise the argument here. It's different. You pointed out this is a different site. This is a different appeal. So I raised it again.
So thank you both. So to the board, the objection that's been raised is that the appeal concerning notice of violation 8 it did not contain reasons challenging violation 8, and so the appeal should be dismissed as to violation 8. So as before, I do agree with Attorney Wyckoff that it's you're not necessarily bound by your prior decision, but I do believe that Attorney Rachel is correct that in the past you analyzed this, and I advised you to look at the notice violation, and if you felt it gave you sufficient notice that violation would be raised on appeal to allow the appellant to challenge that violation. So I would, my recommendation to you is to compare the notice of violation with the notice of appeal and see if, in your opinion, the town had sufficient notice that violation 8 would be challenged.
Let me be clear. The appeal set alleges that a procedural issue with regard to 8 and 9, that they are the same violation because they're factually the same. It also contains a substantive challenge to violation 9. There isn't one as to violation 8. So my point is, what I heard was a beginning of an appeal as to violation number 8 on a substantive basis, and I'm saying that appeal, we don't have notice of that.
So, Attorney Rachel, can you answer why violation number 8 wasn't significantly addressed outside of what was listed on page 4?
When you say page 4 of the appeal, the administrative
Correct.
appeal.
Yeah, we're under the procedural flaws.
Sure. I think because the reasons I've stated that so much of what we are arguing is that there is duplication, that this unpermitted shoreline stabilization is just part and parcel. If you look at 9, right, which I think Attorney Wyckoff conceded that there was a substantive objection to, it's exactly the same provision. If you look at the notice of violation, it cites the same exact provision. And so one's unpermitted shoreline stabilization, it's both the same thing. And by saying it's duplicative, those arguments will apply similarly. And I will note that in prior proceedings, as I said, Attorney Wyckoff raised the same issue, that it should be dismissed. And this board decided that it should not, and you should consider it on its merits. That's not to say that ultimately, if you decide on the merits that you disagree, and I would ask you not to, but not to dismiss it in turn before even considering it on the merits. You've already done that in the prior proceedings. And I'd ask that you do the same here, based on the same reasoning.
Is the issue clear to the board?
Yeah, David, can I chime in?
Yeah,
Ron?
please.
Would it appease you is if you just argued 9? I mean, it seems like your intention, I don't want to get ahead of you, might be, as you did with 1 and 2 and 6 and 7, to kind of make your arguments for the first one and then ask if your arguments are still stand for the one that you're saying is a duplicate. Would it appease everyone if you just did that opposite and just made the argument for 9 and then said, Alex, do all of these? I don't, just maybe a way to, I don't know. It was just my thought.
Well, from a procedural standpoint, I just want to be clear. I'm not making arguments right now. I'm simply asking a witness questions.
Yeah, I'm not a lawyer. I think you understand what I was saying.
So if I can chime in, perhaps this will help the board. You know, I do agree that there's a difference. You can make a argument that there's a difference between whether violation 8 is being substantively challenged, and there's no evidence to support the claim of that violation, and that violation 8 is merely a duplication of violation 9. And I think you can draw, you know, the notice violation draws the distinction between those two violations. You know, but as before, I think I advised the board, you know, in my opinion, that distinction is so nuanced, and I don't think it would be appropriate to apply that level of scrutiny on. You know, I agree with Attorney Rayson's position. This is something analogous to a pleading, and the standard there is low. So if you didn't ask for my opinion, but if you were to ask for my opinion, I would agree that there's sufficient notice here to challenge 8 on its own. And so I would recommend that you overrule the objection from the town.
Great, Tom, Fred, Pete.
Do we need to make a motion on this?
I would suggest that you should, yes.
I'll propose a motion that we, I guess, accept Attorney Rayson's argument and move on.
If I can, I suggest, why don't you make an, and you can make this motion, and that doesn't mean that you're going to vote for it, but make a motion to grant or sustain the town's objection and exclude witness questions pertaining to violation 8. So then if you were to vote against that, you would be allowing Attorney Rayson to continue with the questions.
So moved.
I'll second that.
Any further discussion? All those in favor? Let you guys start. It's got to be a roll call vote. All those in favor? All those opposed? David, yes.
Greg opposed.
All those abstaining?
I'm going to abstain.
Fred, Pete?
Opposed.
Opposed. Fred? Got to come off mute, Fred.
I agree with you, Dave. Yes.
So we got 1, 2, 3, 4 opposed, 1 abstain.
So then the objection is overruled, and Attorney Rayson can continue with her line of questioning pertaining to violation 8.
Thank you. Thanks so much. I appreciate it. So we're at violation number 8. And so, Alex, would you agree that if a shoreline stabilization, if it was warranted in certain circumstances, that this is actually the sort of thing that you can obtain a permit for under the shoreline zoning ordinance? And I'm specifically looking at section 15C 12 here, that it contemplates that it is the kind of thing that you can apply.
Is it an allowed use, or is it an allowed activity? Is that what you're saying?
With a permit, yes.
Yes.
Okay. And the argument, of course, is that the town did not obtain a permit. That's your argument for why this is a violation, correct?
That your client didn't obtain a permit, yeah.
And that, would you agree that this was part of the permit by rule that we were looking at Let me pull that up for you. That this permit by rule was seeking the very kinds of shoreline stabilization, erosion control, filter fabric, riprap, bark mulch per DEP requirement. So that's the kind of stabilization that is contemplated here, correct?
This activity does also require a permit by rule, yeah.
Okay. And it's essentially very similar, if not the same activity that just requires permits from both entities.
Within 75 feet, you have to get a permit by rule, yeah.
Okay. And did you measure to determine whether more than 100 feet of shoreline that was covered by the PBR? I think here is 98 feet of shoreline was more impacted as far as you're concerned than what was applied for already?
Yes.
Can you elaborate on that?
I cannot, no. You're looking for the exact number? I don't have that exact number with me right now. I could find it, but it's going to take time.
Okay. All right. I'm happy to move on. I wanted to ask you about nonconformities. So we can put our attention here on section 12. You'll agree with me that this is section 12 of the Shoreline Zoning Ordinance that deals with nonconformities, correct?
Yep.
And in essence, if we look at subsection B2, which is entitled Repair and Maintenance, talks about how the ordinance allows, without a permit, normal upkeep and maintenance of non-conforming uses and structures. You agree with me there?
Yep.
That's what it says. Okay. And so what I'm wondering is, are you looking at, we talked about, we saw the pictures that this is a heavily riprapped property. Do you consider the riprapped area to be a use or a structure?
It would be a use, I guess you could say.
Okay. And so non-conforming uses and structures allow for repair and maintenance, correct? Under the terms of 12 feet.
As long as they don't exceed 50%.
50%, I'm looking for 50% of what? I'm not sure what you're talking about. Could you direct me to a provision that says that?
Yeah. You're going to want to go to number 4 under that section. Any non-conforming structure which is located less than the required setback from the normal high water line of a water body, tributary stream, or upland edge of a wetland, which is removed or damaged or destroyed regardless of the cause by more than 50% of the fair market value of the structure before such damage, destruction, or removal may be reconstructed or replaced, provided that, and it goes on and on and on. But 50% is typically when someone is repairing or maintaining a non-conforming structure, such as a deck that's just a few feet from the water that doesn't show up on a subdivision plan from 2007. Sure. If they were to replace that or reconstruct that by more than 50%, they would have to relocate it to 100 feet.
Understood. So a couple of follow-up questions then. You had said that this was a non-conforming use. This provision that you just directed us to is a non-conforming, deals with non-conforming structures, correct?
Yeah, and typically they are a wall for erosion control is typically treated as a structure. However, it's a structure that's not required to meet the 100-foot setback in most situations, unless it's not necessarily required for erosion control.
All right, so I just want to be clear. Are you saying that it's both a use and a structure? It's just a use or just a structure?
I would say it could be both.
Okay, and when you say by 50% of the market value, how did you determine that this exceeded 50% of the market value?
Well, that would mean we'd have to assess a market value for the entire riprap wall that was there. And the easiest way in my mind to do that is to just do it based on, percentage of the wall replaced. They clearly exceeded 50% of that.
How is that clear? That's what I'm trying to understand. You say you're supposing it's clear. How is it clear?
Yeah, I mean, I guess we'd have to go back to what did your client pay for this portion of the wall to be repaired.
But,
You know,
well, I think, let's be clear that this is
well,
your
I mean, if we're gonna make that conversation, or we're gonna have that conversation, then we're gonna probably need some more information, I think, to clearly come to that.
But I think what's
agreement.
critical to understand here is that this is your notice of violation, and the violations that are alleged must be substantiated before. I mean, we're not talking about after the fact. It's not our job at this point to submit additional information. This was your allegation. And so I'm simply trying to understand how it is that you came up with those calculations.
Right, Leah, but it's your appeal and that burden is on you. And you're saying, you're asking questions trying to prove that they are not in violation for something that's as easy as not having a permit.
No,
so I just don't see where we're going here.
Sure, and I don't want to engage in a back and forth, and I think, you know, the questions have
I mean, I'm fine answering the questions, but I need to understand where we're headed with this in order to give you the accurate information.
Sure. So let's back up. You had said that this I had submitted to you that section 15C of, excuse me, section 12 with respect to nonconformities specifically states that you can repair and maintain. And then you directed me to this reconstruction replacement, and that was the basis for your thought.
Right. So to answer your question,
excuse me, Alex, I haven't finished. If you just let me.
I know, but I understand you're explaining it for me, for my benefit, and I get it. So let's not waste anyone's time. I do not believe this is repair and maintenance. This is not repair and maintenance. They completely replaced this entire existing riprap wall. If someone could explain to me why they felt like they needed to replace an existing secured wall, then we can talk about that. But there's no reason that I can see.
Okay, so I heard you say it was an existing wall, correct?
Yeah, but was it legally existing?
No one suggested that it isn't. Are you suggesting that now?
I'm not saying I don't know if it was legally existing or not, is what I'm getting at.
Right, but there's been no allegation whatsoever that it was not legally existing. You have not made that suggestion. Okay.
We haven't formally said that, no, but we're giving that your client the benefit here and assuming that it is.
Okay, let me be clear. The notice of violation, going back to my earlier conversations with you, the notice of violation, the purpose of which is to identify any alleged violation, right?
Yes.
First principles. At any time, has it been suggested that this was not a legally conforming use or structure?
Has it been suggested?
In your notice of violation?
No. Okay. We have not raised that, no.
Okay, so let's end that line of questioning then, because you have not raised that. But under violation number 8, right, it talks about over or below the normal high water line. So we're really talking about what's below, correct?
Yes.
Okay, and what you're talking about, I think, is over and above the normal high water line, correct?
We're still talking about 8 and 9, right?
Yes, we are.
Yeah. Yeah, so that comes from that particular section in the ordinance. And I've never understood why that's where the state dropped it in, but that's where the state dropped it in. Specifically 12, the technical standard that we're relying on is under the heading, for structures or uses extending over or below. And I think the whole point of that is because sometimes, a riprap wall is actually below the normal high water mark for a majority of the year, usually until September.
Okay. All right, I think I want to move on to number 9, all right? And this is, again, same provision, unpermitted shoreline stabilization, no barge, right? And I think you agreed that shoreline stabilization, if it's warranted, that is the sort of thing you can get a permit for if you apply.
Yeah.
And what was the level of the water when this work was done? Are you aware of that? Can you speak to it?
It was pretty low. I'm actually pretty sure you could find out the exact level if you wanted to on the website, but it's the low time of year.
What website are you referring to? Like
I don't know exactly.
Is it a Sebago Lake?
The dam has a website where you can go back historically to find the exact.
So at that point in time, it was fairly low, correct?
Typically September, October, it starts to come back up depending on the rain.
Okay. And do you know how much, just in terms of draw, in terms of depth, how much it draws when fully loaded with this kind of heavy equipment?
No, I don't.
Okay. And do you know where the barge would have been situated offshore? You know?
No.
Okay. And do you know what the reach of the excavator is as far as? Okay. And what did you do to determine if that barge would have been feasible?
Just based on seeing it in that particular area, that same segment of shorefront on Sebago Lake.
Okay.
You know, he has the barge, he uses the barge. It's in that, line of work frequently.
Okay. All right. I'm going to move on to violation 10. And this is removal in excess of what's allowed by the point system, right?
Mm-hmm.
And how many trees roughly do you think that was removed at Whitetail?
I would, off the top of my head, I'm going to say I would go to the NOV and see what is listed there, because I don't have that number memorized, unfortunately.
All right, that's fine. We can move past that. But you'd agree, and I think we've had this conversation before, that you can cut hazard trees without a permit if the person consults with you prior to doing so. So no.
Correct.
Okay. And you recall, I think I should ask you, do you recall the evidence that was submitted by Aaron Goslin of Q Team that most of those trees were, in fact, in his opinion, hazard trees?
I think that was specific to Fernwood.
I think it included Whitetail as well. But do you dispute that is the case? I mean, I can.
Well, I mean, we were told by Q Team that they didn't do any of the work on 28 Whitetail. So I would kind of be a little confused as to why they were assessing hazard trees on 28 Whitetail if they didn't do any of the work.
Well, I'm not sure that's the case. So let's just make sure we are clear, because if you'll recall, Mr. Goslin submitted evidence in the last hearing. And I've called this up here. If you just bear with me one moment. Well, it was my understanding that it was both properties, but let's leave that aside for a moment and look at the photos. If you give me one sec. So I am calling these photos to your attention. And again, these were taken yesterday. And this is the tree that was removed. This is at Whitetail, and this is right next to the deck. Remember that deck area?
Mm-hmm.
Sorry, the stairs. Not the big deck out front, but the stairs. Do you recall that one?
Sorry, can I interrupt you just briefly? Are you screen sharing right now?
Oh, I'm sorry. I don't think I am. Thanks.
Thank you.
Okay. Can you see?
Yes.
Okay.
Yep.
Great. So here we have one of the larger trees at Whitetail. And from my perspective, I'm looking at a fairly large tree with the middle portion, a large extent of that rotted out. Do you agree with me that that's a fair characterization?
Sure, yeah.
And would you agree with me that looking at this tree, that would be the kind of tree that is characterized as a hazard tree?
Yeah, could probably meet that definition.
Probably, or yes?
Yeah, I mean, who knows how long that's been there? That could have been there 10, 15 years. I don't know.
I think, is that not one of the trees that you identified in your NOV as having been removed?
I have no clue. I mean, I'm just not trying to be difficult. I'm just saying I can't really tell based on where this photo is taken if it is one of the trees or not.
All right, but you say that you agree that is in fact a hazard tree.
Yeah, that would look like a hazard.
Okay, and you also agree that Aaron Goslin is a licensed arborist, correct?
Yes.
And you are not?
Correct.
Okay. one of the things that is alleged in violation number 10 is the fact that there was some canopy loss.
Mhm.
Can you tell me how you measured that canopy loss?
Yeah, we based it on aerial imagery.
Okay. So from that aerial imagery, what did you use to measure that 250 feet?
That was Google Earth measurement from aerial photo.
And just for the layperson to understand, how does that actually work?
I believe if you go to the last exhibit in the NOV, you know, it shows the dimensions that were measured based on the measure tool in Google Earth on that actual aerial photo.
Are you talking about exhibit F?
Yeah.
You can see my screen here. Is that what you're
Yeah.
talking about?
Yeah, for some reason the markup's not showing on that exhibit.
Okay, hold on. I think I have another way to get to it. No. But these lines you're saying have been drawn from Google Earth.
Mm-hmm.
That's where you got it. Okay. All right.
Yeah.
And what was the canopy? What was it before the tree cutting? Are you aware?
So in that exhibit F, it does show the canopy before the trees were removed. I circled the trees that were removed, and you know, provide a dimension for reference, showing that number of 250 has been exceeded.
Just so I'm clear, this exhibit F here, that's a before photo, correct?
Yeah.
Okay, so where's the after?
The after is not included in the NOV. It actually came out from Google not too long ago. It was probably the last 3 months that it actually was released.
Okay, so when you, at the time you drafted that, you did not have any after photos, correct?
Correct.
Okay. So moving on to violation number 11. This is vegetation removal in excess of what was allowed by the point system. I'm just going back to the canopy piece, right?
Yeah.
So we talked about how there's no after photo, but what's the scale of the after photo? How did you get that?
It's based on the area that's opened on that site visit. You know, assessing where that area is now open and essentially drawing a circle, and the number greatly exceeds 250. So yeah, I mean, I suppose you could try and say it's probably not exact, but we're talking it's well into the thousands of square feet, not hundreds.
And you're basing that on what though? Like, how did you measure that when you say it's in the thousands? How do you actually measure that empirically?
By using the measure tool on Google Earth, and you know, measuring that shore frontage and looking and seeing what's open on site. We can easily assess, you know, how much area is open now compared to what would have been open if there was a large tree standing right in that spot.
Okay, but that was not. That was just through the Google piece. That wasn't through your phone app or anything like that,
No,
right?
No.
And
no.
With respect to both your phone app and this Google tool that you're talking about, how are you aware of the reliability of those tools? Like, how can you verify whether or not those are reliable?
Well, again, I'm not a surveyor. I'm not a state licensed surveyor. So how reliable is a tape measure? I mean, it really all comes down to the user. You know, I've tested the phone app, for example, and set 100-foot tape and then measured 100 feet, and it's not close enough to measure inches, but close enough to measure feet. I've also done the same with the Google Earth tool. So, you know, we have to use what tools we have available to us, and that's what I've done.
Okay, so let's go to violation number 11, okay? And this is vegetation and removal of the point in excess of the point system. Can you just very quickly let us know how that point system works?
Yeah, so essentially you have, for selective removal or removal of vegetation within 100 feet only, within 100 feet, you have to establish 25 by 50 foot grids, and those grids have to contain 24 points based on the diameter of the tree at 4.5 feet off the ground. You have to assess every single tree within that 25 by 50 foot grid, assign it a point, And in the end, you have to have at least 24 points and you have to maintain 5 saplings. If you have a 25 by 50 foot grid and you cut all but 1 tree, you are in violation of the point system because you cannot have 24 points with just 1 tree. So that's very easy for me to determine that's a violation.
Okay, and did you, when you were determining that it was a violation, did you go out, did you actually plot those grids yourself when you went out to the property?
I didn't physically plot them on site. We plotted them, again through Google measurement and looking at, you place that, that 25 by 50 foot grid right at the shorefront, and there's a place where there was trees and there's now no longer any trees. So it's very easy to see that that grid is now empty, has no points, and it was selectively removed. It wasn't for removal of a hazard tree, so that's your only option at that point.
And
that,
sorry, go ahead.
Sorry.
No, go ahead.
That can easily be avoided by getting a permit. You can actually cut trees in excess of the point system if you have a permit for an approved activity.
Okay. Again, I'm looking at Exhibit F, okay? And this is what was submitted in conjunction with violation 11. Can you tell me where that property line is between, because I know a lot of these trees that you're counting and indicating have been removed may very well not be on the whitetail property. So
I guess I don't see why. Obviously we're looking at the lines on this, our tax map overlays. They're usually off a few feet. In this particular case, I can tell you they're actually, they're skewed too far to the right. When we met on site a month or so ago, we were pointed out the property line on the right-hand side next to the driveway where there's a shed that's actually over the line. And the property line on the right actually is just to the right side of that right white bubble or cloud that I drew. So by that, I can tell you this tax map line actually should be shifted well to the left. So where the deck is actually going to be where that point is.
Hold on, one sec. I just want to make sure that we're where you're. Let's make sure we're looking at the same thing.
Yeah. You're talking about Exhibit F?
I want to know what you're talking about. Yeah, I'm looking at Exhibit F, and I'm trying to figure out. I want you to tell me where on that exhibit that the property line is located.
If I can interject, I think the problem here is what you're showing as Exhibit F doesn't have the actual lines on it that the notice of violations has on it.
Yeah.
And I think that's causing some confusion.
Fair enough. I realize that somehow has been.
Do you want me to just screen share mine?
Yeah, that would be great, Alex. I'd appreciate that. Thank you.
Yeah, why don't I just, because I can actually explain it a little bit better here. So hold on one sec. Here we go.
I'll stop my share. Go ahead.
Yep. All right, so you can see the markup now, right?
Yep.
Okay. So what I was trying to explain here is the cloud. I'm actually going to see if I can just, here we go. The cloud over here, can you see my mouse?
Yeah, when you say cloud, you mean just kind of those squiggly, like
this right here. Yep.
Yeah. Mm-hmm.
The property line itself is actually right around there. So this tax map is off, the white line here, the white property line you're seeing. This corner right here that I'm circling is actually right over here. And that was pointed out to us on site. So this entire white line on the shorefront actually needs to get moved over here. So this side corner is actually down on this side. And the 50-foot wide walking path right of way that you see on the subdivision plan is actually right around here. Does that help?
Somewhat, yeah. Okay. All right. I'm going to move on to violation 12, okay?
Yep.
And I'm gonna share my screen again, if I may.
Mhm.
Okay, and so 12, you noted that this was within that 1250 square foot area, correct?
Yes.
And that's essentially the same area that's alleged in violation 11.
Yes.
And you measured it in the same way that you identified earlier?
Yes.
And how is that different than tree removal? This was vegetation without a permit. How is that different from the allegation that there was a tree removal in that area?
So you're saying how is 12 different from 11? Is that what you're?
Well, I'm wondering, it says removal of vegetation without a permit within the 1250 square foot area. And before you're talking about a point system, and here you're talking about just general removal of vegetation.
Yeah, so the point system is in violation of section 15 Q, right? Just making sure I have the section 15Q for the 250, and then you have 15Q2B, I believe.
I just
so
want
it's
to clarify.
one's 2A and one's 2B.
But you're basically saying that trees and, are you conflating trees with vegetation? Are you saying they're the same thing? It's just not clear from this.
Yeah, I guess I'm not necessarily following the question you're trying to ask. Because it seems clear to me.
Okay, let me clarify. Between the house, on allegation 12, between the house and the water, vegetation has been removed from a 1250 square foot area.
Yep.
In that,
Correct.
are you including just vegetation of less than 3 feet, or are you talking about trees? Are you talking about both?
Both.
And so basically, this is the same allegations, or the activity, I should say, that is included within violation 11 and 6. 11 being,
yes.
Okay, so we agree on that.
Yep.
Okay.
Yep.
All right. So moving on, we're going to talk about the corrective action, right? As part of any notice of violation, as we said, corrective action is specified, correct?
Yep. Yep.
And largely here, what you have asked for corrective action is a series of after the fact permitting, correct?
Yes.
Okay. And you're aware that management controls and various other parties have submitted after the fact permitting. Originally back in March, there were, I'll just bring these up here. Let's see. We had a series of 4 different after the fact permit applications submitted by Mr. Morse, correct? You recall that?
Yes.
And for whatever reason, the town apparently was dissatisfied with this, and that my clients retained another expert, Elizabeth Ransom, correct? You recall that?
Yes.
And that she actually submitted back in early August additional after the fact permitting plans, restoration plans, correct?
Yes.
Okay. And the town refused to accept those. Do you recall that?
Yeah, we're not going to accept it until we feel it's adequate. Exactly.
And wasn't one of the reasons stated in the rejection that the application doesn't seek anything that the planning board can review here?
Correct. Yep.
Correct. But isn't this exactly what you had asked for, that they submit plans to the planning board and to the code enforcement officer after the fact?
Well, the planning board isn't responsible for reviewing a restoration plan. If it meets a specific, under that table of land uses, if it's required to go to the planning board for approval, then it should. But if it's a restoration plan that exceeds the scope of what something that, can be, for example, it could be approved by a code officer, then it wouldn't need to go to planning board.
But wasn't the whole point of violation number 8 as asserted that they needed a permit for shoreline stabilization? And isn't exactly what is being submitted? The plan for the stabilization after the fact, as it may be.
Yeah, I think one of the difficult things for people to understand is the planning board likely would not be able to approve that. So what happens then? Your client will spend more time and money going to the planning board to get this thing approved after the fact. What if they say no? What if it doesn't meet the requirements of the ordinance?
Those are a lot of what is valid, but what is there? I mean, aside from submitting the after the fact permit that was directly required under the corrective action. Anyway, I'll leave it at that. I think that's it. And I really appreciate your time. I know it's been a long, winding road. I appreciate that. Thank you.
No problem.
Thank you. So just from a visual standpoint, I want to make sure I'm clear. I have asked my question. I don't have any other witnesses. Of course, I reserve the right to cross-examine any, if necessary. But I know other parties have their case put on, and I won't make any final arguments until after that. But I just want to make sure we're clear on the process.
Wagner,
Yeah, so Attorney Wright, you're asking if you'll have an opportunity to make arguments after the other side has presented their witnesses. So yes, I mean, generally how we've done this in the past with that, you'd present your arguments now, when you would have an opportunity to give a rebuttal after the town puts on their case. So I think you would have that. So yes, you would have that opportunity after.
Okay.
Reference.
Yeah. I think if I recall, we don't make our final arguments until after everybody has the testimony in. I just want to make sure that that's consistent with your recollection.
I think it's varied on each appeal. I mean, I know in the last one we had there was a mix of arguments and evidence all at once. But I have no problem, and certainly it's up to the chair. But I would recommend, to you, Mr. Chair, I think that's a reasonable approach, is to allow each side to present their evidence and then return to both the town and the appellant to then make closing arguments, essentially.
so Attorney Wagner, can ask if you could outline for us the next step in this, and then I'm going to propose we take a 5-minute break.
Sure. So the next would be if the board had any questions for the appellant on this testimony so far, or for the CEO.
Board have any? I don't at this point.
Okay, and Attorney Regin, you have no further witnesses?
I do not. Nope.
Okay, any other evidence?
From a procedural standpoint, it seems to me, that we've been building from one hearing to another, correct? And we've all agreed, certainly for today's proceeding, that what is entered from one hearing will carry over to the next. You're going to make decisions here based on these arguments, and then theoretically, Big Lake Marine will have opportunity to have its notice of violation heard. I would suggest and would prefer, in fact, opportunity to participate in this line of questioning and in the discussion of evidence here, so that we actually have an opportunity to participate in the process. Otherwise, what we'll end up with, which is part of my arguments from the prior night, is that decisions will be made, and then we'll either make to pretend that the bell can be rung and we get a fresh start, which I think we all agree, certainly in the same evening, is probably not an accurate description. Or I can have opportunity to participate, make some questions of the witnesses or arguments on Big Lake's behalf. And I think, especially since the notice of violations are literally identical, the determinations made by the board can be made as to both.
I agree with you. I think that you've, as other parties here, and I would call, I'm using parties loosely, but I would say you absolutely have an opportunity now, if you'd like to ask any questions of Alex, you can, and I maintain that you've had that opportunity before. So I guess that's why I was confused as to your objections last month. I've always thought how I've laid out the procedure and how the chair's laid out the procedure is that you, even though you're not a party in this appeal, would have an opportunity, as you do now, and I'd say go right ahead to ask questions of this witness. So if you have any, now would be the appropriate time.
You would all agree with that? And do we want to take a break? I know the chair just mentioned that before I do that, or would you like me to continue on with the line of question?
I have a question. So is the thought then, Leah, as the appellant, has asked Alex to put him on as a witness, and then are you skipping the town now and then go into Greg to ask questions of Alex, or is?
No, I guess Leah has Alex on the stand now as a witness, so I think it'd be an appropriate time for Greg to ask questions relevant to the answers that Alex has given, and then the town will have an opportunity, and you can certainly call Alex back up, and Greg will be given that opportunity again if you would like to ask questions relevant to the answers that Alex gave in response to your questions. Does that make sense?
No, I don't think it does, actually. I mean, that seems to be an inefficient way to go about it. I mean, if I was in, I guess what I had in my head is the appellant has gone, has asked Alex, the question she's going to ask. I think then I should have the chance to, the town could put on its it's the presentation it's going to have. I can ask Alex the questions I have, and then Greg, if he wants to ask questions, then then it would have been had everything Leah had, everything I had, and then he can go again rather than him getting two bites at the apple.
I have no objection to that.
That just seems inefficient to me.
Yeah, I think you're right. And if Greg, you have no objections to that, then why don't we do that? And so we'll go as Attorney Wyckoff outlined.
Okay. Now, I heard someone mention something on a break first. Chairman Merch, did you want to take a break before we did that?
Do. So I'm showing 8:14. Let's reconvene at 8:20.
Okay.
So I believe it was our understanding that Attorney Wyckoff now would have a chance to present. So Attorney Wyckoff, we'd be happy to hear you have for us.
Sure. So my plan here is first I'm gonna ask Alex to give the board an overview of the violations at Whitetail Lane, and then after he does that, generally, then I propose that we go through each of the violations, and Alex and I will together address each of the issues raised by the other side. Bear with me, my computer's telling me it's restarting in 4 minutes here. Hang on, excuse me. I'm trying to prevent this from my computer from restarting. Bear with me, I'm sorry. Okay. With that, I'm going to turn things over to Alex, please.
All right. I'm going to share my screen. I'm going to try and do this quickly. Okay. Sorry. Whoops, I actually. Can you see that?
Yes.
Awesome. Okay. All right. So as you guys know, we were tipped off on this violation from DEP October 14th, 2021. In an email, she sent us a photo of the activity taking place on the adjacent property, initially 18 Fernwood, and then eventually she also sent photos of 28 Whitetail as well. We inspected the site October 26th, and this is the condition as we found it. It was an overcast day. It wasn't raining when we were down there, but I believe it had rained earlier that day. I'm going to go through the violations listed on the NOV. And the first one is for filling and earth moving of greater than 10 cubic yards, no erosion control. So here you can see existing shrubs and lawn were completely stripped and regraded on the entire left side of the property. There is a mulch berm kind of where the arrow is here. It's actually not an erosion control mulch. It's more of like an ornamental mulch. Erosion control mulch is usually more of a reddish color and is larger. It's stump grindings, waterlogged so that it doesn't float away. Fill was deposited in spots when they created the new riprap shoreline. As I said earlier, this was existing riprap. It clearly was doing the job, so I'm not exactly sure why it needed to be completely, replaced. But ultimately, that activity would have required a permit, and it would have needed an erosion control plan and erosion control on site. So here you can see where Leah and I were discussing earlier, the bottom of the boat ramp headed down towards the water. This section actually before kind of jogged to the left where the boat ramp was, and then back to the right as it went around that little peninsula towards the beach. The way they filled and graded this boat ramp made it a little bit less steep, but longer. Here you can see the erosion control on site, like, I don't know, less than 2 weeks after, maybe about 2 weeks, had fallen completely down here in this particular spot. The next one here is for the boat launch. And so here you can see the boat launch in these photos was 2 pallets end to end, and It was used to lower, a rowboat or kayaks and canoes down to the water, so they didn't have to take them down the rock shorefront or the stairs. It's really the only spot to access the water for something like that. That was the use for it, which we can tell by this photo. They've got some stacked up at the top. So this was the existing. This is what they replaced it with. It's now shallower, wider, firmer, and it was done without a permit from the planning board. Okay. The next thing here is for the shoreline itself. And this photo is a before photo. You can see the site as it existed from one of the older Portland Water District photos. The after photo, you can see all of the ground cover and trees in that area has been essentially all removed to grade that slope back with a very large riprap wall. Next one we're going to go to is beach construction. We did talk about this a little bit already, so I don't want to go into it too heavily detailed, but you can see there's large boulders on the shore at the water in the before photo. The after photo, all of the large boulders are gone. So they have effectively created a nice sand beach area, which once they go down and rake it up will be the perfect spot to hang out. Those rocks were removed, creating a beach. Coincidentally, it's also possible that they brought sand in to cover some rocks. Looking at the photos that Leah presented earlier from the site today, it does look as though sand may have washed away and it's now exposed the rocks that were there before. That's also possible, on site. Vegetation removal, less than 3 feet in height. You can see there's, in this older Portland Water District photo, there's grass and shrubs on a majority of the lot shorefront, and that has been completely removed. The work could have been done from a barge. Leah mentioned earlier that this area was disturbed for storage of the excavation equipment necessary, required to replace the existing riprap wall. That section exists in the ordinance to prevent that very thing. The planning board is supposed to make a determination if that work could be done from the barge or not, to avoid disturbance to the shorefront, the protected area. Rob does own a barge. He does do a lot of work on the barge, or has done a lot of work on the barge. And he did mention at a site meeting, a couple of months ago, that he felt as though he could do repair work from the barge down there if necessary. So I do think this work could have been done from the barge. Ultimately, that was the planning board's decision that they never got to make. Tree removal within 100 feet for activity other than timber harvesting. Multiple trees have been removed. Again, back to this old photo, you can see all the trees here, 4 small trees, a large one here, another cluster of small trees, and then a couple other larger trees have all been removed. You can see the after photo showing where they were. Again, on this drone photo from Portland Water District, you can see there's other trees that were existing that have all been removed. This is for vegetation removal in excess of specific standards. This first one is excess of the point system, which I explained earlier. 25 by 50 grid, diameter at 4.5 feet determines how many points the tree is worth, and you have to maintain at least 24 points. If we establish just one grid here, where a couple large trees were removed, these trees are no longer, there's one still standing in that area, but a majority has been removed. They definitely have exceeded the point system allowance here, and the 250 square foot canopy opening. I believe that is it. I'm going to pass it off to Eric.
Thank you, Alex. And then I'm gonna share my screen here, okay? Okay, I just want to make sure that you can see what I'm doing here. Do you see me changing a page number?
Yes.
Okay, good enough. Okay, so first, I'm going to address that management controls makes this overarching argument that it relied on its contractor to obtain permits and to do work consistent with the shoreline zoning ordinance. And in the first instance, the ZBA should reject that argument just as it did in connection with management control, similar arguments relating to the Fernwood administrative appeal. As the property owner, management controls was responsible for what happens on its property at its direction. And here the contractor, Big Lake Marine Construction or Big Lake Marine, is management controls agent. Management controls hired Mr. Durant for the project. And we've seen a copy of the contract with the applications for an appeal here. And management controls acknowledges it asked Mr. Durant to obtain the permits. And I'm going to just show you for a moment the appeal that was submitted by Durant Excavating. And then bear with me, I'm going to show you that. And with that appeal, they submitted Big Lake Marine submitted the permit by rule notification, and on it, it identifies the applicant as management control and the agent is Big Lake Marine. And my point being that Big Lake Marine was acting as the agent for management control, and a principal is liable for the violations that are engaged in by the principal's agent. So management controls is responsible for any violations committed by its agent here, Big Lake Marine. And then I just want to go here. Here's the invoice where management controls is sending an invoice. Pardon me, Big Lake Marine is sending an invoice to management controls for the work that it did. Now, I also provided the board with a copy of a application that was recently submitted to the Department of Environmental Protection by Ransom Environmental on behalf of management controls. And I'm just going to go to the third page of this document. And on the third page of the document, Ransom describes what happened here as the work. It's right here that the scope of the work, it relates that these issues relate to the scope of work completed by contractors on behalf of management controls. And my point is that this work was, Ransom on behalf of management controls is acknowledging that the work was done on by other contractors on behalf of management controls. So here, a property owner and as principal, management controls is responsible for the actions of its contractor. And I've given you a statutory citation for that concept. And that another section 444, providing that any person who orders or conducts an activity in violation of a municipal ordinance is penalized in accordance with the statute here. And then the shoreline zoning ordinance itself says that permit applications must be signed by an owner or a person authorized by the owner. And I've also given you a case law citation for a case that stands for the proposition that a principal is liable for the agent's misconduct within the scope of the agent's authority, whether or not the principal is aware of the misconduct. So the ZBA should reject management controls contentions that it isn't responsible for any violations here because it hired its contractor to obtain permits and to do work consistent with the shoreline zoning ordinance. It's responsible for those violations as well. Next, I want to go to violation number 1. And violation number 1 relates to filling and earth moving that occurs in violation of the shoreline zoning ordinance. And the ordinance requires that that activity be done in a way that to prevent erosion and sedimentation of surface waters, and that if a permit is required, that it be done in accordance with an erosion and sedimentation control plan. For all the reasons that you upheld this violation as to management controls for Fernwood, you should uphold it. You should uphold the violation with regards to whitetail as well. And now I'd like to ask Alex if he could just walk us through what this violation is and describe it.
Yeah, so here we have the activity of the soil disturbance taking place without an erosion control and sedimentation plan. We require that to be submitted, meet those requirements prior to the activity taking place, and then we also require that erosion control plan to be followed to protect the environment.
Okay, let me just go to the here's a photo. This is Exhibit B to the notice of violation. Alex, can you just describe to us what we're seeing here and describe the violation that's being depicted?
Yeah, I mean, there's, you know, at the top of the hill, you'll see there's exposed soils. And at the bottom of the hill, you see erosion control, a silt fence that's fallen down, was kind of carelessly placed, it looks like, at the bottom of that bank. But
is that right here where my cursor is moving?
Yeah.
Okay. Okay. Let me just go to Exhibit E. Okay, could you describe to us what's occurring here?
Yeah, so activity taking place in the after photo at the bottom here, it clearly shows that there's exposed soils on the bank, and at the bottom of the hill, the silt fence is in place where there's stabilization, and then where the bank is not stabilized, the erosion control ends, which is not what we want to see.
Okay. Can you describe what's happening in the bottom photo here?
Yep, same thing. Silt fence has fallen down and is not doing anything.
Okay. I'm going to go to the next violation is violation number 2. The shoreline zoning ordinance requires a permit from the code enforcement officer for any fill or earth moving of more than 10 cubic yards that occurs in the zone that's at issue here. Alex, can you just describe describe this violation, and I'll go to the exhibits.
Yeah, so 10 cubic yards is one good sized dump truck. So if you look at any of these exhibit photos and the after photos, you will see that a significant amount of disturbance has taken place, but they also brought in mulch. They brought in all of the rock, and it doesn't take very much to reach that 10 cubic yard threshold, which they exceeded by probably quite a bit.
Okay, so let's just let me go to Exhibit A here, and you could just walk us through these first 3 pages and just describe what we're saying and relate it to this violation, please.
Yep, so the bank has been stripped, graded. The old rock has possibly been removed or covered on top of with new material. Here is the area that's been, vegetation's been removed. And then this is the new bank in place with the new material. Just in this one photo alone, right there, I mean, they definitely exceed a single dump truck worth of riprap, that's for sure.
Okay, let's go to Exhibit B here. If you could just describe this as well.
This one is for the boat ramp. Yeah, so the boat ramp, here you can see that they deposited, much more riprap than, was clearly on site. You can tell by the slope of that boat ramp is much shallower pitch than what existed before. All that mulch on the side.
Okay. can you describe what's we're seeing here in relation to this violation of the filling and earth moving?
Yep, all of this material in the after photo, the riprap, the mulch, all of that's all new. Been deposited on site without a permit.
Okay, and could you describe on this page and this page the same thing?
Yeah, this is a very large area. It goes back almost about 100 feet from the water and probably out 50 to 75 feet. Just, the stripping of all of the grass that was there, or if you were running equipment over it constantly and disturbing that site, you're disturbing an area that's all sloped towards the lake, and all of the water from the top of the lot and the road behind it and the roof is all coming down that and headed right for that nice new pitched boat ramp.
Okay. I'm going to go on to violation number 3, and this violation relates to the boat launch. So, as a permanent structure, construction of the boat launch requires planning board approval. Alex, does the town have any record of any planning board permit relating to the boat launch?
No.
Okay. Now, the shoreline zoning ordinance also requires that a boat launch have a permit from the DEP. Are you aware of that existing?
No.
Okay. And now the ordinance provides that a non-conforming structure can be expanded, but only after obtaining a permit from the same permitting authority. Is that right?
Correct.
Okay. And so here then, expansion of the boat launch would require a permit from the planning board, correct?
Correct. Yes.
And again, the town doesn't have any record of that. Is that right?
No.
Okay. Let's go back to Exhibit B and just have you just describe this.
Sure.
Okay.
Yeah, so this boat ramp was a wooden structure. Like I said in the presentation, it looks as though it was just 2 wooden pallets, end to end, used to transport kayaks, canoes, rowboats up and down the shore, since they can't do it from the rock because it's pretty steep already. And
okay,
and stairs.
Alex, I'm just going to stop it for a moment, and I'm going to go to I'm going to show you for a moment some pictures that were just submitted today, Leah re-forwarded to the ZBA today. These are photos that were included in there, and my understanding is, and you tell me if I'm wrong, that these show what the former boat launch looked like.
Yeah.
Okay.
Yeah. This is definitely it.
So then here, that's what replaced it.
Yeah, I mean, it doesn't even look like the same lot. Completely
right.
different.
I mean, it's clearly expanded, isn't it?
Oh yeah, definitely.
Okay.
I mean, it's much larger.
Okay, I'm going to go back to what management control also provided to the ZBA today. And in here, I don't know if you recognize this, but this is, you confirm it if to me, Alex, this is part of the application that Attorney Rachel described that was submitted to the planning board from Mike Morse. Does that look like what this is to you?
Yeah.
Okay. And I just wanted to point out here that in that document, here's what he stated. And could you just read that to the ZBA, please?
Yeah. The width of the boat launch was expanded to approximately 16 feet, largely as a result of the removal of a large tree stump that altered the side slope grade.
Okay. Good enough. Okay. Let's see. I think that and also actually, let's see. Okay, I think that pretty much wraps up for violation 3. Let's move on to violation number 4. Violation 4 is for enlargement or expansion of the shoreline without a permit. And here the shoreline zoning ordinance provides that where permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extend over or below the normal high water line, approvals required from the planning board. And for all of the reasons that the ZBA upheld violation 5 in the notice of violation of management controls relating to Fernwood, you should also uphold this violation. But beyond that, Alex, could I have you describe the enlargement or expansion of the shoreline? And I'll go to the exhibits to the notice of violation for that.
Yeah, here in Exhibit B in the before photo at the very end of the arrow for existing boat ramp, you can see it curves in away from the water at the end of that peninsula. And in the after photo, you can see that it's a straight line across. There's no longer the curve in where the water was coming in. So it's clear to me that this area has now been expanded towards the water to create more of a straight, cleaner angle.
And I think there was, I was kind of a little confused from the questions that Attorney Rachel was asking you, but I think what your testimony is that essentially the U is filled in. Is that basically what it is?
Correct.
And what has the U been filled in with?
Riprap.
Okay. Okay, I'm gonna have you look at Exhibit D here. You just describe what we're seeing there.
Yeah, so I mean, at the bottom here, you can see, that after photo, likely that shoreline kind of continued straight, kind of parallel with that silt fence, and then turned right once it hit that peninsula. But now it's kind of curving out into like more of a straighter line instead of having a jog in.
Okay. Okay, I'm going to go to violation number 5. Now, violation 5 is for construction of a beach without a permit. And the shoreline zoning ordinance requires that the construction of any beach shall have a permit from the DEP. And for all of the reasons that you upheld violation 6 that was contained in the notice of violation of management controls relating to 18 Fernwood, you should also uphold this violation as to whitetail. So, Alex, could you walk us through this violation, please? And I'm going to go to Exhibit C.
Yeah. So yeah, what we're seeing here, then the before photo, there's some large boulders on the beach, rocks that don't exist in the after photo. My original assumption was that they were removed. I don't know if they were used to make the the riprap stabilization project work, or if they were brought into the water or offsite, who knows, or if they were covered with sand. Really, the end result is now a cleaner, smoother, flatter beach area.
Okay, very good. We'll move on to violations 6 and 7. So violation 6 is for clearing or removing vegetation less than 3 feet in height within 100 feet of the normal high water line, and the shoreline zoning ordinance prohibits that from occurring. Now, violation 7 is for clearing or moving vegetation without a permit, and the shoreline zoning ordinance prohibits clearing or moving of vegetation really of any height without a permit. And for the same reasons that you upheld violations 7 and 8 in the notice of violation relating to Fernwood, you should also uphold these violations here as to whitetail. Alex, I'm gonna ask you to walk us through these two violations here, and I'm gonna go to Exhibit D for that. Bear with me.
Yeah,
Okay.
so in the before photo, you can see that there's vegetation on the bank, and actually there's grass and some ground cover growing in this retaining wall, which is exactly what you want. And then in the after photo.
Yeah, I just want to be clear. And what you're talking about the vegetation growing within this hashed area that's marked by the hashed line?
Yes.
Okay.
Yep. And then in the after photo below, that segment of shoreline was replaced, and everything that was there has been covered or removed.
Okay, and then let's go to, just describe this to me.
Yeah, so here you'll see there's grass, natural ground cover, and shrubs, which have been completely removed. And I think it was stated that they were ornamental or landscape features that weren't serving any purpose. The ordinance doesn't differentiate between the two. Within 100 feet, vegetation less than 3 feet in height, or vegetation in general, is required to be removed under the removal standards.
Okay. Can you just describe this here too?
Yep. Again, here's that large section that I talked about before next to the house. That was grass. Originally, has been stripped of everything down to the water.
Okay.
And this is just a different angle of that same area.
Okay.
Yeah, I mean, this one is probably one of the more drastic angles of this particular property. You've got all of that vegetation, the ground cover in there that no longer exists. It's all been removed.
Okay. And just to orient ourselves here, is this the location here of the boat ramp?
Correct.
Okay.
That is it.
Can I just have you describe this here too?
Yeah, so you can see there's a few different spots where grass is, over the years grown up between this existing riprap. And, that's exactly what you want, holding the bank together, absorbing rainwater as it comes down. And it's all been removed.
Okay, thank you. Now, as Alex pointed out, there's been some contention that this vegetation was of limited value. You should reject that argument here, because those issues would have been considered by the code enforcement officer if a permit had been applied for. Here, there was no application for a permit submitted. The code enforcement officer never had the opportunity to consider that, and you should reject that. And here, because this work was completed without a permit, it's a violation. And like Alex was just mentioning, whether the vegetation was within an existing lawn or ornamental shrubs, that just isn't relevant. What's relevant is whether vegetation less than 3 feet in height within 100 feet of the normal high water line was removed, and whether vegetation was removed without a permit. Both of those things occurred. Therefore, both violation 6 and violation 7 have occurred. Now, I just want to talk about violation 8. Violation 8 is for the unpermitted shoreland stabilization project. And there's some discussion about that. Alex, can you just describe what that violation consists of?
Yeah, I mean, there was, like we talked about before, there is an existing riprap shorefront here. The shoreline was all stabilized. There's no clear need for an erosion control project based on what we've seen on these photos. They, for some reason, decided that they didn't like the look of it, maybe. Maybe it just wasn't what they wanted. I don't know, but nevertheless, they went ahead and removed, covered, replaced what was there with new riprap without any permits.
No application for permit was made.
Correct. Yeah.
Okay. Okay. Violation number 9 is for completing a shorefront stabilization project without a barge. And for the same reasons that the ZBA upheld this violation as to Fernwood, you should also uphold the violation as to Whitetail. Now,
Mr. Chairman, if I may just register an objection, please.
Sure.
I've heard Attorney Wyckoff say on several occasions that for the same reasons that you should uphold the violations in Whitetail as you should on Fernwood. As I said in my initial remarks, I think it's really critically important to focus the board on the fact that these are two very different properties for all the reasons I identified. But I just want to make clear that that is on the record.
I appreciate that. You know, you're right. What I'm really trying to say is for all, you know, for the facts are different, but for the reasoning that you employed with regards to the other property, that same reasoning should be used here, applying the facts relating to whitetail. So as Alex testified earlier, the stabilization project requires a permit from the planning board. And when that happens, the shoreline zoning ordinance directs the planning board to determine if access by a barge was feasible or not. Now, the contention by management controls that a barge wasn't feasible, you should reject that. You shouldn't pay any attention to that argument, because that issue would have been considered by the planning board had a permit been applied for. There wasn't an application for a permit ever filed, and the planning board never had the opportunity to consider whether a barge was feasible or not. So you should just reject that argument. So I want to have you, Alex, if you could just go to Exhibit E here and just describe what this photo, the significance of this photo.
Yeah, so this is a picture of Rob Durant's Big Lake Marine's barge and excavator moored on Sebago Lake, November 16th, 2021, just around the cove from where this property, the work has taken place, exists. So yeah, he does a lot of work throughout the summer on this barge. We see it all over the place.
And Mr. Durant, you've spoken to Mr. Durant about the concept of doing restoration work here this fall. Is that right?
Yeah.
And what did he say about the concept of using a barge to do the work?
Well, it was brought up on site when we met, I don't know, a couple of months ago at this point. Whoops, sorry. We met on site and it was discussed about who would do the restoration work and when that would be done, and would it be feasible to do the work this fall. And Rob stated that he felt as though he could do the work to the 28 whitetail property from the barge.
Okay. Okay. Next I want to talk about violations 10, 11, and 12. Now, in the appeal, management controls contends that trees were removed to accommodate construction equipment. Now, you should just reject that argument, because that issue would have been considered had management control sought a permit, but as is clear, no application was submitted. So you should just reject that argument. And then there's also a contention that these trees would have been hazard trees and they could have been removed. You should also not credit that argument at all, because those issues would have been considered by the code enforcement officer had he been consulted as required by the shoreline zoning ordinance relating to hazard trees. Now, violation 10 is for violating the shoreline zoning ordinance's prohibition of removing trees that create an opening in excess of 250 square feet. Violation 11 is for removal of vegetation in excess of what's allowed by the point system contained in the shoreline zoning ordinance. Violation 12 is for violating the prohibition against removal of vegetation without a permit as a result of removing vegetation between the house and the water here. So the shoreline ordinance does allow hazard trees to be removed after consultation with the CEO if one canopy opening would be less than 250 square feet. If the canopy opening is greater than 250 square feet, then replacement with native trees is required, and the ordinance requires that stumps may not be removed. So now, Alex, was there any consultation with you regarding any hazard trees and removal of any hazard trees?
No.
Okay. So as a result, we don't know whether or not they were in fact hazard trees. Fair to say?
Correct.
Now, under the ordinance, if someone comes to talk to you about the removal of hazard trees, I understand you could require submission of that evaluation to a forester regarding hazard trees. Is that right?
Correct. Yep.
But that never happened, right?
Correct.
Okay. Now, an opening in excess of 250 square feet can be created, and if that happens, then there has to be revegetation, and revegetation can only occur pursuant to an approved revegetation plan. Was that submitted in connection with the removal of the trees?
No.
Okay. I'm going to have you walk us through the violation. I'm going to go to Exhibit F. Can you just describe this, please?
Yeah, so here we're seeing in the before photo, 11 trees that were removed for the erosion control project illegally without a permit.
Okay.
That's a perfect example of something that would get reviewed under the permitting process for an erosion control project, stabilization project.
Okay.
And here we're looking at,
go ahead.
Yep, 10 through 14 in the before photo, and then the approximate location of those trees on the new segment of shoreline.
Or rather,
today.
the non-existence of the trees than being removed.
Correct.
Okay. This photo?
And we're looking at, 11, 12, and 13.
Okay.
Which I don't see how, 12 and 13 were likely removed for the replacement of the wall. I would assume they clearly wouldn't have been hazards. I can't see how they would have been, but.
In any event, they were removed.
Correct.
And that was in violation of the ordinances.
Correct.
Okay. Can you describe this picture, please?
Yep. And here we're looking in the before photo of tree 14 as we identify them, and the after that tree has been removed.
And you weren't consulted about what that tree was like, and so you don't know what kind of tree, what it was like.
Correct. Yeah.
Okay. Can you describe this page, please?
Yep. And again, before we're looking at trees 1 through 10, and then the after photo, the approximate locations of trees 1 through 10 during construction of the project.
Okay. Now, how do you know? So describe this this page, please. This last page of Exhibit F.
Mm-hmm.
Can you describe it, Alex, please?
Yep. So here we're looking at the aerial photo from, I believe this was 2018, Google Earth, and this is showing the areas where trees have been removed. And it's included, I've added some dimensions to give you an idea. 25 by 60 is in excess of 250 square feet by a good amount. And then you add in the other 2 sections and you exceed the standards for what's allowed to be removed.
Okay. And all of those trees that made up those bubbles are trees that have been removed. Is that right?
Correct.
And that was depicted in the photos we just looked at, that those trees were removed.
Correct.
Now, earlier we heard Attorney Rachel was asking some questions relating to the notice of violation and what it stated could be done in order to eliminate the violations. And I just wanted to have you go to that page and read that to the Zoning Board of Appeals. She was trying to make it sound like the town was asking only for submission of after the fact permits. And I just wanted to have you relate to the board what the notice of violation actually said as to how they could be remedied. And you could just, for instance, for violations 1 and 2, could you just describe what the notice of violation says?
Yeah, for violation 1 and 2, well, the above it asks for a global restoration plan, which should include the following. And then for 1 and 2, they needed to obtain after the fact permitting for filling and earth moving that occurred of more than 10 cubic yards. And if you cannot obtain a permit, restore the area to its condition before the filling and earth moving.
Yeah.
Yeah, and that's it for that one.
And really, that's the case for all of these violations, that the town asked for either to obtain an after the fact permit, or if that wasn't possible, to restore the site to its original condition. True?
Right.
Now, I think you said it, Mike Morse did submit an after the fact application to the planning board. Is that right?
Correct.
Do you have an understanding as to who actually hired him? Was he hired by Management Controls?
I believe he was actually hired by Rob Durant.
Okay. And did you review the restoration plan that he submitted?
Yes.
Okay. How did you evaluate it?
We found quite a few deficiencies, things that we were just a little disappointed by.
Okay. Now, do you have an understanding about what the status of that application is?
I believe it was submitted and then tabled. And I believe at that point, Mike Morse had contacted Sandy to let her know that this likely would need to stay tabled for a while.
Okay. So it's your understanding that he basically said to Sandy Fredericks, this should just be tabled until we let you know otherwise.
Yes, I believe so.
Okay. Okay, I just want to address some procedural arguments that have been made by Management Controls. They contend that that violations 1 and 2 are the same violation, and that they're only listed twice in order for the town to seek duplicative fines. And for the same reasoning that the ZBA used with regards to a similar argument relating to violations 1 and 2 as to Fernwood, the ZBA should also reject that argument. These are two separate violations. Violation 1 is for filling and earth moving without taking steps to prevent erosion and sedimentation. Violation 2 is for filling and earth moving without a permit. Even if a permit existed for filling and earth moving, there would still have been a violation, the failure to take steps to prevent erosion and sedimentation. And even if steps were taken to prevent erosion and sedimentation, but the work is done without a permit, it would still be a violation. Now, to the extent that Management Controls is making any argument relating to fines, you should reject that. Fines, that's a separate issue from violations, and the ZBA doesn't have any jurisdiction, doesn't have any role with regards to assessing fines. So that's really beside the point, and it isn't something that the ZBA should be considering here in connection with the appeal. Management Controls also contends that violations 6 and 7 are the same violation, and they're only listed twice in order for the town to seek duplicative fines. So just like I said, fines, that's not for the ZBA, doesn't have a role in connection with assessing fines. So that's just an argument that you should disregard. You should also disregard this for all the same reasoning you employed in the other appeal as to Fernwood. These are separate violations. Violation 6 relates to violating a requirement that vegetation less than 3 feet cannot be cut, covered, or removed, except for a footpath. Violation 7 is for moving vegetation without a permit. If there had been a permit, removing the vegetation less than 3 feet tall within 100 feet of the normal high water line would still generate a violation. So these are just separate violations, and you should reject this argument. Management Controls also makes a procedural argument relating to violations 3 and 4. And they contend that these both cite the identical version of the zoning ordinance but are included as 2 separate violations, and it's only being done in order to seek duplicative fines. Same story there. That's not for you to deal with. Fines aren't something the zoning board of appeals deals with. These are separate violations. 3 is for expanding or enlarging the boat launch without a permit. 4 is for expanding or enlarging the shoreline without a permit. They're separate violations and they don't rely on one another, and you should reject that argument. Management Control also contends that 10, 11, and 12 are the same violations because they all involve unpermitted tree removal and are just redundant for seeking duplicative fines. Same thing there. Fines are for the zoning board of appeals to deal with. That's not your issue to deal with. You should also reject this argument for all the same reasoning you employed in the other appeal as Fernwood. These are separate violations. Violation 10 is based on the Shoreline zoning ordinance, which prohibits removal of trees within 100 feet of the water. It creates an illegal opening in excess of 250 square feet. Violation 11 is a separate provision in the ordinance. It allows selective cutting of trees within a buffer strip. as long as you maintain a stand of trees and other vegetation. And if other trees are present, that provides sufficient points to allow for selective cutting. 12 is removing vegetation without a permit, and it relies on a separate provision in the ordinance. So these are separate violations relying on separate provisions in the ordinance, and they don't rely on one another. I don't have anything else. Thank you.
Thank you. So Attorney Wagner, if I understand correctly, at this point, the zoning board can ask questions of Alex and great. So I do have a couple of questions, Alex.
Just to clarify, again, will I have opportunity to question a witness and participate in the proceeding?
Yes, after the board has had an opportunity to have questions and Attorney Rach, and then we'll turn it over to you and any members of the public.
So Alex, for the notice of violation, specifically number 3, where we're talking about boat launch, there was a picture shown. I think it's under Exhibit B, and it shows the stairway, and then it shows the picture of the older boat launch, and then there was a reference given in that picture of the width of the older boat launch. Is it possible to bring that picture up again and essentially point out where?
Let me. I can share my screen.
Yeah.
I think, is this the photo you were talking about?
Yeah, especially the one on the before on the bottom. Just I can see clearly. I can see the steps. Can essentially with a pointer show sort of like the width, you know, the side to side of the boat launch from that view. Is that an option?
Oops, sorry.
See, it's kind of coming blurry. So is there any chance with a pointer to just say, you know, point out from left to right, this is where you perceive the width of the pre-existing boat launch?
So I think you're asking Alex to do that, and I'm trying to figure out how to do that logistically as this is on my screen. Oh, he's doing it. You're muted, Alex.
I love Zoom. Zoom is great. Sorry. Once you're in that particular menu, you can't mute or unmute yourself. So, all right. Yes. So from here, it's black too. So hold on. I'll do it white. From here to here. From here to here. You see that one?
I can see them. Yeah, I can even see the black one too. Okay.
Awesome.
Thank you. Thank you very much for that.
Yeah, no problem.
For number 4, we're talking about the shoreline. The references to section 14, table of land uses number 17B, permanent piers, docks, structures, wharfs, bridges, boat launches, and other structures. Is the contention or the argument that shoreline is a structure?
Yes.
Okay. Do we have?
It also says uses.
So when we wrote this up, what is it? Are we defining shoreline as a structure or a use?
Hold on one second. I'm trying to find something that will help answer this question. If you want, I think Leah jumped in. If you want to maybe let her speak and then I can circle back to.
I'm sorry, I didn't mean to interrupt the question. I just wanted to clarify that, you know, under this section, we're talking about piers, wharves, docks, those kinds of things that if you look at the definition of structure, it talks about, and I don't have it in front of me, but housing people and you know, a shoreline does not fall within those things that are traditionally associated with structure. I know that there was an indication of use, but again, if you look at the land use table, right? And if I could, can I share my screen for a moment, if that would be helpful?
Actually, yeah, I think I'm just going to rely on Alex to provide us. All I'm looking for is where was Alex coming from when?
Okay, fair enough. Fair enough.
So, I mean, in this particular situation, we rely on what the ordinance says, and you know, under piers, docks, wharf bridges, and other structures and uses extending over or beyond the normal high water line or within a wetland, there's temporary and there's permanent. A permanent is a structure which will remain in or over the water for 7 months or more in any period of 12 consecutive months. The table, you know, lists who is the permitting authority. Then if you go to that particular section in the ordinance, it has standards specific to piers, docks, wharfs, bridges, and all that other good stuff, which is 15C. It's listed as other structures, and I believe the intent here, and this is something, you know, I've had conversations with Jeff Kalinich at DEP. The intent is to treat it as a structure because a retaining wall at the shore to correct a stabilization or a erosion control issue usually is at or below the normal high water line. So that puts it below the normal high water line for more than 7 months a year, which makes it a permanent structure or other structure. And that's the interpretation that I've relied on.
Okay, thank you. For number 6, removal of vegetation less than 3 feet in height. We have the shoreline zoning reference, and then you also, in the beginning of that section, listed, you know, your own comments. Was the first word in this where it says all existing vegetation is all just an unfortunate use of words?
Yeah, it definitely is. And that's what I was trying to get at with Leah earlier. It's like, I understand exactly where you're coming from on that. Clearly, all is not the best word choice for that. And that is an oversight on our part.
A few more questions, Alex. For number 5, construction of a beach without a permit. It appears that there was a beach there previously. Can you construct something that's already there? Or
I would pose it in a question like this. If you have a beach that's covered with large rocks and you bring in sand to cover those rocks, do you feel as though that would be beach construction? Maybe the beach is already there and there's large rocks on it, but have you improved the beach? Have you done any activity, any construction activity to that beach? Now, if you go down there and you have a beach that's covered with large rocks, maybe 6 to 12 inches in diameter, and you go down and you pluck those rocks out, you remove those rocks, are you improving and continuing to construct an improved beach? And that's how I looked at it. Yes, there was, you know, an area that's flat for them to sit on and hang out. But did they actually go down, and was there construction to that area to improve it? That's the question I asked. And to me, there.
Do you view just? Okay. And
David, I think one thing. Sorry, we're not saying they created a new beach.
Right.
That's how I think I can best answer you. We're not saying there's a new beach here. They may have had a beach before, but there was improvement activity to that beach without a permit, is what we're saying.
Okay, very good. My last question, Alex, is for number 8, permitted shoreline stabilization, no permits. There's been mention of this permit by rule I'm not sure if this is the appropriate place to ask it, but how does a permit by rule come into play?
So they applied for a permit by rule, I believe, in July of 2021. Under the process for a permit by rule, you submit this application to the state, and if you hear nothing within 2 weeks, you are approved. Alexis Avalos of DEP reached out a few weeks after they submitted it to let them know that the application had not been approved and was marked deficient. I believe they exceeded the length allowed. You're only allowed to do 100 feet of shorefront, and they were proposing much more than 100 feet with the two contiguous properties. They were, I believe, their opinion was that because the two properties were together, they thought they could do 100 on each to do a grand total of 200, I think. I don't want to get too much into this because that's DEP and I wasn't involved in that. All I know is from what we were told by Alexis, they did not have an approved permit for what took place on site.
Thank you, Alex. That's it for me. Any other board members? You have questions for Alex? Great.
Yeah, I have a question on number 5, and back to the beach. Perhaps you could pull up the before and after photos on that. Either.
Sure.
Anybody, what's wild card?
All right, so the beach. Yep.
Yeah. So Leah did a pretty good job, I think, at kind of establishing a timeline. I just want to verify the timeline of these photos. So actually, if you could zoom out so we can compare the, I'm looking at the water line and what is likely the time at which these photos were taking place. Can you explain the before photo? When was that taken?
The before photo was taken in August of 2021. The after photo was taken October 2021.
Okay. So there's a substantially lower water line in general between those two times of the year.
Yeah, so you've got this rock down here, which looks to be somewhere around here.
Okay.
So I guess what I'm wondering is where are all these dark rocks here? That should be right here.
Yeah, and are you suggesting that those were covered in the after?
Well, in the photos that Leah showed earlier from yesterday, there's now rocks in here that were not there in October of 2021. So I don't know if the sand that was here has eroded away.
Yeah.
So I'm trying to figure out, maybe with you here at the same time, how in August of 21, it looked like this up here. And then in October looked like this. And then now today, again, looks like this, if that makes any sense.
I mean, sand kind of does come and go a little bit on a beach. It's not necessarily guaranteed that.
Hey, Alex, this is Tom.
Hey, Tom.
Okay. Go ahead.
Hi. So all the black rocks disappeared. And then what Leah showed us of today's photos, there's new rocks thrown in there from some source. Is that what my takeaway is? Someone threw in some additional rocks and
well, I don't really know what the conclusion is on that. I mean, the other possibility is you can get a permit from DEP to rake sand out from the lake up onto the beach. Although it doesn't look like there's much down here for sand. It looks like you got a lot of rocks right here. So you can go in and rake some of that out if you have an existing beach. I don't know that happened. I don't know. Wave action could have pushed sand up, but again, if this was all sand here, I would say that's possible. But where did all of this sand here come from? Is the question. For me, like I said to Dave a minute ago, I'm not arguing there was no beach. I think there was a beach. I think there has been some type of activity that's taken place on the beach that has improved it. And that's why they were given the notice of violation.
I see, but you can see that there's a certain amount of flux in the natural change of a beach anyway, and what I guess what you're saying is that your opinion is that it exceeded that threshold.
Yeah, yeah. Based on what we saw when we went down in October of 2021, we felt there was a significant change that had taken place.
Okay, and then I have just one other question on. I always get, this is always a tricky one for me, but 6 and 7. If we could pull up an example of a violation of 6, discrete violations of 6 and 7, where they're not kind of overlapping. I think just in particular, I have a hard time understanding the distinction. I know you're referencing different ordinances. I just was hoping you could point out specifically where 6 was uniquely violated and where 7 was uniquely violated.
Yeah, so 7 is the table. So that's the actual activity without a permit. And then 6 is the actual removal for the project, for the erosion control project. So you can, like I had said before, you can remove vegetation less than 3 feet in height for an allowed use or permitted project. And that's allowed. In this case, there was no permit issued. Had they gotten a permit for the stabilization, that tree removal would have been allowed. But they didn't get a permit for that. And then they didn't get a permit for just the tree removal for that, for vegetation less than 3 feet in height. So people often will apply for a permit just to remove vegetation less than 3 feet in height within 100 feet, which is not allowed. The only time it's allowed, like I said, is for permitted use or if you're creating a 6-foot wide meandering path for the water. Now, that removal doesn't necessarily mean you're going in and pulling up, what's there. It can be trimming it. It can be covering it. It could be putting a tarp over it for 6 months. All sorts of different things. Now, I don't think that's going to answer your question based on how I've seen you handle this one in the past. But what I will say, I'm going to go back to my old one. Let's say theoretically they went down there and they built a house 25 feet from the water, and they didn't get any permits to do it. There's multiple sections in the ordinance they would be in violation of. It's one activity. The building the house is that one activity, but they would be in violation of the 100-foot setback, and they'd also be in violation of the requirement to get a permit. So we have to, when there's a violation that takes place, we have to look at the ordinance and determine out of this, couple 100-page document, where all the violations are and which sections they're in violation of. So that's why we approached it that way.
But is it fair to say if they had a permit, then both of those violations would go away?
Yeah, I think all of them would, most of them.
But for the vegetation less than 3 feet, right?
Yeah.
Right.
Yes.
So then, yeah, I mean that's
Is there a situation? Whoops, sorry, go ahead.
No, I understand that when there's specific subcategories, like there's a point system for trees, there's canopy coverage, there's like erosion control, and then there's just certain thresholds of moving earth that are kind of different specific things that you could uniquely violate. This one and the reason why I'm bringing it up, and I hate to belabor the point, but I think this one 6 and 7 seem really hard for me to tease apart, and I was just hoping we would try it again. I think we're kind of at a similar juncture.
Yeah, and I think one thing you said last time was, is there ever a possibility where someone could get a permit for the activity and then still be in violation of the other one, right? And they could get a permit to remove vegetation for less than 3 feet in height and then exceed what was allowed under that permit and be in violation of the specific standard, exceeding what's allowed under that with having a permit in hand. Now, you probably argue that they then don't have a permit for that portion of the activity, I suppose, but that would probably be the only situation where that would work.
Yeah, I understand what you're saying. I'm not sure I'm quite moved that much than my previous understanding, but I get it. That's it for me.
Dave, can I ask Alex a question?
Yep, please.
So on the tree removal, even if it's permitted to be removed, you're not allowed to remove the stumps, correct?
That is correct, within 100 feet,
Now you're allowed to grind them down.
correct.
So do we know if them stumps were removed or if they were covered or ground? Or...
We believe they were removed. At least the large stumps at the shorefront. And that was actually, I believe, in Mike Morse's submittal that Eric brought up earlier that had me read from. I think they actually removed a stump at the shorefront, and that was the reason for expanding the boat ramp.
That's all I have.
David, can I ask Alex one last question?
Yeah, of course.
Alex, I know that town owns several boat ramps on different lakes in the town of Raymond. Is there any of them that are 16 feet in width besides the Sebago Lake double ramp?
You know, that's a great question. I'm not sure, to be honest.
I bet they're not. Just
Yeah, probably not.
I've been to 2 or 3 of them, so just ammunition for you.
Pete, did you have any questions? You're on mute, Pete.
Yeah, I don't have any specific question for Alex, but I do have a comment that I'd like to make, if that's okay. Is this appropriate to do that?
What do you have to say, Pete?
So I took a quick look at the letters from Q Team, and I just wanted to point out that the first letter does not make any specific reference to either property, but the second letter does specifically identify 18 Fernwood.
Thank you. So Attorney Wagner, does this, I believe, that we allow Attorney Rachin opportunity?
Yes, Attorney Rachin, and then I turn it over to Attorney Braun and members of the public.
Good. Attorney Rachin.
Thank you. I just wanted to state for the record, because I'm required to do so, to preserve any issues that or concerns I have. I just wanted to make clear that I don't think it's appropriate for board members to be advising the code officer about ammunition that they should have. And I think that that's inappropriate, and I'm just registering that as a possible indication of bias or due process. So I will leave it at that, but I do need to register that for the record. I just have a couple follow-up questions, if I could, for Alex. I think on a couple of occasions that I wrote these words down, so I think they're correct, but you said that the riprap was replaced or removed. I think you said that both of those things could be true. And I just want to go back to a picture of the property itself. Let's look at this. I'm going to share my screen in just a minute. Can you see my screen here?
Yep.
Yes.
Okay. And so clearly, I mean, we've got quite a large boulders here. Fair to say those would be pretty hard to remove. Or let me ask you a different question. What evidence do you have that the existing riprap wasn't in any way removed? I mean, did you look underneath the new riprap that covered it to maintain it, or do you have any evidence?
No.
Okay.
I did not look underneath
Okay.
the new riprap. No.
So to the extent that you said it's replaced or removed, we don't know that's the case, correct?
I mean, we would rely on you to let us know if there's anything different than what we're saying. I mean, if it hasn't been replaced or removed and it's been covered over, then that would be good to know.
Okay, so that I'm going to ask my question again. Do you have any evidence to suggest it has in fact been replaced or removed?
No, I guess we don't. Unless you want to help us with that.
Okay, so the next question I wanted to ask you about is with respect to the boat ramp. And I'll pull up some pictures of that if I can. There we are. And I think you had mentioned a times you talked about how its pitch has changed or its slope has changed. Can you just talk about what your basis is for that? Did you measure the slope, or what are you basing that on?
Based on where that boat ramp lands on the before photo, it's much further back.
Did you measure it at all?
Yeah.
With how did you measure that? With
Just
what?
based on visually, I mean, looking at that.
Okay. So no, I think you had mentioned,
How would we measure that with the survey equipment, or what would you accept for a measurement on that?
I'm asking you if you did measure it. I'm not suggesting options. And I heard you say no.
Well, I mean,
I'll move on.
What would be a measurement, I guess, is my question, because it's possible we did measure it then, depending on what you're looking for.
You talked about how I think you said you believed that there were stumps removed, and I think you mentioned that there was one place in particular near the boat ramp. But with respect to all of those other trees, do you have any evidence to suggest that those stumps were removed?
I believe we do. Let me just take a look.
And while you're doing that, well, go ahead. I'm sorry. I don't want to interrupt you.
Yeah, I mean, the best evidence I think we have would be under Exhibit F, which shows no stumps.
But those stumps can be ground to the level of.
Yeah, I don't believe they were. No.
Based on what though? Is what I'm asking.
Testimony from Rob Durant on site.
Okay, and what about the evidence, I believe, of...
And I don't understand. I wouldn't make sense to me why they would remove one or two, but not all. When you're going to be stabilizing a bank, you're not going to put filter fabric and riprap over, tree stumps.
But isn't it your testimony that's what standard?
No, I'm saying they have removed the tree stumps.
Okay, but you didn't. Have you observed any sort of areas in the land that show that there's a gap? That usually when stumps are removed, it's my understanding that there's some, I forget the word, but you can see in the land that there's a depression there.
Well, unfortunately, the site was completely altered and filled and graded, so there's not going to be very much evidence after the fact. The site was very soft, I can tell you that. It was not as firm as it would be if there was, 12 or 10 stumps holding a bank together.
Okay. One question was going to the PBRs, and my understanding with permit by rule is that when an application is made to the state, that towns are notified. In fact, I believe that states that on the application itself. Were you notified by the DEP of the application?
No, the state does not notify the towns, even though it's on the form.
And okay, so you're saying as a practical matter, even though the permit actually says that they do not? Correct. And you did not, in this instance, receive notification?
Nope, I saw all this in October.
Okay. And regarding the Google Earth, I'm going to just circle back on that, the measurements that you used with respect to Google Earth. Mm-hmm. And for some reason, can you bring yours up, that Exhibit F, to the notice of violation? Would you be so kind to do that?
Yep. It looks like you'll need to stop screen sharing first.
Oh, yes, of course. Sorry. Thank you. Mm-hmm. And can you tell us when that was actually taken?
Yeah, this is a 2018 aerial photo.
Okay. And those measurements that you put on there, you talk about these bubbles, right? Yep. Just so I understand, you talk about bubbles, but it really is supposed to be a grid, correct? There's like okay. Yeah. And these don't look like grids to me. They are not that sort of I think it's 25 by 50.
Mhm.
Okay. So you'd agree with me that a grid tends to be a square rectangular
Absolutely.
area. Okay.
Yep.
So with respect to Google Earth, I see that you put these on. You drew these, right? These measurements here.
Correct. Yep.
And how do you know, the margin of error with Google Earth?
I don't know. No one's ever questioned it.
Okay, and that's the scale. With respect to camera height and such, doesn't that make a difference as to what the scale is?
Yeah, but that's usually calculated based on the height. That's how it works. At least that's my impression of the technology.
All right. And the after photos that you have, you don't have Google Earth after photos, correct? That would show the same area?
Not included with the NOV, no.
Okay. All right. A couple more things. I'm trying to find that picture of the boat ramp at the bottom, right?
Mm-hmm.
And you talked about how there'd been some filling there.
Yep.
And again, the violation, I think, references at or on or below the high water mark, correct?
Mm-hmm.
So tell me where the high water, can you on that picture point out to me where the high water mark is? Actually, I want to find the photo. Oh, here it is. Yeah, if you would do that.
So this particular day, it would be here.
Okay, so how on any given day, I thought that the high water mark was what the high water mark was. I think, like you mentioned, that website. And doesn't that website sort of specify 266, or I can't remember what the numbers are, but are you suggesting that the high water mark changes on any given day?
It changes depending on what the town's ordinance says. And our ordinance doesn't specifically take the elevation of the water.
Okay, so when you put this line in that you put in, what are you basing that on?
Basing it on where the water is right there. Now, I can tell you observed change in vegetation is going to put the high water mark much higher. So that would be up here. But realistically, that's not the normal high water mark. So in this type of situation, the way we handle it is we accept a surveyor's decision on where that mark is, which they did do.
Okay, and so this lower mark here is the surveyor's position?
Nope, that was ours based on our site visit that day, having to determine a location.
All right. I think as far as cross-examination, that is it for me. My understanding is that Greg will now go, and then I'll have a chance to summarize.
I would say, yeah, Greg would go. I would then give an opportunity for Attorney Wyckoff if he has any re-examination, and then you as an appellant would have the last word.
Thank you so much.
Attorney Wagner, when's the best time to open this up to the public? We don't have any members of the public, but
well, I would turn it over to Attorney Braun and then the public after that.
Very good. So, Attorney Braun.
Sure. So
you have to say.
Going to touch on an awful lot that Leah has already touched on. So I'll try hard not to be repetitive. But to the extent that I am, it's important, I think, to make sure the record establishes certain facts. And so I just want to confirm some of the statements or testimony you previously gave. First, you indicated that you have no background or training as an environmental engineer. Is that correct?
That is correct. Code officers are not required to be.
Okay. And you have no background or education in surveying. Is that correct?
That's correct. Code officers are not required to be.
Okay. And similarly, no background or education in geology?
That is correct. Code officers are not required to be.
And no background or education as a civil engineer?
That is correct. We are not required to be.
Right. And so the extent of your training and knowledge base here, you indicated was based on your state certification to become a code enforcement officer, correct?
Yep.
All
correct.
right. When did you obtain that certification?
2015, I believe.
Okay. Are you required to do any sort of a continuing education to maintain that certificate?
Yep, we are. I was actually recertified in January, I believe.
All right. And as part of that certification in your position, are there any sorts of best practices that the office requires or obligates you to follow?
No, we just need to make sure that we maintain the amount of continued education credits per year that we need to keep the license active.
All right. Surely it teaches you and gives you some idea of how to do your job, correct?
Yep.
All right. And so based on your training, when you're advised that the violation may have taken place, what does that training tell you you should do?
We need to basically notify the violator that the violation is taking place. And then tell them to stop work.
So your training then, you're testifying, doesn't provide you any sort of instruction or guidance on how to determine whether or not a violation is actually taking place?
Well, yeah, we must use the ordinance to determine that.
All right, and the ordinance tells you what is legal and what is not legal, correct?
Yep.
Okay, but what does your training tell you, or how does it instruct you to determine whether or not that law or ordinance has been followed or not?
I guess I don't know how to answer that question, Greg.
Okay, so I'm just trying to clarify here that through your code enforcement officer training, you can't speak to any specific protocol that you learned as it relates to establishing whether a violation took place or not.
Yeah, there's a CEO handbook that the state issues.
And what does it say as it relates to establishing whether a violation is taking place or not?
I don't know that off the top of my head.
Okay. Did you review it before you went out and saw this property?
We often will review that when we are looking for different, procedures and rules.
Did you do it before you went out and looked at this property?
When specifically?
Well, I guess you indicated you went out on October 26th, 2021, based on some photos and reports that you'd received. Did you review your code enforcement handbook as it related how to establish whether a violation had taken place?
I did not review the CEO handbook on October 26th, no, 2021.
And in fact, you testified that when you went out to the property on October 26th, you brought no equipment with you whatsoever.
That's not true now.
That's not what you testified to?
That's not what I testified to, no.
Okay, well then clarify then. What did you bring with you when you went out to the site?
I had a cell phone.
Okay.
Yeah, that's
all right. So
camera, notepad,
equipment, and the extent of your equipment was you brought your cell phone with you. That's what you're testifying to.
Yeah, that's what I had in my pocket. But of course, we do keep a toolbox with tape measure, pop level. We keep all of this stuff in the car. Of course, we have all that stuff with us.
Okay.
Notepad right on the phone, camera right on the phone, measurement tool right on the phone.
Okay. So you brought all of that with you?
Yeah.
Okay. How many times have you been out to the property?
3.
Have you ever asked for permission to visit the property and been denied?
No.
How far is it from the office, just roughly?
About 20, 25 minutes.
Okay. And so you've been out there 3 times. At no point have you ever been told you couldn't visit the property.
Yep.
It's in close proximity to your place of work.
Yep.
You bring tools with you when you go.
Yep.
And yet, in all of those visits and in all of these processes, you never once took a single measurement, did you?
Of course we did. Have you not been listening? I mean, we've taken measurements.
Using your cell phone.
We've taken all sorts of different measurements. And
Using
yes, they've been on a cell phone, not just a cell phone, Greg.
Did you at any point pull out the tools that were in your toolbox?
Yes.
Okay. So when you were asked earlier what kind of measurements you took, and you did not indicate that you used a tape measure or a level or any other tools, that was not true?
I guess I don't see how that's relevant.
Well, I'm trying to determine how, in fact, you came up with the measurements that you came up with.
which I've already told you and the board and Leah.
So exclusively then using your cell phone.
No,
What other methods did you use?
we use Google Earth measurement as well.
Okay, Google Earth. In your code enforcement officer certification class and continuing education that you take, does it discuss the use of this iPhone app to measure distances?
No,
Is there any training program related to that app?
no,
Okay. In your code enforcement certification course, did it discuss using Google Earth to establish measurements to determine
No.
if a violation is it? No. Okay. Are there any training courses related to it?
yes,
To Google Earth?
yes,
Have you been certified in a Google Earth training course?
I've not.
Okay. Are you aware of any studies or evaluations that determine the accuracy of these programs?
Yeah.
Okay. Can you please clarify or expound upon those?
If you want to give me a few minutes to pull it up, I can.
All right. So currently you have not. Is that correct?
I'd not off the top of my head, no.
Okay. And in fact, you indicated that you had run a personal test related to this iPhone app. Is that correct?
Yes,
That in the past you would run a tape measure and then walked it to establish whether or not the distance was the same.
yes,
And you found that it was the same
more accurate than
to an
tape.
extent,
Yeah.
correct?
Yes, because you understand horizontal measurement, correct?
Right. So
Right.
there was a difference in the length that the Google or that the iPhone app told you and what your tape measure told you. Is that correct?
Right, because the tape measure is not completely level, correct?
Okay. So do you think there's any risk in relying exclusively on your iPhone app and Google Earth to make these measurements and determine whether or not a violation has taken place?
Absolutely not.
None whatsoever.
No, absolutely not. No,
These are records that you can rely on or measurements that you can rely on.
absolutely. Yep.
Okay. And you think it's fair then to say that online databases like this are accurate and correct?
Yeah.
Okay. So
I
I'd
have,
like
I
to,
have no issues with confidence when it comes to the measurements that we've taken on site.
Sure. So if I can, and I don't know how to share the screen, I guess I'd ask real quick just to have permission to do that.
Greg, yes, you have permission. I'm going to ask that we take like a 2-minute break. I need to step away briefly and come right back. I apologize for this, but gotta step away. We all good with taking a 2-minute break?
I'd like to finish this line of questioning before
I would love to allow that for you, but I got to step away for a few minutes and I'll be right back. Okay, thank you for your patience, and I apologize for the interruption. Attorney Ron, please continue.
So where we last left off, I just asked Alex about his belief and trust in these online databases and systems. And I'd asked if you would please allow me to share my screen.
Yeah, from my perspective, please go ahead.
Well, I got to do it. I don't know if I can. Let's see here. Okay. All right. So we'll just go ahead and take this exhibit F. This comes from your notice of violation. It's one of the attachments, correct?
Yes.
All right. And you've been asked a lot about these clouds that you drew in on this picture, but I want to specifically draw your attention to the white lines that are here. Those indicate property lines, correct?
That's the tax map overlay. Yep.
And you indicated that those are wrong, did you not?
Incorrect. Yep.
Yeah. So this is an online system that taxpayers, in fact, use to establish ostensibly their property lines, and you've used it as an exhibit here, knowing that the property boundaries it indicates are wrong. Is that correct?
It's a tax map overlay. I'm sure you understand tax maps are often incorrect. The tax map and the property lines don't have anything to do with the exhibit.
Well, they're here for some reason, correct?
Yeah, because I have the KMZ filed and installed on my Google Earth so I can find properties easier. It has nothing to do with 25 by 60 foot canopy opening.
Well, I'm not asking about that. And so you indicated that
Well,
this overlap.
You're asking why it's part of the exhibit. I'm telling you why it's part of the exhibit.
All right, and you just indicated that these white lines and this overlay, in fact, are part of Google Earth, correct?
They are part of Google Earth, but they're tax map lines. They're tax map lines, just like we have the parcel maps. What would I have done to show this violation? I could have drawn this on a tax map, not use the image overlay.
Okay. What could you have done to demonstrate and show this violation? It's a good question, Alex. That is a really good question. So, all right, let's come back here. Let's look at before and after, right? These are befores and these are afters. Can you indicate in these after pictures where you used a tape measure or another physical device?
I'm not gonna carry that on because it's 10 o'clock. But listen, I'll explain. I'll answer your question. I was going to, but you interrupted. I use the tools that I have available to me to display where I found the violation and how I found the violation. I use those tools that you keep mentioning. And I feel like I did a pretty good job with displaying where they're in violation of that canopy opening.
So it's an honest statement then that at no point did you use a tape measure or another physical device to measure any distance on this property?
We had a tape measure on site.
But you did not use it?
In fact, Jeff Kalinich and Chris Hansen were on site a week after this picture was taken, and they measured everything with a tape measure.
All right, but you did not.
My assistant went for me because I was in a meeting.
All right, and her measurements are not included in your notice of violation.
Yes, they are.
All right,
how do you think we put that together? We used measurements from on site. Now, Chris has been to the property more than 3 times. He is my assistant. He went and took some of these photos.
But
I signed it.
You used an iPhone to make these measurements.
Greg, you just wasted the last 10 minutes trying to make a point that I didn't actually pull a tape measure on site. I'm telling you, my assistant pulled a tape on site with the Shoreline zoning coordinator for DEP.
Okay, so let's
drop it.
Let's look at the before and after photos here in Exhibit B. You indicated this stairway here is still present, correct?
That stairway was in this picture used as reference.
That's right. But the size of it is just an estimate based on your best guess of what a standard commercially available stairway might be, correct?
Yeah.
Your previous testimony was that you did not measure that stairway.
That's correct. We were not there. We were not able to measure the old boat ramp because your client pulled it up without getting a permit.
Sure.
Correct? Correct.
So, but you've used it, right? This good faith, best guess analysis to ascertain or establish what you think not only these measurements are across here, but also what this new ramp might be. Is that correct?
No, we pulled that right from Mike's document as we displayed earlier.
All right. So you're saying you measured this physically yourself to establish.
We have measurement, yes. I did not myself, no, but I had my assistant go do it, which is totally fine.
All right. And yet we don't have an accurate measurement of what that width is, do we?
We do. It's 16 feet.
And where do you indicate that in your notice of violation?
It's not in the notice of violation.
Okay, why is that?
It didn't need to be.
You indicated that this has been extended, and when asked for an accurate determination of how wide it's been extended, you've only given best guesses and not included any specifics in the violation. You don't think that was necessary or relevant information?
I still think it's a violation regardless.
Okay, so you think the
no one has been able to prove that wrong, I guess, at this point.
Okay. Take a look at Exhibit C here. Similarly, it sounds like at no point did you walk down to the beach and actually measure physically the distance either from the water to the stones or across from one side to the other. That's an accurate statement, correct?
Yeah, I don't see why I would need to do that.
All right, well, you've alleged that a beach has been expanded or
That's
built.
not what we alleged. That's incorrect.
That's not
what did we allege, Greg?
All right, let's take a look here. So if I'm looking at,
Because I've stated it twice tonight.
This right. Notice of violation 5, construction of a beach without a permit.
Yep.
Okay. And you have alternatively indicated that either sand may have been brought in to increase the size of that beach, or that rocks have been removed to increase the size of that beach. And yet you've just testified that you didn't think taking a measurement of that beach to establish its size.
I've said twice.
You know,
tonight.
I've been very patient here. You are, the tone you're taking with him is insulting and offensive.
I agree.
You've mischaracterized his testimony, and I object to that.
Multiple times.
My tone. I'm just trying to establish what actions he took on the property to reasonably and effectively measure these dimensions.
You've been taking his testimony and twisting it and misrepresenting what it is.
Well, I disagree.
Greg, I'm sure you do.
I've said
I'd
twice.
ask you to treat him with more respect.
I've said twice tonight. I actually literally said, like probably an hour ago, I'm not saying the beach has been made any larger. So I don't know why we're talking about the beach needing to be measured.
So you agree
no
with
sense, and it's wasting everyone's time, and it's disrespectful. So let's move on.
All right. Let's see here. Similarly, we're going to take a look. All right. So I'm curious here. What is the square footage of these clouds that you brought?
If you guys want to take another 5-minute break, I can give you the exact number. I don't have that prepared right now.
You have not done that math previously.
I can tell you what 25 by 60 is.
All right, but is that a rectangle?
That's 1,500 square feet. So that cloud is larger than 25 by 60. So I'm going to tell you this is probably around 1,700 square feet. Now that's not an exact number, but it's much larger than 250 square feet. Therefore, that's a violation.
That's an estimate, right? Again, you didn't actually measure that section. We're just giving.
Greg, if we can take a 5-minute break, I will get that number for you.
All right. So I think you testified as it related to notice of violation 1. When you were asked about the cubic yards and how much had actually been brought in or not, that in trying to establish how much that was, you didn't actually pick up or look under any of the riprap to establish how deep it was. Is that correct?
No.
Okay.
Um,
And when it related to topsoil and mulch or other material put in there, the form of measurement you took was to kick it with your foot. That was what your testimony was? Is that correct?
yes, we could take the length and the width and multiply that by a centimeter, and it would still exceed 10 cubic yards.
How many inches is a centimeter?
I don't know off the top of my head. I can look it up if you'd like.
Well, you just suggested that that was sufficient to cover it. I didn't know if maybe you'd done that math. All right.
It's very easy to find this information. It's all out there.
The high water mark, I think you indicated that generally you obtain a survey to establish what that high water mark is. Is that correct?
That's what the property owner did. Yep.
All right. So you relied on the property owner's survey to establish that?
No. As I said earlier, we relied on the watermark the day of when it came to determining where the high water mark was.
All right. But you acknowledge that that changes day to day.
Yeah.
The lake, it doesn't have like tides, right?
Correct. Yep.
But the water level does change depending on the time of year.
Yes.
Okay. Why does it change?
It's regulated by a dam.
All right. And so water is let in or let out of the lake.
Yes.
All right. And there's actually a website that you can go to determine what the level is. Is that correct?
That's correct.
All right. But your testimony here is that you did not take that step.
Correct. Are you aware of our definition for normal high water line?
I'm just asking what steps you took to make those measurements.
Right. But to answer your question, I'm asking, do you know what our definition for normal high water line is?
Yeah.
No, you probably have to look it up, right? Yeah, that's what I usually do all day long too. So the definition for normal high water line says the line which is apparent from visible markings, changes in the character of soils due to prolonged action of the water or changes in vegetation, and which distinguishes between predominantly aquatic and predominantly terrestrial land. Areas contiguous with rivers and great ponds that support non-forested wetland vegetation and hydric soils, and that are at the same or lower elevation as the water level of the river or great pond during the period of normal high water are considered part of the river or great pond, period. There's nothing in there about elevation marks or elevation points or dam regulation. It's based on those changes visible. It doesn't say anything about requiring a survey to come up with that number or that height.
And you took no measurement of it when you were on the property. It was based solely on your visual perception.
How would I measure that other than a photograph? I am not a surveyor. I don't have survey equipment with me. How would I measure the normal high water mark with something other than a photo?
You were physically on the property. Yes.
And
you brought a toolkit with you. Yes.
And
is that true?
We've already determined that, so let's not waste everyone's time. Please move on.
It had a tape measure at least in it, correct?
Yes.
And you didn't use any of those tools to try to establish that, correct?
Mr. Chair,
Establish what?
this is getting a little ridiculous. How can I determine
I have
normal
to,
high water mark with a tape measure for crying out loud? That's ridiculous.
Right, can you move on from this? I think that we have gotten clear testimony. It's
embarrassing.
We made a determination of the normal high water line, so I'm not sure what the line of questioning here is really at.
All right. So I'm moving on to point or notice of violation number 8 and 9 here collectively. I'm hoping you can explain to me what you believe section 15 subsection C 12 requires as it relates to work on shoreline.
All right, hold on. So 15.
Yeah, just notice 8 and 9, the quoted text there.
Yep. All right, vegetation may be removed in excess of the standards in section 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. construction equipment must access the shoreline by barge when feasible as determined by the planning board. That section?
That's it.
Okay.
Continue.
When necessary, the removal of trees and other vegetation to allow for construction equipment access to the stabilization site via land must be limited to no more than 12 feet in width. When the stabilization project is complete, the construction equipment access, when the stabilization project is complete, the construction equipment access way must be restored.
So you allege it's a violation to complete this work from the land and not a barge absent a permit.
Yes.
What in this provision indicates that the work has to be completed and done from a barge?
It needs to be, the planning board must make that determination. And the work was done from land without approval from the planning board, without that permission.
I'm looking for clarification here, and I mean, I'm not going to lie. Like, this verbiage is new to me, so maybe I'm missing something. But what I see in a couple instances here is the word access, right? And not only access, but it indicates that if access needs to be made from the land, that the width of the path to access the work zone cannot be any wider than 12 feet. And when the project is completed, the access way must be restored. And so this seems to me to be a provision related to how you get the equipment there, not how the work is actually done. And I'm looking for some clarification from you as to why you believe whether or not the work is done when when the equipment is on a barge as opposed to being on land.
That determination must be made by the planning board. Unfortunately, your client didn't apply for a permit by the planning board. So I really can't give you much more clarification on that.
So can you, so you agree then that at least you can't clearly point out to me where it says in this provision or this ordinance that work needs to be completed from a barge surface?
Say that again, sorry.
Sure. So I'm still just trying to see within this ordinance where it indicates that work would need to be done from a barge and how this doesn't simply apply to how you get your equipment to the job site.
Construction equipment must access the shoreline by barge when feasible as determined by the planning board. That's the violation.
And so you take that to mean that unless the permit authorizes otherwise, the construction equipment would need to remain on a barge in the water and not actually on the land.
That's up for the planning board to determine through their approval process.
All right. Okay.
I wouldn't make that call. That would be, the planning board would review that under their application, for a site plan.
Regarding the tree removal, you've done a lot of work with, or you've been involved in at least in a number of jobs with Rob Durant and Durant Excavating and Big Lake Marine, correct?
Yep.
He doesn't hold himself out as an arborist, does he?
He does cut trees.
Okay.
Yeah. He's not an arborist, but he does cut trees.
All right. You generally understand that this property and the adjacent property to which we previously had hearings was considered one large project, correct? It went on to multiple property sites, but it appeared to be essentially the same job, correct?
Yeah.
Okay. And you know that Q Team did the work on the adjacent property, correct?
Yep.
All right. Is there a reason, or can you explain the basis why you didn't cite Q Team for cutting these trees and doing the work on this property?
I had a meeting with Q Team about a week after we did the site visit, and they told us at that point that they did the work on Fernwood. They admitted to it. They sent us a letter confirming it, and they also stated that they weren't taking any ownership of the work that was done on 28 Whitetail, and that work was done by the contractor who did the site stabilization work.
All right. And so they had their tree cutting equipment out there, correct?
I don't know. I never saw it.
Never saw it. All right. But they did tell you that they did the work on the adjacent property.
That's what they said. Yeah.
Right. and solely based on their testimony and indications to you, you chose to believe that you didn't do the tree cutting on this property.
No one's told me otherwise.
All right. Well, we filed a notice of appeal that's indicated Big Lake Marine didn't do the work.
Did it?
Okay.
No. Is that what you're saying? Big Lake Marine didn't do the work?
Yes, that's what we've alleged. That's what our appeal indicates, is that they did not do the work as it related to the tree cut.
Okay.
Just one final question. When you went out there on October 26th, you communicated orally to Rob Durant and the other people there that they should stop work on the project. Is that correct?
Yeah.
All right. At any point, did you actually issue a written stop work order?
Not written in the heading, but we basically, sorry, I'm getting tired. I'm very popular tonight, so I'm getting a little tired. We gave him a verbal stop work order, and the communication that we gave him at that point was, we're going to be sending you a notice of violation. And the intent through that was they're one and the same.
Is that standard procedure for the town of Raymond?
No, I wouldn't say it's standard procedure. We do it differently. Sometimes it's written a little differently, but just for this particular situation, we met with him on site, and he told us he was done. He wasn't doing any more work. So I trusted that. I have no reason not to trust that. And as far as I know, he hasn't been back to do any work. So I think we're good.
All right. And in fact, I think you testified that based on your observations and site visits, no additional work was committed or completed on the property after that October 26th date.
Correct.
All right. Apologies for getting you riled, Alex. I know it's been a late night, and I thank you very much for answering my questions.
Yep.
So Attorney Wagner.
Yes, I would turn it over to Attorney Wyckoff if he has any re-examination.
I do. Thank you. First, Alex, there's some testimony or some questions from Attorney Rachin about the riprap along the shoreline at the Whitetail property. And my question for you is, if riprap was only added and wasn't removed or replaced, does that change the situation with any the existence of any violations here?
Mr. Chairman, before the answer that question, I just wanted to ask Attorney Wagner perhaps to weigh in on a procedural issue. Again, the hour is late, and I know we're all tired, but my recollection is that after I did my examination of the code enforcement officer, Attorney Wyckoff had an opportunity to redirect.
I did not.
Okay, then I'll stop and I will mute myself.
I don't know that you answered the question I asked, so I think let me just ask it again. So there are some questions for you about riprap, and my question for you is, if riprap, let's see if I can say it without tripping over my tongue here. If riprap was only added and not removed or replaced, would that change whether any of these violations have occurred or not?
No.
I'm going to go to Exhibit F. I'm going to share my screen. Okay. Exhibit F here, it has the bubbles that show the area of canopy that has been removed. Now, how do you know that greater than 250 square feet of canopy have been opened? Could you just describe how you know that?
Yeah, it's very clear if you stand on site and you look up, especially on the right-hand bubble where you see the deck that exists on site that wasn't on a subdivision plan in 2007. You can see that that entire area was once canopy. That's now all open, basically back to the deck. All of that. So anything that's there in that particular bubble is now gone. That adds up to greater than 250 square feet. And same thing on the other side, we established a 25-foot distance, and it's actually greater than 60 feet on that side, but we're calling it 60 to make it easier. It exceeds by 1,000 square feet, probably.
Okay. I mean, what's 25 times 60? Do you know what that is?
I don't do public math.
Okay.
By rule,
I'll represent to you. I'll represent to you. It's
1,500.
1,500. I'll represent it's 1,500 square feet.
Yeah.
That more than 250 square feet?
Yeah, it is. Quite a
By
bit.
by a factor of 6?
Yeah.
Okay. So in other words, you were satisfied that there was far more than 250 feet of canopy opened up.
Yeah.
Okay. There is a question from Attorney Braun relating to cutting of trees at Whitetail Lane, and it's really an issue relating to the Big Lake Marine appeal, but I just want to be clear about it because he raised and he asked the questions now, and I want to get it clearly understand from you about that. So you understood that management controls had how many contractors working in this project?
2.
Who are those?
Rob Durant, Big Lake Marine, Rob Durant Construction, whatever it is, and Q Team.
And you met with someone from Q Team?
Yes.
And that was about the violations that occurred?
Yes.
And what did you understand from that meeting with Q Team?
Yeah, they came in and met with Chris and I want to say less than a week after October 26th. And they told us that there was an oversight. They usually obtain all the permits for their projects, but in this particular situation, they didn't ensure that a permit had been pulled. They apologized. They admitted to doing the work on 18 Fernwood. And
Okay.
we asked Robert Fogg, who did the work on 28 Whitetail, and he just kind of said, the contractor.
And did they also talk to you about whether they cut small vegetation or not?
They did, and because that was something that was originally referenced, and they, his answer to us was, I think word for word was, we're in the tree removal business. Those aren't trees. They're not going to waste their time with that, essentially.
Okay. Now, they sent you a letter too, right?
Mm-hmm.
And do you recall what that letter said?
Yeah.
What did it say?
They essentially said exactly what they said in the meeting with us, and that they were, responsible for a certain amount of the work that had taken place. And it was an error that took place, and they were under the impression that a permit had been pulled.
And your understanding from them is that they didn't do the tree removal at Whitetail, and that Big Lake Marine did.
Yes.
And did you find them credible in them describing that to you?
Yeah. I mean,
why did you find them to be credible?
I mean, they owned up to the work that they did do without permits. I guess my impression of that would be, why would you admit to one but not the other? It seems a little odd. And I have no reason not to believe, what they were telling us. They've always been very good about following the rules and doing what they need to do. So I did believe that it was an oversight.
Okay. I don't have any other questions. Thank you.
Attorney Wyckoff, I guess do you have any summary arguments before I turn it over to Attorney Rakin? I don't recall if you had that opportunity.
No, I haven't had the opportunity. And I guess I would just say you know, we've gone through in fairly gory detail about the existence of these violations. And Alex has described how the facts underlying these violations, and a number of arguments have been raised by management controls as to why those violations haven't occurred or why those violations are duplicative of each other. And for all of the reasoning employed by the ZBA in connection with the Fernwood violations applied to the facts here, those arguments about why the violations are duplicative and shouldn't exist should be rejected, and the ZBA should uphold the violations as Alex Roy has described here today. Thank you.
Okay. And Greg, or Attorney Braun, did you have any summary arguments? Okay. So then I would give the last say to.
I do that. It appears to me that, and again, argument, you know, what I ascertained from this is that very little in the way of documentation or explanation in the form of measurements or clear explanation has been provided. Rather, the board is just being asked or it's being suggested that the thing speaks for itself. Not only in the extent or measurements in dimensions of the project and the property, but also as it relates to some of the wording in these violations. You know, we want to explain away all existing vegetation less than a certain height as just, you know, we could have done it better, but we didn't. You know, access compared to completion as it relates to violations number 8 and 9, and there not being a distinction. And to those points, I would argue, especially in a case like this, where publicly the town has indicated that this is the most egregious thing they've ever seen, and you know, potentially they're seeking millions of dollars in fines, that a higher level of proof and explanation should be required.
Okay. Attorney Rachel.
Yeah, so I will just summarize and basically talk about the themes we've been talking about all along, but understanding that, again, Whitetail is not Fernwood, it's its own property and it should be treated and viewed as such. But, you know, the first argument, of course, is that the wrong person has been held responsible here or is being thought to be held responsible. And this notion that, you know, somehow management controls is an agent, or I should say the other way around, that Durant or Big Lake Marine is an agent of management controls, that's just legally incorrect. An independent contractor is just that. They're independent and they are not in an agency relationship. So that's incorrect. The second theme that we've been talking about here is that heavy duplication. And I do need, I know it's late, but I do need to talk about what that duplication is and talk about how these things should be consolidated. When I say these things, I mean the violation. So as you know, the notice of violation actually alleges 12 separate violations. Many, if not most, are duplicative. We've argued before, and I'll renew this argument, that had they sought and received a shoreline stabilization permit under section 15C12 of the ordinance, it would have covered many of the other purportedly single violations, such as earth moving and filling and vegetation and tree removal. All of those things would have been subsumed. And so we would respectfully request that all of those, meaning violations 1 and 2 relating to earth moving and filling, violation 4 regarding expansion of a shoreline, violation 5 regarding a purported beach construction, 6 and 7, which deal with removal of vegetation, 9, use of a barge, and 10 through 12 are tree removal, that those all be stricken entirely because they are subsumed under violation number 8. If, and that is our ask. Now, if the board decides that they are not going to strike, at least it's really important to understand the need for this consolidation, because so many of these purportedly single violations are in fact one and the same. They're based on the same activity and often based on exactly the same provision under the ordinance. And I'll identify those quickly. Violations number 1 and 2 basically should be consolidated because on the one hand, violation 1 simply states that it's earth moving and filling in excess of 10 cubic yards. We know that that activity in and of itself is not a violation unless and until a person didn't get a permit. And that is what they allege in violation number 2. And so those are exactly the same violation and they should be consolidated accordingly. With respect to violation number 4, which alleges an expansion of the shoreline without a permit, and number 8, which is an expansion of shoreline with riprap, this is the same thing, again, that would have been subsumed under a shoreline stabilization permit. So 4 and 8 should be consolidated. Looking at violation number 3, which is the expansion of the boat launch, and violation 4, which is expanding the shoreline, I think it's important, and the testimony of the CEO is actually very revelatory in this manner, or in this way, that both of the violations, they cite the exact same provision under the ordinance. That would be 1417 sub B. And I think it's clear that the code enforcement officer said that the expansion of the shoreline was limited to that area of where the boat launch was expanded. So again, even according to the code enforcement officer's own testimony, same activity, and therefore those violations should clearly be consolidated. Again, just like violations number 1 and 2, violations number 6 and 7 talk about an activity which is actually permitted here, removal of vegetation, and then slaps them with a second violation for removal of that vegetation without a permit. Again, same activity should be consolidated. Numbers 8, violations number 8 and number 9, 8 being the unpermitted shoreline stabilization without a permit, and number 9 being unpermitted stabilization without a barge. Again, those are both activities relating to unpermitted shoreline stabilization. They cite exactly the same provision of the ordinance and they should be consolidated. And again, with respect to numbers 10, 11, and 12, all relate to vegetation and tree removal, same activity, should not be 3 separate and distinct violations. So that is with respect to our arguments around duplication. Let me talk to you about the last round, and that is the fact that as alleged in the notice of violation, they simply, we know the purpose of a notice of violation is to give notice of what the violation is. And here, it's been a long night, but the testimony and it's our respectful submission that the evidence just simply does not support a conclusion that many of these alleged violations occurred. And I'll be as quick as I can. But with respect to violations number 1 and 2, again, that's the earth moving and filling of in excess of 10 cubic yards. The evidence does not establish that there was actually greater than 10 cubic yards. As there was a lot of testimony and a lot of questions about that, and that there was no empirical specific measurements in that regard, and therefore it was not established. With respect to violation number 3, the boat launch has been expanded again. The pictures that were shown you were from a great distance. They were fuzzy. There was no scale associated, and it was very difficult for them to establish that there was, in fact, that area of the existing boat launch. And let's be clear, it was existing. No one's disputing that it was expanded beyond the scope of where it was originally. With respect to violation number 4, that being the alleged expansion or enlargement of the shoreline, first and foremost, there's some doubt as to whether or not this was a use or a structure as defined in the ordinance. But even if it were, the code officer did not provide measurements. Again, like I said, he's saying that the expansion of the shoreline was exactly the same thing as the expansion of the boat launch. And so all of our arguments in that regard apply, that the evidence just does not support a conclusion that there was in fact an expansion there. Another piece of that is that it's important to understand that any addition of riprap, I think we heard the testimony of the code enforcement officer to say he didn't know and he couldn't establish that there was a removal or I think he said a removal of the existing riprap. Rather, it was just something that was put on top. And as stated earlier, that it's our submission that under I believe it's section 12 of the ordinance, that repair and maintenance of existing non-conforming structures or uses is permissible without a permit. With respect to violation number 5, I think it's clear the evidence absolutely does not support a conclusion that the beach was constructed. Those were the words used, constructed. It clearly already exists. And I think, as the chair very eloquently stated, how can you construct something that's already there? Even the code enforcement officers before photos show beach chairs. Clearly that was being used as a beach. And to the extent that rocks were allegedly removed, again, the evidence doesn't say, even the code officer himself acknowledged that the beaches are not static, the sand moves in, moves out. And so it just has not been established that a beach has been constructed. And to the extent that improvements are somehow a construction, again, the sand can move in, sand can move out. Code enforcement officer himself acknowledged that. With respect to violation 6 and 7, that again is the removal of vegetation of less than 3 feet in height without a permit. This is just another example of the town's overreach. As we highlighted, it talks about all existing vegetation. The evidence clearly shows that that is not the case. All existing vegetation has not been removed. With respect to violation number 8, which is no permit for the stabilization project. The permit by rule covers actually a certain portion of that stabilization project. Also, as I noted before, that this was in the nature of maintenance, adding, again, the evidence is clear that this shoreline was very much characterized by extensive riprapping already. And so just adding some additional is in the nature of repair and maintenance, not an entirely new project. Also, I think the code enforcement officer testified, and I may not have his exact words, but where the water is where the high water level is. The normal high water mark is where the water is. But there's no evidence that there was stabilization below the normal high water mark. And if we look at the ordinance in the section that he is citing, it is talking about work below the high water mark. And so there's no evidence to establish that. Getting there. Violation number 9 is that was the stabilization without a barge. Again, we dispute that it was feasible to conduct this work, given the fact that, the time of year, the water was low. There's no evidence to suggest that a barge could, in fact, do that work and be able to reach the areas given the water levels. And finally, with respect to violations 10 through 12, this is with respect to tree removal and the point system and doing the work without a permit. The evidence supports the conclusion that the trees at issue here were largely hazard trees. We have evidence in the record where Mr. Gosselin indicated that. We also have evidence that the code enforcement officer himself says that the folks from Q team are trustworthy. There's no reason to not believe that what they are saying is truthful. You have pictures showing clearly that one of the trees that was right next to the stairway, which was identified as a tree that was removed unlawfully. Clearly, this is a hazard tree, just like all of the other ones that were removed, or at least the majority of them. And again, ultimately, these 3 violations all involve the same activity, removal of vegetation and trees, and therefore should be consolidated because they are not in truth 3 separate violations. And that is it. I thank you for your time. And if you have any questions of me, I'm happy to answer them.
So, Attorney Wagner, I have 3 yes/no questions for two of the attorneys. And then my thought is that given the time that we work to potentially table these until tomorrow evening, that match your thought process?
Yes.
Okay, so my 3 yes nos, Attorney Wyckoff, there was a document that came up during one of the screen shares regarding the boat launch, and a testimony by someone indicating that the boat launch had been expanded to 16 feet. Can you, we have
Yes.
so much talk. Can you just simply provide that document to the board for tomorrow's meeting? To have
Yeah.
so much documentation here, I would just like to just have that single document available.
Okay. You have it. It's a 249-page document that was provided by Attorney Rachin today, and it's on page 71 of the PDF.
Print that out, David.
Attorney Braun, 2 yes, no questions. During your questions for Alex, you had some concerns over the tools that he was using, Google Earth, as well as the tool on his phone. Again, just simply a yes, no answer. Question, do you have any evidence that the tools that Alex used are inadequate for what he was trying to accomplish?
So a little longer than a yes or a no.
No,
Yes,
all I want is a yes.
I
no.
do.
Okay, can you provide that?
Sure. In fact, you already have it in its Exhibit F that Alex included with his notice of violation. He himself indicated that document and the overlying lines that were included with it to ascertain or establish tax maps were part of Google Map and Google Earth. And he also indicated that they were wrong and incorrect.
Okay, is that the only evidence you have? Yes or no?
Yes.
Thank you. And finally, do you have any evidence that Q Team was contracted for use at 28 Whitetail?
No.
Okay. All right, that's it for my questions. I will ask the board, do you have any last minute questions for these, for our attorneys?
I don't have any.
Okay. I would like to, unless anybody objects, I would like to make a motion that we table. Yeah, Attorney Wyckoff.
I have a procedural question.
Yeah,
I don't think the public has had an opportunity.
This is true.
I think Attorney Wyckoff is correct. So could we just go through the motions of asking if there's any members of the public who wish to?
Yes, I can do that. So I will open up the public hearing portion to this. Do we have any members of the public that would like to speak in favor of this application? Do we have any members of the public who would like to speak in opposition to this application? And then finally, do we have any members of the public who would like to just speak from a neutral perspective on this? Seeing and hearing none, I will go ahead and close out the public comment portion of this.
So before, I think you're in the process of motion to table, though. I guess I would suggest first we motion to close the public hearing and the record, and then take up a motion to table deliberations until tomorrow.
So I will motion that we close the public hearing and wrap up the testimony. Something along those lines. I'm so tired too. Thank you.
Close the public hearing and close the record.
Close the public hearing, close the record. Second.
I'll second that.
Thank you. Any further discussion by our board? All those in favor of doing so, David March, yes.
Yeah. Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lockwood, yes.
Step is, I'd like to make a motion to table our 2 appeals with regards to 28 Whitetail until our next meeting.
I'll second that.
Further discussion? All those in favor of tabling, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lee Lockwood, yes.
So we get to have fun tomorrow night, starting at 6 o'clock.
Just one question for you. Do you have any other business besides the parties that are here today?
We have another administrative appeal.
Do you have any sense of how involved that one is? I just know, I think that party got pushed away last meeting because of this group here, and I just want to be respectful to their time. And if it's a short, if we think it's short, I might suggest trying to get them in first so that they don't have to sit through what I suspect will be another long night.
Yeah, understood. My sense is short, but and I get a couple other board members to chime in on that one. This is,
My thought, without really knowing how long it would be, was to deliberate on this first and then do that before we go into the other 2, just because the continuity makes it a little bit easier. That would be my only thought.
Tom, Pete, Fred.
That's reasonable.
Again, I don't think the next one will take a lot of time, and I'm okay with deliberating first.
So I don't know. I mean, it looks like it could be shorter, but I guess you just never know. So I kind of am aligned with Greg Dean in that we just sort of continue on with what we started tonight. Unfortunately, they're just in the order that we come through them. So that's my inclination anyways. Okay. So I'll make a motion to adjourn for this evening. 1 second. All those in favor, David Murch, yes.
Greg Dean, yes.
Fred Miller, yes.
Lee Lockwood, yes.
I can't hear you.
Sorry, David.
But...
Go ahead. I got distracted for a second.
Okay, we're adjourning. You good for that?
Thank you so much.
Okay, all right. Thank you, everyone. We will do this again tomorrow night.
Have a good night, everyone.
Good night.
Thank you for your time.
Of course. Thank you.
Okay, welcome to the Town of Raymond Special Town Meeting. Greetings. In the name of the state of Maine, I am hereby required to notify and warn the inhabitants of the Town of Raymond qualified by law to vote in town affairs to meet at the broadcast studio at 423 Webb's Mills Road in said town on Tuesday, August 9th, 2022 at 6 p.m., then and there to act on Articles 1 and 2 set out below. Article 1, to elect a moderator to preside at said meeting. I'll entertain a motion.
I'll move Joe Bruno for moderator. Second.
Okay, so for that, You need to vote. Would anyone like to? I only require 3 ballots.
Yeah.
You guys all set? Joe Bruno. Okay. Thank you.
Which friend him?
Huh?
Joe Bruno.
Need help spelling that? How do you spell that?
But you don't.
And it is unanimous, sir?
Okay, I need a piece of one.
Yes. Hope I can remember.
You want your pencil back?
You can say I will or I do. I, Joe Bruno, do solemnly swear that I will support the Constitution of the United States and of this state as long as I shall continue a citizen thereof.
I will.
I, Joe Bruno, do swear that I will perform to the best of my abilities the duties incumbent on me as moderator for the special town meeting on August 9th, 2022. So help me God.
I do. Okay.
All right, welcome everyone. We have a special town meeting and it has one item on it. So do you have the?
Oh, yes. It is in the beginning of your package.
Yeah. All right. Thank you. We're here to vote on or discuss and vote on Article 2 to see if the town will vote to appropriate from undesignated fund balance the surplus the sum of $23,200 to help fund the moving and restoration of the historic Raymond Town Watkins Blacksmith Shop circa 1820 to the Raymond Casco Historical Society campus. The Select Board recommends Article 2. Budget Finance Committee recommends Article 2.
Move article, or recommend Article 2.
Do I have a second?
Second.
Any discussion? Step right up to the microphone.
Can I use this one?
Nope. Step up to the microphone.
Make it hard, Joe.
So.
Hi, is this on? Yeah. My name's Alan Stone, and I live up on Spiller Hill Road in Raymond, and I just want to make a short statement in support. In 1971, the Maine State Legislature stated that it is the policy of the state to preserve the architecture, historic, and environmental heritage of the people of the state, and to develop and promote the cultural, educational, and economic benefits of these resources. Many states and municipalities throughout the United States have addressed similar issues, and they've said similar things. I'm just going to kind of quote from one of them. The history of a community contributes to its personality. Preserving the history of a place through its significant historic resources gives a community its unique character. Historic preservation provides a link to the roots of the community and its people. Overall, historic preservation adds to the quality of life, making for a more livable community. Historic preservation is beneficial to the community in the following ways. Culturally, a community is richer for having the tangible presence of past eras and historic styles. Economically, a community benefits when the community is attractive to visitors seeking heritage tourism opportunities. Socially, a community benefits when citizens take pride in its history and mutual concern for the protection of the historic building fabric. Environmentally, a community benefits when historic buildings are restored or rehabilitated rather than demolished and disposed of in the community landfill. Educationally, a community benefits through teaching local heritage and the understanding of the past and the resultant cultural respect by its citizens. Historic preservation is an important investment in Raymond's present and future. Thank you.
Okay, thank you. Anybody else?
Step right up.
Marilyn Westcott, 172 AI Road. I just want to ask a question. It's my understanding the town of Casco has committed $25,000 to this project. Why are we not matching it?
We are matching it. There's money in the general budget that would bring it to the 25.
Oh, okay, so the
So that we already
difference.
had an appropriation. So basically, the request came in too late for the major fund that we're talking about tonight. So we did have some monies already in the budget, though.
Okay, thank you.
Yeah. 25, if you pass it, yeah.
Anybody else? Seeing no one else, I'll ask for a vote. All those in favor, raise your pink card. All those opposed? The motion passes. Do I have a motion to adjourn? So moved. We are up.
Can I just thank everyone for turning out tonight? It's not been an easy couple of weeks for everybody. We get a little cool weather. I think you'd rather be sitting on your decks or in your backyard, but the Historical Society thanks you for this support. You don't know what this does for us, to know that people really care. Thank you so much. And come and see the blacksmith shop.
Great, thank you. So before everybody leaves, we are having a discussion later on the taxing program for freezing your property taxes through the state. If you are 65 and over, hopefully you can get an application at the town hall, or you can go online and get one. You need to submit it by September 1st. Now that December 1st. But there are some qualifications you need to meet. You have to be a permanent resident and have had the homestead exemption for 10 years. And if you meet those qualifications, your property taxes are frozen. So if you don't know about the program, look it up, go to the town office and speak to any of the clerks and they'll help you with an application. Yes.
Maine Public Broadcasting did a really excellent program this morning from 11 to noon. They were repeating it this afternoon and they're going to repeat it once more. And it was very, very interesting and informative for anybody who listens to public radio.
Yep. Right. And our contract assessor tonight will be making a presentation.
Yeah,
and you can watch it on rebroadcast.
Yeah, if you want to tune in later, we're going to have a discussion on it. We don't start our next meeting till 6:30, so it'll probably be on around 7:30.
Yeah, that's the live, and then it's because it'll be archived on the website, YouTube, so it's there.
There are no income guidelines. Anybody qualifies as long as you're 65 and over. And I'm looking around the room. Yeah, I know Sam qualifies. So, all right. Thank you, everyone. Good evening. You're here at the Selectmen meeting for August 9th. 2022. We have a fairly long agenda, so we're going to get started. Can I have a motion to approve the minutes of July 12th? So moved. Second. Moved and seconded. Any discussion? All those in favor? Unanimous with one absentee. We now have a public hearing on Cafe Sebago liquor license renewal. So, is it actually a public hearing?
Yes, it is.
It is, yeah. Okay. All right. So I'm going to open up the public hearing on the renewal of the liquor license for Cafe Sebago. Do I have any comments from the public? Okay. I'll turn it over to the select board. Any questions?
Joe, that
Yes.
letter that came in, can that be read and put into, I don't have it on hand though? And it would be a letter concerning the garbage out back?
That's the question I was going to ask. If I can find it, I'll read it into the record.
I know it was sent, hold on, sorry, I'm trying to find it. And also regarding, is this where when we also go over the fire inspections?
Yes. Yeah.
Okay, because there's a lot of things on here, knowing that this has been put off a couple times, and there's a lot of things on here that still have to be done or have not been done.
Understood. So Wayne, we just received your inspection report tonight. Can you give us a rundown, please?
Sure thing. Was there yesterday for the inspection for this liquor license and the special amusement license. Some of the things that we found in particular was the grease hood was dirty. There was quite an accumulation of grease on the walls and ceiling area in the kitchen. Talked to the owner about the oil and grease that was in open buckets outside the dwelling instead of, not dwelling, outside the building, instead of placed in the approved container. Emergency light was not working, and that's the only emergency light in that whole building for the public to be able to see their way to exits if we lose power. And then the other item was the rear exit door. It's starting to rip out from the hinges and needs to be secured back in place so the door will operate properly. And there, the other thing was the fire alarm system. There's annual testing and maintenance that's required with a report submitted to the fire department. That has been scheduled, but the date of that testing and inspection would be the 15th of this month.
Wayne, I don't know if you said it or not, I'm sorry. What about the dance floor inspection too? Did you mention that?
Yeah, so as far as the fire department's concerned, it's kind of the same thing. But the key there is State Fire Marshal has to come in, perform their inspection, submit their report, and if everything passes with them, then they grant a license, which, you know, for us, that's kind of a condition for the approval for the amusement part of the license. That doesn't expire in closer to the end of this month. So there's still a little time for the fire marshal to come in and do that inspection for Cafe Sebago. But that's where we stand at the moment.
Joe, I found that letter if you didn't find it.
No, I actually have it in front of me. If you want to read it, go ahead.
All right, we got the letter, and it said, to whom it may concern, I am writing regarding the pending site plan for map 55, lot 004A for a patio and parking expansion. As a property abutter, it appears the expansion was begun long ago. The back of the property has already been extended onto residential property and is currently used for parking. Is there a new parking expansion plan, or is part of the parking lot going to be used for patio extension? What are the stormwater runoff ordinances? The current parking extension of residential property has been stripped of vegetation, allowing water runoff onto my property. I would like these issues addressed. I do hope when you are considering the liquor license renewal that you take into consideration what the properties that abut this one must contend with. I can only speak for myself and my tenants. So here is just a few things we deal with regularly. My back parking lot is gated, so there is no access by vehicle at night. On the portion of that lot that is separated only by a cement barrier from the bar, it is common to arrive in the morning and have to clean up broken glass and drug needles that have been left on our property. If it is windy, we get the pleasure of picking up their trash that is blown all over the neighborhood. Disgusting is an understatement, not to mention the horrible smell that comes from dumpsters that do not get dumped regularly. In closing, I do support any extra parking that is within town ordinances. I do not support the patio extension or liquor license renewal. Sincerely, Jeffrey Cox. So is Kyle here tonight? I can't see the audience.
Yeah, he's here, but we're not ready for you, Kyle.
Okay.
We're still working as a select board.
And I think also looking on the report too, one of my concerns is as a selectman, as a parent, as a citizen, is the police reports. As far as how many people are leaving there drunk and getting OUIs, getting tickets for driving. And I do know at the last time that I think we renewed Kyle's thing, it was mentioned to him, you know, we were concerned about hearing things. And Kyle said that they watch, he's a bouncer, and I may be just assuming here, but to me, a bouncer is someone that is watching someone's personalities, the way they interact, and if they are letting people leave there that drunk that they're getting picked up with OUIs, I have a really big concern.
Okay.
All right, that's just me.
Any questions for Wayne? Hey, Wayne, I have a question for you. Wayne?
Yes, I'm right here.
Okay. That grease issue.
Yep.
If I remember last May, it was still a problem back then. It was. And then it was supposed to be rectified with regular cleaning, and now you're saying it hasn't been cleaned in a year and 3 months?
No, I'm not saying that it hasn't been cleaned in a year. Well, it was actually cleaned in May. But what the conditions we found there yesterday during the inspection, it needs to be cleaned again. I know that Kyle has reached out to the contractor that does that professional service, and they're actually scheduled to come back in tomorrow morning and clean that system again. So in all fairness, you should be aware of that.
Okay, thanks, Wayne. Alex, are there any permits that have not been obtained or any zoning violations?
So there's still an open violation for this property, and that is for the parking area that was created in the back of the building without site plan approval. So Kyle is aware of that. We've had multiple discussions about that and how he can correct that, productive discussions, with what he's thinking he's going to do to try and correct the violation. It's really two different permits. One would be site plan to keep the back parking area the way it is and use it as parking and with some modifications. And the other one would be just a building permit application for the modifications outside of the building. A few years ago, there was a rear deck with some, outside storage behind the building. That area was turned into seating. So that's a very simple building permit to just modify the change of use of that area from storage to seating and patron area. He hasn't applied for that permit yet, but those are the two things that we would need to get everything.
How long were these uses unpermitted, let's say?
I think the seating area goes back to before he was actually operating over there. I think it was at least 2 years. And the rear parking, I believe, was last spring that they did that.
Okay. Any other questions for Alex?
No. Okay. Thanks.
Any other questions from the select board? Teresa?
No.
Okay. Kyle? So you just heard everything.
Absolutely. We'll run down it piece by piece. Let's start with Wayne. The inspection, I received the report this morning. Me and Wayne have talked about the core things that need to be taken care of that. He has an email that I sent to him this afternoon. We've taken care of the door, the emergency light, everything minus the state inspector for our dance license. That's scheduled for Thursday at 12. The alarm company is scheduled for Monday at 12. It's the earliest I could get them in there to take care of that. Hoods is coming back. The problem that we had with the grease system, I hired an outside contractor in both times. August 2nd, I had this company come in and they charged me $600, did a full service. Wayne came in 5 or 6 days later, was not happy with the work. I had them come back and do it again. I was assured that this time around, when I scheduled it again in May, that we weren't going to have these issues. Clearly, this company is not putting together what I need them to do. They will return because I've already paid for this service to get it completed tomorrow. We'll speak with Wayne and have him do an inspection after, so that'll be taken care of as well. So the only open items that are left on Wayne's list are going to be those things that I just mentioned. The meeting on Thursday with the state fire marshal, the alarm system on Monday, and then hoods tomorrow. After Monday, the 15th, his checklist will be complete. He'll have everything he needs for a full sign-off.
Okay.
What about the parking lot?
What about the permits?
The permits, so I've tried the online system 3 times. I've called Town Hall. I actually spoke with Kirsten today. I said, I'm having problems doing the online permitting. Is there any way I can come in? She said, yeah, I'll be here tomorrow from 8 to 4. I said, that's not an issue. I'll make sure that you have the permit for the back extended area that he was looking for, an after the fact permit. The issue with that is I can't do it online. I've tried it 3 different occasions. Now I just have to go manual. We'll take care of that tomorrow.
But it's been 6 months.
That was just brought up to my attention less than 2 months ago. This is 2 separate things, as Alex had stated in the beginning. There's a rear seating area that was existing that I have to get a permit for now because that's what is believed should be done. I'm okay with that. It's a $50 or $100 permit. We'll get it taken care of tomorrow. The second, the extending the parking area in the rear. When I had acquired a lease on the rear area, which is a commercial zone property with a residential use. We had removed the topsoil from the area. That's where the violation stemmed from. That was before we added any gravel. That was before any work has been done out there. So that violation is in standing from the very beginning, from the neighbor that actually wrote that letter that Teresa had just read for us. What I did was work with Alex, and I had misunderstood after I had submitted an engineered plan of the facility, what we were doing, that there was additional tasks that need to be done. There's been no construction back there. There's been no fence installed. There's been no extension of my patio. There has been 6 inches of gravel that's been laid down, and it was in my understanding when we had talked prior that the engineered plan would get us where we need to be to at least do that, and that could have been on me, a mistake that I made. But we're in the position now where I've met with Alex and the town planner. We have a plan formed to get this up to speed. I'm currently waiting for a surveyor to come in because the town planner feels that I need to survey that lot before I can submit any more plan. Unfortunately, I'm waiting for that to come back. As soon as I can get a surveyor in, we can move forward with the plan that me and Alex put together. If you remember, we had sat in the office, come together, how we're going to do this, and we're going to move forward in that direction. So I'm doing everything I can as quick as I can to resolve that issue on that front.
How often have you dumpster picked up?
The dumpsters are dumped regularly. So there was an issue with my dumpster supplier, and I actually received a $900 credit for that month. There was an accumulation of cardboard that was overfilled the dumpster. And I called them up. I said, listen, there's an obvious discrepancy here. They came back and actually credited my account $900, brought the truck out as quick as possible, and I let them know that this is unacceptable. Since then, we haven't had a problem. Those dumpsters remain dumped every week, both cardboard and trash, and we're very vigilant about picking stuff up, which can lead us into our next thing. The complaint from Jeffrey Cox wants to talk about broken glass and drug needles. That gentleman has a camera pointed on our property line, but it seems like he has failed to provide any evidence other than a letter making up stories about what he sees, because at any time he can provide still photographs or video of the shared property line in question, but he is yet to do that. what I've done for probably the last month and a half since I found out about this violation, I've taken videos on different days of the week, both on the weekends and during the weekdays, documenting that property line, showing that there's no broken glass, that there's no trash, that there's no drug needles. And I have it on a thumb drive in my pocket. If you guys want to review that here, take it back with you. I'm fine with that as well. So a lot of this comes down to a neighbor rift. And I will note that if this was the case, it's come to my attention that abutters all got a notice of this meeting, correct?
Correct.
Nobody's here to speak against me, even Jeffrey, for whatever reason. So I have multiple neighbors. I believe there was 14 people on that list at one point that received this letter. Now, one of them are coming here and they're speaking ill of me, as Jeffrey did. And like I said, if we want to look at pictures and photos, I have those. Jeffrey, I don't know what his status is, but I would ask him to show you some evidence to back up what he's claiming.
Not everybody wants to get up in public and talk bad about another person. It's not easy to do.
Sure, but if they wanted to, the opportunity's here, and if the problems like drug needles and broken glass were as prevalent as people want them to believe, I'm sure that that might bring them up here to, mention it, at least to you guys.
So, yeah, go ahead, Teresa.
So, Kyle, after I got the letter, I have gone by a couple of times looking back there just to get my own view of it.
Sure.
And I see a lot of garbage. Cardboard boxes thrown on top, cardboard boxes laying on the side of it and in front of it, and I've seen it several times. So like I said, I don't want to take somebody's word for it. I want to see it myself. So if I go to Wyndham or whatever, I do see it. So I have seen it several times. And I guess I would also have Joe address the question to you as to the OUIs and the people leaving really drunk.
Yeah, let's talk about that, because this is, any evidence or facts that you guys have provided, I have not been provided. I also have to deal with the state liquor inspector on a regular basis. If this was a continuing problem or an issue that was directly related to me, I would imagine that I, in some way, would have been contacted, since I'm the one held responsible. That's why I'm here today. So if we want to talk about that, this will be the first time I hear about it. I'd be happy to answer any questions or try to fill you in with anything that you think is missing. So
we got a report of 5 OUIs that came out of your place.
And how do they determine that?
Sheriff's office.
Right, but I mean, they pull somebody over.
Yeah, and they said we had drinks at your place. Yeah, they've been observed leaving your parking lot and then get pulled over.
Okay, so if you look into the state law, my responsibility as somebody that serves liquor or alcohol on it is to not let anybody that is visibly intoxicated stay on my premise. That means if they're falling down, if they're falling asleep at the bar, if they're slurring their words, that's what my responsibility is. So if these guys are drinking and they are holding themselves together, they seem like they are well put, we look at them and we observe them, and they're not falling asleep, causing problems or any of these issues, that is beyond me. So if I don't have a breathalyzer, I don't have the right to breathalyze any of my customers. I can't do a field sobriety test before I leave. So my only obligation is to make sure that these people aren't visibly intoxicated when they're in my establishment.
No one's asking you to do a blood draw and
no,
figure out the blood alcohol level. Yeah,
and I'm there every night, and that's the thing, is that I am there on a regular basis every night. If somebody comes in and we had shut them off, what we see on occasion is most bars close around 9 or 10 o'clock. So you'll get an occasional patron that'll come in, and we won't serve them, but they're not okay to leave there. So we offer them. Can we give you a ride? Can we give you a water? But beyond that, there's nothing I can do. I can't withhold somebody from leaving my building. I can't take their keys. I can't tow their vehicle. I don't have that power. So,
How many fights have you had in your bar?
I have had 0 fights this year. 0.
There was no one that was assaulted?
No, there was an incident that happened outside of my establishment, and somehow it ended up in my parking lot. And I clarified that with the sheriffs. The people that called from across the street, and from what I could gather of the situation, somebody was burning out at a resident's house and caused a ruckus. There was a case of mistaken identity with somebody that was in my parking lot picking up a patron, and an argument ensued. And a customer from the gas station across the street came over and said, I just called the cops because I heard all this yelling. I don't know what's going on. And this is, we're calling the cops. Cops came in, they talked to the parties involved. I spoke with the cops. The exact words out of the deputy's mouth was that we don't have to come here. You run a good operation. We rarely have an issue. Fights are not a thing here. So I have a good rapport with the local sheriffs. And we don't have fights or altercations at all this year. That didn't happen in my establishment, and that wasn't a result of something that happened in my establishment. It just kind of showed up on my doorstep, and I had to deal with it.
Okay. Other questions of Kyle? Okay. Seeing none, any public comment? Seeing none, I will close the public hearing. And we'll go to new business. Consideration of Cafe Sebago liquor license and special amusement license renewal. You can sit down, Kyle.
Okay.
I'm having a hard time doing this, knowing that there's still violations out there that need to be cleared. And Alex, is this something that's solvable within 10 days, within 2 months, within 6 months? What's the timeline?
Definitely 6 months, I would think. Within 10 days, no. We met, I think, 3 weeks ago or so, and, he left that meeting going to hire a surveyor. I know quite a few of the surveyors in our area. There's not many. Most of them are 3 months out, and some of them aren't even taking new clients right now. So it can be tough to get that. So for the site plan itself, I think we're looking at 3 to 6 months before that part of it's resolved. The seating area, that could be resolved in the next couple of weeks.
And do you have a firm resolution, or is that still in flux right now?
It's in flux because the reason there's a few different reasons why we need the survey, but the big one is, the issues he is having with his site is parking and traffic circulation. So that survey will kind of give us the information we need to really see how much space he has on each side, to calculate, what he has for parking spaces based on the, dimensions required for a parking space. And so he has a couple different irons in the fire as far as that goes, with possibly getting more land in the back or the side, or working out some type of agreement, with one of the abutting businesses to try and secure some off-site parking. There's a lot of different scenarios that we worked through to try and make this work for him.
Has he talked to his neighbors about, Kyle?
That I'm not sure.
Have you talked to your neighbors about getting parking after they close at night?
Absolutely. So right now we kind of have a shared agreement with the tattoo shop next door. I've also just put the next building under lease, so that provides us with some additional parking over there that we can work in.
Which building are we talking about?
The tie-dye.
The tie-dye place?
Yep, that just went up. That tenant left, so.
Oh, she left already?
Yep, so I decided to get in there to be able to have some additional parking for my staff, so I can ease the load on what we have over there. And then my neighbors, like I said, they've been great. The rear one has given us the additional space to do what we want to do in the future with the expansion, and the rest have just been very cordial, and likewise with them. I mean, we've had a really good relationship.
Okay, thank you.
So, was there a question with septic too, that the septic had to be changed because of having more people in there? I thought I heard something on that, maybe?
Yeah, Alex, do we need a new septic?
The existing max capacity based on the septic system is 48 seats. So that's established on seats as a restaurant. There's calculations, they're dependent on the use. So if you change to a takeout business or an ice cream shop or whatever it is, it has a different gallons per day. So the number we've been firm with has been 48.
So what's the occupancy in the building?
That would be a question for Wayne. He knows that one. Yeah.
Wayne, what's the occupancy of the building?
The actual number, I'd have to look it up for you, but it's more than 48.
It was around 100, I believe. If I can remember
So if you get more parking in and you're pulling in a lot more cars, that's a lot more people that are going to be coming, whether they're outside, inside, or what, and that's not done. I have to agree with Rolf that I've got really big concerns about approving this right now because I think there's too many things that are untied.
So if we have 100-person occupancy, you need a whole new septic system.
Yeah, you would be required to expand, you know, if you've got.
I mean,
that
he's
much
talking
seating.
about expanding.
Yeah.
Can I?
Yeah, go ahead, Cal.
The expansion that we're trying to do right now is simply expansion of the patio. There will be no additional seats added to this patio. It's simply for recreational use with cornhole boards and a place to keep people that are away that are dining outside. At this point, our seat capacity hasn't changed, and our seat capacity isn't going to change. That 48 is based on seated customers. And as long as I keep my 48 seat count at 48, I'm in compliance with that.
You've never gone over 48?
No, we keep it it's 48 seats in there is, you know, I mean, that's a small building. So we rarely inside, no, we definitely don't get it.
Do you serve food there?
We do, yep, from 12 to 9.
Like bar food or?
Appetizers, light fare, handheld stuff, nothing too extensive, you know, light fare pretty much.
So can I ask you then, Kyle, if you're having, and I know just checking Cafe Sebago, I know that you advertise for like a DJ, different events, you know what I mean? Like that type of thing. So to me, you're advertising to bring in more people so they can come over, have a good time and that type of thing. So in that case, it is going to be more people than the 48.
I mean, we advertise our services just like any other business.
Right.
We just want people to know that we're there. We're in a small town of 4,000 people, so we need to be realistic on the numbers that we're actually drawing in. This place has been in a capacity of restaurant since 1962. The square footage and the parking that is existing right now has been tight just to fill up what I have for seats right now. So my expansion by adding a couple parking spots will allow me to reach the capacity that I'm already established to have. And the other thing is that the new design that me and Alex are working on right now, the only thing that's holding this up again is a surveyor. I have to wait for the surveyor. We're cutting down our patio size by 25 feet. We're increasing the access to the back of the lot, and we're losing a lot of that parking to, it's going to be grassed in the corner, and there's going to be access for the fire department in the back. So we're no longer gaining any more parking from the rear of that structure. We're just coming up to code with the fire department and what they expect us to have for lot circulation. So the original thought was to add the parking. Digging into this a little deeper with code, we realized that that's not going to work. But that's why I leased the other building to get the couple spots that we're short right now to operate, and there'll be no additional parking spots. So there'll be no additional parking. There'll be no, you know, the goal isn't to fill this place up. It's to come up to speed with what we're already approved for.
All right, so I know like before it was just a restaurant. They did not have the extra space out back. And
They did, yes, they had a deck. They had a
right, but just a deck where people went outside to smoke on but they
drink.
didn't have like the whole entertainment center type thing that you have out there now.
fence and stone, and there was tables on the deck. So I mean, I've added a couple picnic tables to the area, and I have some fencing and some stone. This was all submitted with my original application from day one. I mean, this was all detailed out with not only the liquor but also the town.
Right, and I understand that, but I was saying what I was going with is they didn't have to get a new septic when it was the other owner, you know, when it was just the food before, but now you're adding entertainment to bring in more people. So that's why the septic, I believe, has been brought into this. Is the only reason why I'm bringing that up.
This is the first time that I've heard that the septic would need to be expanded with, Alex, we haven't spoke about this
Kyle,
in the past. Oh, so,
talk to us.
All right, so it's kind of directed towards him.
Yeah, that's
This is the first time that I've heard about needing to expand based on what we're doing. The septic system, the restaurant seats 48 people. That's 48 seated people. Now, I'm not sure how the calculations work beyond that, but our seat count, and what I was told by Alex, as long as there's 48 seats in there, we will be in compliance with what we need.
So there's 48 inside.
There's 48 total.
Including outside.
There's a pool table, and we've reduced, I don't know if you've ever been in the cafe, but we've reduced our dining room size by more than half. We put a pool table in the corner, we have the full bar, and then we have, I believe, seven tables that range between 2 tops and 4 tops in there. We have picnic tables out back, and that keeps us at our 48 count. I mean, we're inside and then the outside, combined. We never have more than 48 people in there eating and dining. That just doesn't happen. It's an in and out casual place. At night, they're coming in, they're having a good time, and then they're hanging out for a few hours and going home. We haven't had any backup with the system that we have right now. We haven't had any leaking, any issues. That system was updated early 2000s to accommodate the code for that building.
Have you had it pumped out?
Yes, we had it pumped out last year. We do it yearly. So we'll probably do it again at the end of the season, just to make sure we're good going into the next.
Okay. Any more questions? Alex?
When does the current liquor license expire? What's the expiration date?
That'd be a better question for Sue, probably.
It's in your packet.
Is that I'm not sure.
It's on the liquor license app.
The 19th of this month.
Yeah.
Okay. Yep, thanks.
Can I add one thing real quick? Sorry.
You have something, Wayne?
Yes, I do, if you're.
Yeah, go ahead.
Couple of things. You asked about the capacity. There's an inside capacity and an outside capacity of occupants that the building can hold, and the current outside patio with the picnic tables can hold. The inside capacity is 112 persons. The outside capacity of that patio is between 109 and 125. So that's to answer your question on that. And then just for a point of clarification on licensing, on liquor licensing for the different things that we're talking about, there's the liquor license, which the business has had right along. There's the the special amusement license, which is basically allowing entertainment and dining. That's a separate license.
Does he have that license?
Yes. Yeah. Yes, he does. He got that this past year.
Okay.
And the third thing is liquor license expansion, expanding the area that liquor can be consumed and served, and that's like that rear area that we're talking about with creating parking and an outside space to use. So just for clarification, I know it wasn't real clear. There's really 3 licenses involved here, so three different issues.
Okay.
That makes sense.
Yep. Kyle,
okay.
You want to add something?
Yeah, I'd like to speak to the capacity rating. Is simply they take the square footage of the building, they tell you how many people you can put in it. That doesn't mean that I'm going to have 107 people in there. It doesn't mean my intent is going to have 100-something people in there. That's simply during the inspection that's required by the town for my dance license. She has to go in there and figure out what that space can hold with tables, what it can hold without tables. So it by no means that I'm advertising to put 200 people in there. It doesn't mean that I'm trying to put more than what. It just says that facility, with the way that it's laid out, can potentially hold that amount of people. I can't call her and say, hey, listen, it's, we're only allowed 48. Can you bump this down so it looks better? So this comparison between what I'm allowed to do as far as my septic system capacity and then this number up here that seems to be spooking people, there's really no relation other than that's what the building can hold in its capacity if that's what we chose to do, which we're not choosing to do.
Okay.
And Kyle, I'm not criticizing you for advertising. I get that. That's not it at all. I'm just saying that, you know, then does pull more people in, which is good for you, but then not for the.
Sure. Well, I mean, that's why I'm there all the time. I'm continually monitoring. I'd also like to see, you know, what other locations in towns that serve liquor, you know, see for OUI cases to see if that's, you know, there's got to be a standard there. There's got to be something and some metrics that they use because. Yeah, that kind of bothers me that I'm just hearing about this now, especially when I'm the one holding the license and supposed to be responsible for responding to allegations like this.
Well, they're not allegations.
Sure.
They're fact.
Well, I mean, those are summons. I mean, those are summons that are read out. So the reality of it is that 5 summons were written. Unless there's 5 convictions in that paperwork, I think that we're speculating a little bit on what's going on. Because at any time, you could be pulled over and accused of doing what they think you're doing, and you can go into court, and it happens all the time. It gets thrown out, dismissed, or beat.
Well, Kyle, and right here on the report, it does say operator admitted to drinking at the bar. And it says it right on here, and it came from the sheriff's department. And it's literally from 3/18 until 7/14. And again, my concern is, and it's with any bar, you know, and I tell my kids when they're driving, I'm not worried about them, I'm worried about the other person that's driving. And when you've got people that are leaving there, again, and you keep saying too that you aren't responsible for them on your property, but don't you have some responsibility that they're leaving your bar drunk and they're gonna go drive from your place?
My responsibility as a person that serves liquor and the state holds me to, and this is a gray area, and if there's an issue, and I think it's an issue too, is that my responsibility is to make sure that you don't look like you're intoxicated. That is my liability in this whole thing. So again, if you're falling down, if you're slurring your words, if you're, you know, causing a problem, you're hurting other people, it's making obvious things. I need to, 1, stop you from consuming, and then really beyond that, my only responsibility is to serve you water until you can find a ride home. I can't force anybody to do anything else. Now, if these guys went to another bar, maybe they didn't get shoved, whatever the reason may be, I can't take their keys. I can't, and these people, you know, I'd like to see some the reports detailed on what these were. I mean, because these cops are, a lot of times, and this has been video documented I can present, they're sitting there 3 or 4 in a row watching my bar for 20, 30 minutes at a row. And this happens on a continual basis. And I can provide enough video to fill, you know, at least an hour of clips of them sitting there. For them to sit there and to pull 5 people out of the, you know, however many thousands of people a year that I serve, I think when you put that into context and that number, that it becomes, you know, a different story and a different narrative than what we're trying to push here.
This is for 6 months. This report.
And Kyle, one person on an OUI can kill somebody.
And I understand.
And there's not a redo of that. So to I guess minimize it, kind of the way you are of how many people you serve in a year, 1 person is all it takes. And to me, I'd be saying, okay, if you leave this parking lot, then I'm going to call the sheriff and tell him you're too drunk or whatever. But I have a real problem, I guess, with that, knowing that somebody I know or any other loved one is having somebody drive home. And that's that just one time, Kyle. That's all it takes.
And I understand that. But at the end of the day, you're asking me to do more than what I can legally do. I can't stop people from leaving. There's been no instance where people are fall down drunk or causing that got into their car and left. There's been, how many times, if the sheriffs are willing to present to, you know, they've been called 1 time in a year, you know, to that place. Now, if this is such a big deal and this is happening all the time, and I'm not minimizing what you're saying, and I agree, 1 drunk driver can change a lot of things, but you're putting the responsibility on a business owner that the state says, if he looks drunk, then you need to serve him water and try to find him a ride home. That's my responsibility with that. I can't control, again, if these guys come in and say they have 3 beers or 4 beers, they look sober, they talk sober, they pay their tab, they walk to their car fine. There's nothing I can do.
I know, but again, you're in that business for doing the alcohol. So to me, that is a responsibility that is on your shoulders.
Well, I mean, I'll have to disagree
I know
with
you
you.
and I look at it, you look at it differently. I know that.
I mean, I can only do so much, and I think that it's unfair to think that I have to sit there and play the role of the police officer and law enforcement. This is law enforcement's job to stop people from driving on the road. Now, I do everything I can in my power to make sure that people that look visibly intoxicated or they have the signs of it do not continue to drink or to go out there. I do everything in my power, but at the end of the day, it's the law enforcement's responsibility to find these people if they're exhibiting that behavior and punish them. It's not, I can't do anything about that. What I can do is just what I've been doing. Keep an eye on my patrons, make sure that they're not visibly drunk, and continue to do my business. And I know that, you know, liquor has a sore spot for, you know, this and that. I'm doing what I can, and I'm being very responsible. I'm there on a regular basis. I'm there making sure my security is watching for those signs. But I can't do anything beyond what I can do physically within my power.
All right, that's enough. Let me try and move this along a little bit. Kyle, you mentioned there's 3 or 4 sheriff's officers watching your establishment. Why do you think that is?
It's easy because 302 is there, and when you go fishing, you go where the fish are at, right? So if you're looking to pick up people that have been drinking, you sit outside of a bar. And we can take this into another time, and I could provide the photos and the videos of people that are leaving my bar that have exhibited no signs of being intoxicated, and they get pulled over left and right. This has happened on video on numerous occasions where they line up, people will leave, which I'm looking into that right now to see if that's even lawful, because they're not even waiting. They're looking at people. It doesn't matter who you are. They get in their vehicle, they'll pull them over, and then most of the time they go on their way because there's no real reason other than they were pulling out onto a roadway from a bar.
All right. Wayne.
Yes.
Do you think all the violations that you have listed in your report can be fixed within 30 days?
Yes, I believe so. Yes.
Okay.
And to Kyle's point, I didn't see his email from late this afternoon. A number of the issues were corrected today, and he did tell me that he would be working on these issues today. So he did send me verification. For example, the emergency light has been corrected. You know, there's a number of things that have been corrected that are on my list. So yes, to answer your question, I do believe within 30 days that can be.
Are you scheduled to go back there within 30 days?
Not currently, because Kyle needed to try to schedule those appointments, like with the fire alarm system company, with the cleaning company for the grease hood system. He needed to make those scheduled appointments. So we didn't set up anything when I left yesterday, but it's very easy for us to do that once he gets everything done.
Okay. So I'll tell the select board where I'm at right now. Kyle's a business person. You know, I know what it takes to run a business. You put your heart and soul into it. You put a lot of money into it. You lose that business, you lose all that investment. There's a lot of things going on that could be done better, obviously. For example, the garbage control, making sure everything is up to snuff. I would kind of like to just give Kyle 30 days to fix it. You know, and then come back and see if everything gets fixed the way it's supposed to be. I mean, I know when you're starting a business, you're short on cash, so sometimes you let things slip, and I just want to give him a chance to fix what's there.
Is 30 days enough, you think?
Well, that's all I'm willing to do. I mean, it's been a year.
Yeah.
You know, and we're coming back with some of the same violations. So, you know, did you fix it in a year?
I mean, we still got the permitting issue, which, okay, it's a surveyor thing. Give them some, you know, I'm willing to give them a little slack on that one. But as far as some of these other violations that Wayne pointed out, they shouldn't be there. They should be fixed. So, I'm open to anyone else's thoughts.
So what happens on the 19th? If we take no action tonight?
We can extend it for 30 days. Yeah, we can. Yeah.
The state can extend it for 30 days. You would have to contact the State Department of Liquor.
Yeah.
And your next meeting is on
September 20th. Yeah.
So are you thinking table it until the 20th?
Yeah. Yeah. I have a question for Kyle. Do you think you can correct these in 30 days?
The only
30
thing
days
that
from
Wayne's whole list will be done by this Monday. So Wayne will be 100% whole. Everything he requires will be completed. You know, some of these repeat violations that we're talking about is, you know, the grease stuff. I've hired these companies and I've gotten a terrible.
Find a new one.
I got it. You know, but they're limited. You know, that's that's the other thing. But you know, I've held them to the fire. So, and everything else I've fixed. These aren't, you know, things that are. I'm fixing them. Everything that's on his list will be completed by Monday. Like I said, the fire marshal will be on Thursday to do the dance license inspection, and Monday the fire alarm company will be there. Everything else right now he has. So that list with all those things, he has an email that can be forwarded to you showing the pictures. And this is in 24 hours. This is, you know, he come in and said, hey, boom, boom, boom. I had a carpenter there fixing the door. I had an electrician hanging the emergency light. I mean, I really put in everything I had to make sure that we were in good shape. The one issue that I can't control how quick I can get a surveyor.
No, and I said, that's not an issue for us right now.
Yeah, so I mean, other than that, that's not a problem at all. We can get this.
But if you could tell me that you got an appointment with a surveyor in 2 months.
Sure, I can get that on the books. That won't be an issue.
So.
But other than that, yeah, everything else by this Monday at 5 o'clock will be taken care of.
Thank you. All right.
Can I ask something?
Sure.
So, what about surprise inspections? Are they done in places like this?
Yeah, so we had one last year. The liquor inspector came down, came into our facility, sat down, and then spent the rest of the evening observing our facility. And they actually let the local sheriffs know that they were in town. They tried to enter without an ID. We caught them there. They were looking to see if we overserved anybody. No issues there. And there's been no violations on my liquor license at all from the state. And they have conducted we've been in contact, and that surprise, there was no, they didn't tell me anything. They came down one night, I think it was a Saturday night, and they ran me through the ringer, and there was nothing, no violations, no issues to be had, and we're in very good standing with the state when it comes to our liquor license.
So Kyle, that's funny because I never even thought about the liquor license. I was thinking about Wayne doing a surprise inspection regarding the grease. You just gave me a lot more information, so good. Thank you for that.
Yeah, no, I mean, we schedule it yearly with him, and then provide the paperwork that shows that we keep up with the stuff when he's not, like we do the hood cleaning every 6 months. And then once a year when this comes up, we get together with Wayne. He kind of goes through, makes sure everything's in good shape. If not, we fix it up, and then we see him again next year. Unless, of course, there's an issue or a call, which we haven't had any issues down there where he would show up.
You may want to consider doing it more frequently than every 6 months if you're having that much of an issue.
Yeah.
And maybe the type of food you serve, you know.
I agree.
Yeah, if you go to a bar, you're not going to get the healthiest food.
Yeah, that's true.
So you may want to think about cleaning that more often.
Let's either that or change that maintenance cycle so that it occurs closer to when the inspection.
Yeah, so what we were doing is kind of going off the state recommendations, but now that we're into it and we have a little bit more experience in the building and what we're doing, we're definitely looking forward to that. And then we're going to switch our companies. Like I said, I've already paid, so Wayne hopefully will come down tomorrow. I can call Wayne, and I'm going to see if he'll swing in after these guys are done and make sure it's done the right way, because I'm just as upset about it because it makes me look bad. You know, I hired this outside company. This is the second time it's happened to me. I've had to call them back. So I'm looking for the right solution too. I'm not looking to drag this out. We're not looking to be cheap or save money anywhere. It's just this company has not been great to work with.
Okay, have a seat.
Thank you. All right, so you heard my thoughts. What's everybody else's thoughts?
I agree with you.
Teresa?
I'm just listening to your thoughts. Rolf?
Yeah, I'm on board with that.
Yeah.
Okay.
All right, so can I have a motion to table?
Move to table.
Second. All those in favor? Okay, so this will be tabled until September 20th, the next selectmen meeting. Okay?
Thank you,
Get
gentlemen.
it cleaned up, okay?
You got it. I appreciate it.
All right. Are you all here for the same thing? Because I know you, this is like live TV right here. This is fascinating, isn't it? So are you all here to public comment?
Yes.
Is that what you want to address? I'm going to go right to public comment so you don't have to sit here all night. All right? So whoever wants to step up.
I don't want to step up because this doesn't make me comfortable. But anyway, my name is Sylvia Sullivan, Abel Bates, and we live at 55 Stark Cove Road in Raymond. And thank you for letting us speak. We're here tonight to express our concern for the town of Raymond over for the destruction of the 500 feet of frontage on Raymond Cape on the West Shore. As you know, Sebago Lake is an important resource, natural resource. It belongs to all of us. And we all have an obligation to take care of it. And with this in mind, we started a petition and a brief letter of support for the town of Raymond that has been signed by over 273 people in the last couple of weeks. They're users of the lake, and several of them are here tonight.
Great.
Wow.
Second fiddle. I'm Abel Bates. And I'd just like to read what this letter of support says that the 273 people have signed. We, the undersigned, would like to express our support for the town of Raymond in its effort to make sure that the waterfront land on Sebago Lake that was significantly altered without permit is restored to its former state. We also support the town of Raymond in its attempt to recover all costs of litigation associated with such efforts and to legally impose a fine to discourage future abuses. The land that was altered without permit is approximately 500 feet of water frontage at 28 Whitetail Lane and 18 Fernwood Drive in Raymond, and those two lots are also identified as lots 20 and 22 on Raymond Assessors Map 1. That's it, and we just are here to support you in your efforts. So,
thank you.
Have any questions of us?
Great.
Thank you.
Anybody else?
Go ahead, Julie.
My name is Charlotte Newberger, and I live on the Forest Road on Raymond Cape. Just like to give a little background. We purchased our land in the late 60s, built our house and moved in 1971. We cherished every moment of the process and the joy we felt in the magnificent place to live and to bring up our children. Now, just a short background. I remember when Mr. Riley came to such a meeting in the evening and influenced the selectmen not to consider the use of DDT. That was quite a few years ago. She was recognized and read and read and read again from The Silent Spring by Rachel Carson to help make them aware of the destruction of DDT and and what the pesticides could rot on the lake. Of course, as is often the case, we are not aware of the dangers of such things when it's first introduced. We know now, and she knew then, and relentlessly read until they became aware of what it could do, and they listened. I was also one of the many Maine area residents who drove to Augusta to a hearing about a proposed pipeline from Fry Island to Eelwell Canal through which they would send their effluent with only tertiary treatment to dump into the canal. More recently, there was the pipeline to tar sands. Each time, those who care for this magnificent area came together to save it from destruction. Apparently, there are those who do not consider this area a treasure for those who live here and for those who visit. This makes me not only sad, but very, very angry. There are laws for others to follow. It appears not for them. There is no consideration for the beauty and the ecosystem that many of us cherish, where we live and where we have brought up our children, and where we want to leave as a better place and not destroy. We and you need to send a strong message, and we are here to support you in what must be the ultimate message to those who act as if they do not care. Thank you.
Good evening. I'm Sarah Cusson, Sylvia and Abel's daughter and stepdaughter. I think everybody's on the same position, but I'm not going to assume. This is crime. It's ridiculous that people, and I'm going to say that think they have money, it's entitled behavior, it's disrespectful, it's rude, it's against the law. And I'm not mad at anybody here. I'm mad about the situation, and I want to help. I want to do something. I want to be heard. My parents, they have a tree in their yard that they think might be dead. They call someone in to see, is it okay? Should we take it down? Shouldn't we take it down? I drive by this monstrosity of a place that this gentleman, Donald Buteau, who hides behind an LLC, what he's done to his property, and I look at all these other people who won't move a rock because they're not supposed to, they need a permit, won't pull up a shrub, won't take down maybe a dead tree, won't do anything. Yet this man did it all in the cover of darkness over the winter when nobody's out on the lake to see it. And all of a sudden now it's spring, and what the heck happened over the winter? And now it's done, so he'll pay his fine and move on, and I'm sure that's what he hopes for. But I'm here to say it needs more. It needs to be back the way it was. It needs something. It needs a message, because apparently he's done it before, and he's not going to stop with a fine. But that's all I have to say. But I'm not. I sound angry. I'm not angry at anybody here. I'm angry at the situation and the balls of this man.
Yeah.
All right. Anyone else?
Good for her.
No, she's right. Anyone else? Doesn't have to be on that topic. Could be on anything else you want to talk about. Okay. Seeing none, we'll go back to our agenda.
Give it to the clerk if you want to.
Mr. Bruno, what can we say, what is the status of it? What is anybody doing?
If you look at our agenda, there's an executive session later.
On that same.
And we can't talk about it in public.
If you want to see a public statement, you can
watch Channel 13.
Go to WGME and take a look. I would assure you, at the staff level, the elected official level, we're taking good care of this, and we understand the importance of it, and the environmental impacts, and rest assured we're doing what we need to do.
Yeah, and we can't really talk too much about it.
But thank you for the petition and the signatures. We do appreciate that.
Yes, very much.
And I will also say that, it's not a fight we're fighting alone. We have also gotten the support of the local senators, the local Congress, the local representatives and whatnot that are on board with what they're seeing and things like that. So it's not being taken lightly.
The LEA, the Portland Water District. So there are a number of entities that are in this with us in support, and so we appreciate your support very much. I spoke with Abel, and I knew he was doing this, and I think that's an amazing amount of signatures in a short time.
But we're not,
One more thing.
we're not supposed to talk about it.
I just want to say that there's 273 signatures we got. There wasn't a single person who was opposed to this. And if we had more time, we could have got 90% of the citizens of Raymond, plus all the people that are using the lake. Nobody, everyone is on
We
the
understand.
right side.
We believe, if we could say more, we would say more, but we can't, so.
Is there more that regular citizens could be doing?
I mean, you could write a letter to DEP probably, and express your dissatisfaction.
It certainly would not be out of line to write to
Your state rep, your state senator.
representatives, because they are aware of it, but the more they hear it from other people, the more it drives it home to them as well.
You could also contact the LEA and
I did contact
Colin Hume and see what he has to say about, I'm sure they've had fights like this in other places. He probably could give you some advice.
Is the Corps of Engineers involved?
They are, but only, can you speak to that, Eric? Oh, we can't. Can't do that, can't do that, can't do that, can't do that, can't do that. They're involved, they're involved.
I keep telling you, we're working on this, but we can't speak about it. Okay?
We've been speaking about it for about the last 15 minutes.
Well, we're not really speaking about it.
Speaking around it, not
Sam
about
under
it.
the table.
Yeah. So you're welcome to stay, or you can take off. I mean, unless you're finding this exciting, have a seat. Thanks, Abel. All right, we're gonna give him 30 seconds, and then we'll get back to the agenda. All right, consideration of Fisherman's Catch liquor license extension. Wayne, any violations here?
No.
Okay.
The only question I had was, are they up to date on the personal tax?
As far as I know, they are.
Okay. Okay.
In that case, I would move to approve.
Second. Been moved and seconded. Any discussion? All in
Yeah, I
fa-
want to know if we're considered politicians who are bottom feeders.
Like the lobsters that he sells over at Fisherman's Catch?
It was put on his sign last year.
Ah.
Yeah, all politicians are bottom feeders. So I wonder if he considers.
Well, so are lobsters.
So are lobsters, and he sells plenty of those.
All right, all in favor? Unanimous. Consideration of business license application for Gillies Brewing LLC, doing business as Aroma Joe's. David Gillies, owner.
Eek.
Yep. I'm here.
Oh, hi there. Anything we need to know, Wayne?
No, everything passed in good shape.
Okay.
Just
Move
out
to
of,
approve the license.
well, just one question I have prior to is, if they're already operating, how are they operating without a license?
Because their license inadvertently got paperclipped to the back of Kyle's license.
Yes.
Okay,
So we missed
so
last meeting to get them
okay,
off the
so
agenda.
is that our error, not
That's
his?
my error.
Okay,
An error. Yep.
okay. In that case, yeah,
Go ahead.
I'll second Sam's motion.
Okay. Mr. Gillies, do you own all the Aroma Joe's?
Just Gray.
Just
Gray and
Gray and Raymond?
Yep.
Okay. I've never
How'd it
been
go
to an
with
Aroma Joe's.
What?
Do you have like just regular coffee?
Absolutely.
I mean,
Yeah.
I have these young people that work for me and they love it and they go get these wacky drinks. I'm like, can you just get me coffee?
So Mondays we have free coffee all day. Come down, iced coffee, regular coffee.
Seriously?
Yep.
Every Monday?
We're doing this Monday. We're doing
This
our
Monday.
grand opening this next Monday.
Okay.
I'm saying that again at the mic because the
Yeah.
mic's not
Yeah.
picking up.
No, so I was just saying,
Good
just
advertising.
is this next week we're doing our grand opening. We normally do it 6 to 8 weeks after we open. We're having different giveaways every day of the week, and on the Friday we give 10% of our proceeds. We picked a local nonprofit, which is the Waterways, to donate to.
Okay.
So.
Do you serve food?
Yeah. Well, when we can get it. We're having a little bit of supply chain issue, just like everyone else right now. So we're out of some of our breakfast sandwiches.
Okay, great.
And they're good breakfast.
Nice to meet you. Welcome to Raymond.
I live right down the street. So
Good.
a little Plummer Drive.
Great. Great. All right, and moved and seconded. Any discussion? All in favor? Unanimous? All right. You good to go?
Thank you very much.
How come this says Teresa Sadak? This says Teresa Sadak Chair.
Because it was done, it was supposed to have been approved before, well, she started.
Oh, are our feelings hurt a little bit there, Joe?
I'm upset.
He printed the form
Off the
online.
website? Yeah.
Before you got elected.
All right, consideration of business license application for Performance Motorsports. Is this the one next to the car wash? Auto Works?
I don't know.
Auto Works, yes, it is.
Is it? Wayne, is that where it is?
Performance motor.
It's in that building. It's only one of the spaces in that building.
Okay.
It's the first space on the.
Actually, it's the middle space.
So you have to go around behind it, or is it in front?
You go to the front.
You go to the front, the garage is in behind
the back.
Yeah.
The garage is not part of this business. It's just the office space out front that's part of this business. Okay. And that's what, that's what we inspected.
Okay.
Any issues there, Wayne?
I'm sorry?
Are we concerned about some of the stuff in the building, or?
So I added it to the report because there's three different addresses in this building, and there is 1253 front, which is being leased. There's 1253 rear, which is an automotive repair area that's controlled by Automotive Everything.
Yeah.
So, you know, there were some issues that we'd like to have addressed, but as far as this particular applicant, his space is in real good shape.
So why isn't it broken down to then, instead of 1253, why isn't it broken down to exactly where he's at? The license application.
Well, that may be his address.
He might know, you know, addressing issues. When he made application, he was renting 1253, but there's really front and rear, and he might not have known that.
All right, and another question, Joe, if I can. So you're saying that there might be some issues in the other parts of the buildings, but because one of my questions is like, I know, like if you have one business and you got to have that wall in there so it doesn't go into another business, we've run into that on several different occasions. So what's different here that we're not having those fixed?
So he does have a door that leads into the rear area, but for the number of people that he's going to have in that front office area, he's only required to have that front entrance exit. And, you know, I looked at the rear just to make sure, if worst case scenario somebody had to use the rear exit, just make sure that they could use it. They can. The biggest thing that I had for an issue at the rear was there's some ATVs stored up by the heating unit up top, and they don't have any gasoline in them. The tanks are all dry, but they're a little closer than they should be. So that's an easy fix for the owner of Automotive Everything next door to take care of for us. but it really, I need to work with that owner versus the owner for this application.
Okay, Joe, one more question.
Yep.
I know we had an issue with the other used car dealer over a little ways. Do they have so many cars that they're allowed to have out there? I mean, is there a limit on that? Or maybe Alex might know?
That might be an Alex question.
We don't have like a local ordinance that restricts the number.
No, not a local ordinance. We did with that one car dealership, though. Remember?
Yeah, the one across the old Raymond Auto Care across the street. Yeah.
They actually, you're thinking of the one that had the limitation of like 25 cars.
Yeah, and Ray's Barber there. Yes.
They actually set that number themselves. So when they applied for the license, they said it would be for 25. So when it was approved, it was conditioned that it would be up to 25. So they kind of set that for themselves.
Okay. And this one, there's not.
Yeah, correct.
All right. Can I have a motion?
Move to approve.
Second.
All those in favor? Unanimous?
Thanks, Wayne.
You're welcome.
All right. All right, Wayne, I think you're all done.
Hey, all right.
All right.
Well, have a good night.
You too.
You too, thanks.
Is Kurt LaBelle with us?
He isn't. He is camping just now, and didn't realize he was on the agenda this evening.
Oh.
I can tell you what he sent to me so far, but if you want me to run over what little bit we know.
Yeah, I mean, the website is pretty self-explanatory of what needs to be done. All right. So, anyone 65 and over, please take a look at the, what are they calling it anyway?
It's called the Property Tax Stabilization Program.
Right.
The deadline is December 1st.
Right. Applications need to be in by December 1st. You need to be 65 and over.
Eligible for homestead.
Eligible for 10 years for homestead exemption. And you must be a resident of Maine.
Yes. And it doesn't have to be 10 years
In the same
house.
town. It could be, right, different towns.
It could be different towns or different houses within the same town.
Do you have to apply for it annually?
You have to
Annually.
apply
It's
for
an
it.
annual application.
Yeah, and if you don't, then.
Then the taxes go up.
It would potentially go up.
Right.
If the taxes ever go down, it
It-
stays at that down
Right.
rate. But you don't hear that.
No, that's probably not going to happen.
That doesn't happen often.
Um,
The other piece, though, that we're letting folks know is that because the deadline's December 1st, the assessing agent isn't going to really review them until December 1st. The system, all of this came to be quite quickly. There aren't systems in place. There aren't a lot of things in place. We're not
Right.
really sure how physically we're going to deal with them. So if anyone calls, we won't have any answers for that.
This will be interesting for us going into a reval, because typically in a reval, and this may not be a typical reval because of what's happened in the market all across the board, you've seen, significant increases, but generally a third go down, a third are about the same, and a third go up. And so if you're in the category of go up, apparently it won't go up.
And there's no income guidelines.
Right.
Anyone.
Not means tested at all. Yeah.
Not right. Anyone can apply.
It also doesn't pertain to this September's taxes. It's next year.
Next year's tax.
Right.
Yeah, it's not this year. Right.
Now, has it been defined? It was still kind of up, the last I looked at it, was still kind of up in the air as exactly the timing on the reimbursement that comes back to us.
Yeah, that'll be very important. And the other thing that I'm thinking is, I'm sure they've done some sort of fiscal note on it and have an idea of what this is going to cost, but this is going to cost a lot.
Well, the fiscal note I read had $8 million. That did not include
that's the first year.
That's the first year. It did not include the $371,000 that they've allocated for the administration program.
Yeah.
No.
I think they're going to be under budget on that. Right? That's way off.
When people find out about this program, they're going to sign up.
Right? Why wouldn't you?
I mean, the only thing that where my concern is are we going to potentially
state's screwing this one up. So, yeah, we're gonna have to keep an eye on it and see how it
And I wonder what happens if, if this thing catches on like wildfire, which it should and will.
Yep.
And so then if the resources aren't adequate from the state, normally,
this will get squeezed.
You know what happens. And then, another concern I have about it, though, is that if it does have to come down, or even if it comes from state monies, since it's not means tested there, it's an issue where some people are going to probably not need this and be able to get it. And then there are people who would be struggling to pay their taxes, who wouldn't be of the age range and other qualifications, who would be paying into that fund. And so, I mean, I get it, and I think it's a great thing, but I wonder why it wasn't means tested.
Well,
it's going to be a large amount of money.
Yes, it is.
But I guess while it happens, sign up.
Yeah, and the applications are online.
Yeah.
We get them right from our website.
You have them on our website too?
And we have them printed in the town office, and we're printing the application along with the information sheet that the state gave for citizens.
Yep.
So that they'll have that.
Yeah.
Okay.
Okay.
Thank you, Sue, for stepping in.
So anyone 65 and over, or if you're listening and your parents are 65 and over, just notify them of this program. It's on our website. You can pull down the application and turn it into the town office by December 1st. All right, we have a quick claim deed.
Sue, you're going to take that one?
Kurt had just gotten back to me again. James Floyd has come in, he sold his property and paid the $21,000, almost $22,000 in taxes that he's owed.
Nice.
So he's ready to have a quick claim deed so he can finish the sale.
Okay. Can I have a motion?
Let's see, we have to move on this, yeah.
There you go.
Oh, okay, there we go. You move for a quick claim deed filed against map 008, lot 093A in the name of Floyd James E. in the Registry of Deeds, book 32517, page 100, book 35064, page 304, book 38553, page 64, book 33358, book 286, or page 286, excuse me, book 35913, page 190, book 34141, page 04, book 37080, page 32.
Second.
All in favor? Unanimous? All right. Manager's report.
Okay, so we have confirmed dates for upcoming regular meetings. I believe the date we have listed has now been changed. It's no longer the 13th, it'll be the 20th of September.
Yep. Correct.
And then we have October 11th. So everybody all set there?
Yep.
Reminder of upcoming holiday schedule, Monday, September 5th, Labor Day. And another reminder is the annual fundraising shooting event at Camp Hines, which is going to happen on September 9th. And that's from 8 a.m. to 4 p.m. So I want people to be aware of that. That normally generates some complaints. We have provided them with a butter list, and they're doing notifications. I think we put it on our website, and we may assist in other ways to try to get the word out so that people aren't alarmed by that. But if anyone's been in residence for any period of time, for instance, Sam probably knows all about it, and it's something they do every year. So that's coming around again. Other things I want to tell you about, the Main Street Sidewalk Walk project is on schedule. It should be completed in 2 weeks.
Looks good.
Interestingly, I haven't got a single complaint that has come to my level. I know Nathan's had some de minimis complaints, but Nathan and the crew have done a great job. The engineering firm, the contractor, Sebago Engineering Firm, and Glidden Paving doing the work. I think it looks spectacular. I think it's going to be a super improvement for the town. The only question I've gotten, and I've gotten it from a half a dozen people now, is are we getting streetlights? The answer is no, not now, but it's something that could be considered, in the future, but that's not part of the program. But so I've not had a single person say that they are unhappy about it, which is good news. We're seeking a full-time human resource officer, finance assistant. And that advertisement's posted on the website. It's posted in the local weekly papers. And so Rita Terrio, who's been with us for a long time, I think about maybe 18 years or so, is retiring. So good for her, and we're looking for someone to come into that position. So if you're interested, please apply. The town report finally is available. It's finally available, and it has an audit report in it, right? So that's a good thing.
And I forgot to bring the select board.
You have to bring them, but that's okay. We'll get them in their boxes. So Kevin tells me that he's working with the library, some things that are happening there. They're going to get the full complement of town technology. They got only a partial one now because Kevin's done it on a volunteer basis for years, but they're getting their automatic locks, new phones. They're getting video security and all that entails. And this one you'll really like. We're getting a fiber link between the town office and the fire station that's going in, and apparently it's going in tonight, which is why we don't have the connection to the outside world on television, because they're splicing the connection, and apparently they cut our fiber connection tonight. So that will be fixed, and we'll be broadcasting live next time. We have an RFP, and because Rolf's on the CoLab group, and so the RFP for broadband is, I'm told by Kevin, they're making a few minor changes, and it's going out next week or the week after, so we'll start to see proposals back, town-specific, on what it might take to install broadband infrastructure by town. So that's very exciting, and that's all.
Great. Selectman comment.
Do you need me to come in and sign those quitclaim deeds, or are you guys good?
No, you got a quorum, we're all set.
All right.
I just want to thank Kathy Goslin and Raymond Rescue. I did a pediatric vaccination clinic a couple of weeks ago, and I needed some epinephrine 1000 in a vial, and I could not get any, so they were kind enough to let me borrow one. I never used it, thank God. No one passed out on me, and so I was able to return it intact, and thank you so much for doing that. We spoke to the department, the rescue department in the town where I did this clinic, and they refused us. And I'm like, okay. But anyway, we did 181 vaccinations that day, and we did probably about 70 children. So it was a very successful clinic.
Good.
All right. So thank you, Kathy, and your crew. Very, very appreciative. Can I have a motion to go into executive session?
So moved. Move to go, yeah. Pursuant to 1 MRSA 405-6E.
Okay.
Second.
All in favor? All right. We're in executive session.
No, you.
Bill? Let me know.
I don't know if you can.
Okay.
All right.
Move to come out of executive session.
Do I have a second? All in favor? Thank you.
Move to adjourn.
Second.
All in favor? Thank you.
Okay, so welcome to the first organizational meeting of the Comprehensive Plan Committee. The first order of business has just been happened. We've called the meeting to order. The members that are present have been sworn in. I would like to tell the committee, for one, you'll have name tags next time as soon as W.B. Mason finds where they are. And one member of the committee, Bill Frazier, has already resigned. You'll still see him on things to sign tonight because the selectmen haven't accepted his resignation as yet, but he had some health concerns, so, and not, just, I'll leave it at that. So he's not going to be able to do the committee. I did send out just a standard type of agenda to all the committee members just to get us started. The first order of business is election of officers. And is there any nomination for chair?
You know what, just in the interest of getting to know one another, I'd like to move to table that until maybe another meeting or two, just so we can get to know one another, work with one another, because the leadership of this organization is going to guide it for the next 2 years here.
Is there a second to that motion?
Second.
Any discussion? Okay. I have one thing that I will say, and if that is the case, the committee is going to have to set the agenda before this meeting ends, so that we'll know what to do next, because that's part of the purpose of the chair, is so that I can bounce an agenda off the chair.
And this is a little unusual circumstance. I mean, this is a committee that hasn't been impaneled for 14 years or something, you know. So, you know, I certainly appreciate your point and think it's a good one, but, you know, we have the practical matter of having to have somebody to coordinate with. So a few meetings, a couple, 3 meetings, not an issue, but at some point we need to have, you know, a chair. And the chair has really no more power, I guess, than anybody else, other than, you know, perhaps, you know, hopefully representing the interests of the committee and setting the agenda based on the meetings. I mean, it'll become obvious in the meeting what you want to do, I hope. And then we'll put that on the agenda and off we go. Yeah.
So is there any sense of having a chair just for this meeting, a temporary chair? It sounds like you can run it, can't you?
I can run the meeting. Yeah, I can.
No, that's a good point.
Yeah, that's how we'll do it.
Okay.
I nominate Sue for a temporary chair.
I'm not a resident, so I can't be a temporary chair. So all those in favor of the motion on the floor? Thank you, it's unanimous. So the new business, the first is consideration of adopting the remote meeting participation policy. This is a policy that the state basically came up with, or it's possible MMA wrote it, it's been a while now, that allows committees to use remote means to come to the meeting and participate in the meeting. If you don't adopt this policy, then all your meetings will be in person. If you do adopt it and someone is away for business, they can Zoom in. If you needed consultants that were out of town, it can be a little less expensive. So I'm not trying to advocate for the policy. I just want you all to know that there are some benefits. There are some downsides. Sometimes the technology has some interesting things, especially if Spectrum decides to go south or anything. So there are ups and downs to it. Sometimes people prefer to be Zoom, some prefer in person. We can do hybrid meetings, but we can't do hybrid meetings. And by hybrid, I mean some people on Zoom, some people here. But we can't do those without this policy. So.
Move to adopt the policy as presented.
Second.
Any discussion? Or any further questions? All those in favor? Unanimous. Thank you. And then next is pretty much a wide open discussion of next steps, where we go from here. The one thing I will say is that, actually next step is to pass this around. If you can each sign where your name is, that's the policy for the remote participation policy. I did begin today going out and looking at what kind of resources you might have as a committee for planning. Not saying you're going to do that, but I wanted to start finding out what's out there. And I can email out the list that I've come up with. It was just this afternoon, so there wasn't time to get it to you before the meeting. I've also started collecting some sample RFPs if you decide you need to go to RFP. I've gotten one from Gray, Kennebunk, Saco, South Portland, and York. So
planners?
Yeah, no, well, an RFP to go out to find planners, yes.
I think you're a ways away from issuing an RFP.
Yes.
I think along the line of getting to know one another, you probably want to take a look at the old plan and organizationally decide, you know, how you want to approach this thing, and you know, I think maybe you have a general idea where you're going before you go out looking for a consultant. But after we do the RFP, we'll get hopefully some responses, and you'll be conducting interviews and selecting a consultant. This comprehensive planning and planning in general business isn't what it was, you know, a decade or more ago, and you know, state planning office is gone now, And so it used to be a requirement of towns, and so towns, I've been doing this for 40 years roughly, and I've been through several of these, usually 10-year increments. And although it's not something that's required, it's something that is, I think, an essential component of the community. If you don't have some sort of a semblance of a, you know, direction, goal, roadmap of where you want to go, you're probably not going to have a very, I think, directed journey as you try to achieve any goals for the town. So I think it's a great thing, and I'm glad we're finally doing it, but we're not going to have the kind of support we used to have from the state, and there aren't as many consultants, but there are consultants, and we'll find a good one.
Just to take us off track, I'd like to spend a little time having everybody introduce themselves,
Yes,
a little
that's a
background,
wonderful
who they
idea.
are, what they do, you know, why they decided to suffer through this process. We can start up with John.
Wow, what an honor. John Rand, been in Raymond since 1986, and family's been in town since 1944. Wife and I raised our two kiddos here. They're all went through the schools, and they're working in Portland now. And been involved in the '89 comp plan, which my folks are involved with, the Brad's 2004 plan, and was also involved in Raymond Waterways and Raymond Conservation Commission for a decade and a half or so, and believe in the process. And good planning takes good minds and dedicated folks that are here for the long haul. And that's what I'm seeing all around the table here. And look forward to working with everybody to do some good visioning and keeping our speeches concise with this big group, and working with a planner. And I trust we can find a good one to help us stay on track and make a good direction for Raymond.
My name's Danelle Maloney. I've lived in Raymond for 7 years now. I have 3 kids who are starting to go through the system, or 6 and under. So I am an attorney downtown in Portland. I started working with the town on some cases that I'd been doing, and I just enjoyed being a part of the town that I was living in. So I was looking for an opportunity to get more involved, and thought that this was probably the best option, even if it wasn't one of the only options with the town available at that time. So I was excited to jump on and keep moving.
What firm are you with?
I'm with Drummond and Drummond.
Alan McEwen. No,
Yeah.
Alan?
Yeah, I've heard the name. Yeah.
Yeah. Very good. Oh, Drummond and Drummond.
Not Drummond and Woodson.
Horace.
Horace, yeah.
Yes.
Yeah.
I'm Brad McCurtain. I've had property here in Raymond since 1980, and I think I moved here in 86 or 87, and grew up in Portland, 4th generation Maine, but I haven't been here in Raymond as long as John's family has been. John and I and Greg Foster were on the committee. I think that's it. Back, when did we start? 2001, I think. It was late 2001 is when we started it. And I was really pleased to see both John and Greg back on. It's a great committee, but as I've looked at the resumes of this one, I think this one can be an even better committee here. I've been involved in a lot of nonprofit organizations over my career. I won't bother going into them, but I love getting involved, whether it's at the community level or just nonprofits, and have been involved in a lot of strategic plans, including co-chairing this one when we did it, last updated it a few years ago. So I'm excited about this. I love the community in which I live here. I'm very happy with the leadership of the community here. And Sue, I haven't gotten to know you very well yet, but I think we will over the course of this. I was a big fan of Louise Lester and whose shoes you have filled here. So I'm looking forward to this committee getting a lot done, and I think maybe the most important thing we need to do is make sure that we get out and spend time identifying first and then meeting with all the stakeholders. There are an awful lot of stakeholders whose input we should really get to sell this plan. I think that's one thing Greg taught me on the last plan is we really need to get out into, here's our people, really need to get out into the community and talk to people and get shouldn't really be our, excuse me, shouldn't be our plan, it should be the community's plan. So, thank you.
I'm John Clark. I'm pretty new to Raymond, moved up here November 2020, so almost 2 years. And I work in real estate development from home, so I spend a lot of time in Raymond right now. You know, but part of my day-to-day intersects with kind of, you know, private financing and, you know, kind of the public process of, you know, real estate. And I thought that this would be a really interesting endeavor to do and understand, you know, how it all fits together. So, and I like urban planning, so I thought that this would be nice.
Well, I'm Greg Foster. I like Brad, I purchased land here, I think it was 80 or 81, and I moved here, I think I became a voter in 87. I've been here in Raymond ever since. And by trade, I'm a professional forester. I offer my services to private landowners who manage their forest property. I've done quite a bit of work in the town of Raymond for forest landowners. And John's not one of them, one of my competitors, who was a very good forester, does his work, Rennie Noel. I did do the town of Raymond's forest management plan for the 2 parcels I own, and we executed a timber sale on one of them. I also was on the comprehensive plan, it was the equivalent of the implementation committee from the was it 84 you said?
2004?
Plan. No, the earlier, 89,
I think it was.
Oh,
Yeah.
I can't read my own writing without my glasses. I was on the implementation committee back then, and then in 2004 I was on the comprehensive plan committee with Brad and John and others. I'm also on the planning board. I've been there for quite a few years, and I was on the Conservation Commission for a while. I think that was my first introduction to Raymond, being on a board with John and his mom and others. With that, I do have a lot of interest in forest land and land ownership, and I have what I think is a pretty good expertise in what people think of owning their land and being able to use it and that sort of thing. And I hope I can offer some of that understanding when we work on this comprehensive plan. So with that, it's Frank.
My name's Frank McDermott. I came to Raymond in 1968 as the teaching principal at Jordan Small School. Evolved through those chairs from teaching principal to supervising principal, back to teaching principal, depending on the school budget. Ended up being a superintendent principal here. I was here for 21 years, left here, went to Bonnie Eagles, assistant superintendent, finished my career over there as superintendent. My wife has been on just about every committee there is in town. She served 9 years as on the select board, and was on many other committees too at that time. I served on a number of committees myself. We have 5 kids, all went to school here. Got a great education and are doing very, very well. I've always been interested in what happens in this town, because I can remember when it was just a sleepy rural community. And Raymond has evolved into a bedroom community, that people have a desirability to live here. But I think we can even move beyond that. I think we could become one of the leading communities in the Lake region. And that's what I'd like to see us do. And there are many different ways of doing that. I'm going to be interested in seeing what ideas pop up here and see if we can come to some kind of conclusion as to where we should be heading. Because the town does have the resources to do anything it wants to do. Don, you said what? It's going to be probably $1 billion, $1.2 billion, $1.3 billion in valuation on the next
Yeah, and that's
round?
and that's before we do our new revaluation, and so I'm expecting that, we're going to see our mill rate, probably halve, and we're going to see our valuation, half again larger. So it's going to be, interestingly, the valuation of the town, even though it's a very rural, town, tracks with some of the smaller cities in Maine and some other communities. You might be surprised. There's a lot of value here with the lakefront real estate and in general real estate these days, but it's going to be completely different, valuation post this new reval. So Frank's right. We have the resources. I used to say that all the time, but it's what you want to do. It's one of the values of the town, though, has been low taxes. That's been a very primary value. That's starting to change a little bit, but we always pay attention to it. So your job is going to be to try to set some of those priorities and figure out what we should do.
Yeah, Peter Levitt, excuse me. Moved here with my wife in '85, I think. Built a house, bought 20 acres up on Raymond Hill Road here. Raised 2 daughters, went through the school system here, had a great education, both very successful. The oldest one just recently, last year, we built a house for her on the property. And she and her husband and my first grandchild are living now about 100 feet behind me, which is kind of nice. As far as professionally, I was a hospital administrator, ran a number of different hospital services for 30 years, and spent, I think it was around 25 years on the Zoning Board of Appeals. I learned a lot through that process, probably the greatest one being if you want absolutely no political aspirations, get on the Zoning Board of Appeals and continually tell your neighbors what they can and can't do with their property. So I am looking forward to working with all of you and trying to chart a course for Raymond in the challenging years ahead.
I'm Sean McKillop. I'm fairly new to Maine. I moved here about 3 years ago. I met my wife, and it was just the right decision to move to Maine instead of having her move to New Jersey. So I kind of joined this board because I just want to give back to the community a little bit. I'm part of a anti-human trafficking organization, and I'm on the board for my church. So I have some experience with finances and really just, how do we support the community and how do we let the community know that we're for them. And this was like the perfect blend of those two, but my first experience with it in Maine. So I just want to be a big support for the community. Real estate agent here. My office is in Wyndham, but we go everywhere from Harpswell to even Bethel, so my spread's a little big. But yeah, so trying to keep the small feel of Raymond, but give it all the benefits it needs without it becoming Wyndham is kind of my idea.
I'm Kayla Gonzalez. I've lived in Raymond for, I think it's approximately 7 years now. I currently work for the City of Portland, and I'm a former town employee. I was kind of coerced into being here, but I'm also happy to be here. I really am invested in this town. I believe in volunteerism, and I would really like to help Raymond face all of the challenges that it's going to in the upcoming years of a changing society.
Last but not least, Jackie.
Hi, first of all, I apologize for my tardiness. I thought the meeting was online and it was not. So I apparently didn't do all my reading and homework I was supposed to. So, okay, so I live here in Raymond. I've been here about 4 years now with my
What's
family.
your name?
Oh, Jackie Sawyer.
Jackie Sawyer.
Yeah. My 3 kids are in, I've got 2 at the elementary school, 1 here at Jordan Small. I've been involved with some of the youth athletic programs, helping to coach. And I work as a real estate agent. My office is Meservier and Associates. We're based out of Auburn, which is where I formerly lived, but we've got a Sebago office as well. So being here in Raymond is kind of a nice middle point for me. In college, I studied international development. So development is an area that I've never really pursued, but I've always had an interest in. And, you know, I grew up in Yarmouth, which had a really kind of thriving, you know, pedestrian-friendly feel to it. You know, a lot of recreational activities and everything, and I would love to kind of see that side of things grow here in Raymond, get people outside and enjoying life around here. So.
Excellent. So where do you want to go from here?
A couple of questions that I had is, number one, budget. I think, Don,
Yeah, you have $10,000 for this year, and that will be adequate because by the time you get around to deciding what you want to do and putting together an RFP, soliciting proposals, interviewing, hiring somebody, you know, I have a term of art I use, coined, I guess, all deliver at municipal speed, the speed of government. So it'll be, you'll have plenty of money to get you through to the end of the fiscal year, June 30. But next year, you'll be planning on more money, and you'll need to put together a budget, you know, to be reviewed by the Budget Finance Committee, Board of Selectmen, and then off to town meeting. So you'll have money enough to do what you need to do this year, I think, but you'll need to be thinking about next year and beyond. This is, by the way, this is a, you know, a 3-year commitment anyway, probably. So you have money, enough money.
well, I think we just swore that we'd be through by June 30th, 2023, right?
I can swear at you again.
Yeah.
You can swear we didn't do it that quickly last time.
We did.
And the other thing I should tell you is that, you know, Chris Sue's the town clerk, and she's the principal contact person for the committee once we have, you know, the staff, or I guess the offices filled. I'll be attending the meetings. We have Chris Hansen here, who's our assistant code officer. He's been with us for, I think it was about 10 years before he went to Wyndham, and then got some excellent experience in Wyndham. So, you know, he's going to be a resource in economic development, planning and development in general. You'll see our department heads as we hit each area of the comp plan that directly relates to them. They may get really excited and come to every meeting, but probably they'll be here when it's their thing. So that's.
What about minutes of the meetings?
Sue takes minutes.
So you'll be at every meeting then?
Yes.
Okay.
And if she's unable to be here, we record them electronically, or we have a substitute secretary. And of course, in the town, the digital record is the official record of the town.
Right.
I don't take particularly detailed minutes unless there's some subject that you ask me to do.
Yeah, and that's an important point too. That on this meeting, of course, you may know, may not know that, you know, it's being live broadcast, and then it will be streamed on YouTube and off the website as well. So there are multiple platforms that people can review and view the meeting. So that's something that when I started, you know, over 40 years ago, that was not how things went. But now everything is done that way.
So where's the camera?
There are multiple cameras.
There's one right here. There's one right there.
And they pick up on whoever.
Yeah, and of course, and when we do the hybrid, the people will appear on the, you know, television screens and so forth.
Behind that wall and behind the curtain is a gentleman who's running the whole system that does everything. It puts it out to YouTube right now, or streams it right now, etc. And you're welcome to wander back. Right tonight is Sean that's out there as our videographer.
It's the system, not the electronic piece of it, but the system itself, you know, kind of reminds me of Starship Enterprise. It actually came from Harvard, of all places. Kevin, our tech guy, got the cabinetry, and of course it's been updated over the years, but it's quite impressive, and that's just part of what we do. We have server locations at the town office and also the public safety building, but yeah, it'd be worth taking a look, see what's behind the curtain.
As far as the process, is it too soon to decide amongst us if are we going to use Roberts? Are we kind of started off by making motions, seconding and voting, but just to clarify.
That's typical, yeah.
Yeah, it's fairly standard for the town.
So is that something we need to vote?
You can vote to adopt Robert's Rules of Order.
All right, then I'd make that motion that we generally use the accepted version or the current version of Robert's Rules.
I'll second that.
And if anybody would like a copy of that, we'll provide a copy. But I think it'll be most important probably for the chair and vice chair, or however you do it, co-chairs.
Is there any discussion on that motion?
Just one question, yeah. How many are, everybody's probably familiar with them, but how many have actively used them in organizations?
Yeah, to some degree.
Because, you know, it does get pretty formal. For example, I believe the motion to table that I made at the onset
Would actually kill it if you use the direct interpretation, yes.
What's that?
That would actually kill that We wouldn't have a chair because a motion to table kills the motion.
No,
In
no, it
Roberts.
doesn't kill it, it just puts it on the table. But it's non-debatable,
Right.
the motion, but we debated it.
Yes.
So that's why I was wondering, you know, how
formal.
how
Yeah,
formal we
sure.
want to get with this, because if we say we're going to run by Robert's rules, it takes away the friendliness of it. And,
Yeah, I would think that,
Yeah.
you know, it can be loosely interpreted through the chair. I mean, that would be some way to control it to some degree. I don't think we need a parliamentarian or anything like that, but.
I think those are called the Bobby rules.
Yeah.
I can go either way on it, right? I just wondered what people's experience was using it. I've used it in a lot of organizations, but it can get a little.
I have no experience using it. I've listened, and so you know, I don't have an opinion. I defer. I think I defer to those of you who've interacted with it generally.
Modified Roberts with good judgment about how a conversation needs to keep going or not, and but we should keep it in the framework certainly that we're going to.
Sure. Some discretionary
Some
type
discretionary,
of capability amongst the board. If it seems like it's getting a little too hairy and we actually have to think about calling an attorney. I don't want to go there, believe me.
Wait, I already have one.
Yeah.
But at least the motion of the structure of the motions, the seconds, the vote, that makes what you do have a little more substance.
Yeah, that part we hold on to.
Yes.
Yeah.
For sure.
Sure.
So perhaps it's a great question. So maybe a modified version of.
Sure, with discretion to the chair or the board.
And what I could do is send out the main moderator's manual to the board if you'd like, and that has a one-page, very mini Robert's Rules of Order that moderators use to moderate town meetings. And it's really, I don't want to say watered down, but it's just it's a one-page document. So that explains the motions and whatnot.
It'd be helpful if it's just one page. That would be helpful.
Yeah. You've been in a lot of organizations. You have any?
Use Robert's rules, but use them sparingly. You know, giving everybody a chance. It only to the point where it begins to get to be 50 cups. You really have to, you know, call them in. You know, as long as everybody agrees they're going to behave themselves and they're going to listen to other people speak and that sort of thing, then I think we're fine.
Yeah, correct me if I'm wrong, but we're really not, any of the votes we take, they're going to be on recommendations anyway. It's not like we're setting statute or anything.
Right. That's correct.
A lot of what you're going to do, in my experience, is going to be more like a workshop meeting than a formal meeting. Although you'll have both, you'll be making votes on various issues, but there'll be a lot of not exactly scintillating TV that goes on.
Yeah, and most of the time you'll probably come to consensus as opposed to coming to a vote. But for instance, at the beginning of each meeting, I'll have you approve the minutes of the last meeting, and that I would prefer a vote on. And a vote to adjourn, most people look forward to that one.
So, but to have something is important, so Robert's Rules Light or whatever you decide is good.
So I'll send out what I have, and maybe we can decide at the next meeting.
Right. No, I think if that's the dividing, but it's just like as I said on the table earlier. It just if we have to get into wait a sec, that's non-debatable. Oh no, let me check. It is non-debatable, but it's not going to be fun. And I think this really we're all here to kind of have fun and get involved in the community and just kind of help shape the future. I think so.
Could I just ask, in the last comprehensive plan, there were no formal votes or none of that?
No, I think we did formal votes, but I don't think we ever got into Robert's Rules at all. I mean, we took votes from people, and we had a planner named Rich Rothy. I thought was very good. I don't know about you guys, but I thought he was really good. But one thing we did do, Don, is as we moved along, we actually left items. In other words, we finished them off as we were going along. And that surprised me a little bit. I found that, we weren't going to go back and revisit something other than, things changed. And so that's something we ought to think about too, because we'll look at a lot of parts of the community as we evolve here. And the last planner had us, let's just say we were looking at where should businesses be encouraged to locate in the community. We discussed it, we researched it, discussed it, and then we voted on it, and we didn't go back to that again, even though, other information came up. And so that might or might not be the way to do it this time, but just to give you some
I think on that, of course, you'll have ideas, but when you get your consultant, you'll have that discussion, and it may or may not be the way it was before. And, either you did a review or you have a super excellent memory, because I was saying 14 years. It's more like 18 years, I guess, since we did this last. And so I don't know as it'll be the way it was then. Yeah. And I mean, a lot of it will be how you want to do it and what the consultant thinks is the way to do it these days.
Yeah.
And I agree, Rich was good, though.
Yeah.
Yeah. I do remember that much.
I'd like to get some input on video conferencing versus live meetings and hybrid meetings. I've, like just about everybody here, I embraced it during the pandemic, and I still embrace it. I happen to like video meetings, but what's everybody's feelings on?
Before we go to that,
yes.
We do have a motion that's been seconded on the table.
Oh, on Robert's rules, sorry.
Yes.
Thank you.
So is there any more discussion on that topic?
It's maybe a hybrid of, not a hybrid, but a loose.
And did, Peter, do you and Greg both agree with that interpretation?
Yes.
Okay. All those in favor? Opposed? Thank you. I'm sorry, go ahead.
No, I'd just be interested in hearing everybody's thoughts on whether people would like to meet in person for all the meetings, or occasionally do video, occasionally do in person, hybrids, and what your experiences have been.
I guess I'll start. Personally, I'm incredibly busy, so being able to remote in is extremely helpful, and it makes me a lot more available.
I like the idea of doing a little bit of both. I always think it's important to sit across the table from one another and really hash out an idea. And but I do like the convenience of zooming in and not having to be here, specifically when I have to drive home, especially during the winter times. But I think a little bit of both, but still having those in-person meetings, I think is important to do every once in a while at least.
I wonder if we could do some sort of a rotating schedule perhaps, so that, I find it very beneficial to sit face to face and be in a group with people and be able to have a discussion. I think it flows much better than doing a Zoom meeting where everybody's on their own screens. So I wonder if perhaps there are certain topics that might fit better with an in-person type meeting, and some could be more remote, and it would work well for whatever it is that we're discussing during that meeting. I would be open to kind of either a rotating sort of a schedule, or maybe every other month sort of, hybrid and in person or something like that.
Frank?
I may have a problem if we go with that kind of a setup, because I go away for the winter. I leave in December and come back in probably the end of April, but I'm available to Zoom anytime. And if that's a problem, then that would be a problem, and I will graciously get off the committee.
You wouldn't consider flying back for the meetings?
Well, depending if Dawn paid for it.
This is Raymond, Frank, get a hold of yourself.
Sue, this time and whatever time we set up for our meeting will be held for us, correct?
Yes.
So we could say that the meeting is here, but if you have to attend remotely, that's an option for you?
Yes.
Okay.
Yes, that's what the.
I would suggest that's what you should do. I mean,
yeah.
I would like to see Frank stay, on the committee. He has a wealth of information, as you know. Some of the folks who worked with him over years about the community and some really great ideas, I'm sure. And so increasingly, you know, the technology is the way we conduct meetings. And I like Zoom, but I do agree you lose some of the personal connection, and it's not quite the same. So we could do a blend, but always have that option for people who, for whatever reason, can't do it.
I think that's the way to go. We've had enough Zooming, in my opinion, or Teamsing over the last 2 years. It's going to take us all 2 to 4 years to heal from all that technology learning, which has obviously advanced the world. But yeah, let's have a meeting here every month or whatever it is. And for those that need to Zoom, that'll be available thanks to the technology savvy of the town of Raymond.
That'd be a simple way to do it, I guess.
Yeah.
So I have a question. I mean, would we be seeing people on Zoom on the screens
You
here?
would see them up here on the screens, or if we had some sort of presentation, you would see it up there. Anything that's seen on the screens is also broadcast. What you don't get when you Zoom into a meeting that's here is getting to see everybody at once, because the camera angle is so far back that you don't really see anybody other than little stick figures around the table.
It's not going to be the same.
It won't be the same
as
experience.
You know Zoom.
Yeah.
Yeah.
You're going to be looking into the meeting room.
Yeah.
As
So-
opposed to a Brady Bunch thing.
Yeah, so whoever is being focused on at the time, basically whoever's speaking generally is who the videographer will move the camera to. And that's who you'll see on your Zoom if you're on your phone or on your laptop or whatever. But you can still hear everyone if someone else speaks. You just won't, unless you get really good at recognizing voices,
and we
you won't
can see you.
necessarily see. Yeah.
Yeah.
And we see you all the time. And if you're the only one, we see you really well.
No, this is well set up for hybrid meetings. You know, so often you get one little laptop over in the corner, you know, with people who are on it. This is great for hybrid.
Thinking that assuming that that's pretty well agreed on, is thinking we do monthly meetings right straight through until we're done.
That would be my suggestion. I think that's what we probably did last time.
Yep.
So we did, that was only monthly?
I think more than a monthly would probably be tough for people like Kayla and others. A number of folks still working full-time here. I'm one of them too with Kayla, probably most of some of you folks. You're still working full-time.
Yeah.
You weren't going to retire for this committee, Brad?
And just for scheduling, it's a bit easier if you pick a particular day.
Lock it in.
And lock it in.
Yeah.
Because that way other committees will know, okay, this day is always going to be for you folks, and they won't try and beef it. They'll also set it up on the calendar that way. But if you choose to move it each month, you're more than welcome to do that as well.
Would we do well to try to spend a minute right now setting that day?
You could. That's on the agenda anyway, yes.
One question is this where most of the committees meet? Do the selectmen meet in this room?
Yes.
Yes.
They all meet here.
Okay. So do you have a calendar that you could share with us, either now or by email afterwards, of what the different,
It's the
when
town.
they meet?
Well, it's the town calendar, and I did send it out in an email earlier.
Okay.
But it's, the select board meets the second Tuesday, planning board is second Tuesday. ZBA is fourth Tuesday. The recycling committee, which should be winding up, is usually on a Thursday, but I think it's the second Thursday. Mondays we generally don't do, and Fridays we generally don't do.
Good policy.
Yeah.
Although sometimes Mondays are used by the
Yeah.
budget committee during the budget review.
Not for the last 3 years, but they have been. Yes, but they have been.
We have at times had to do that. So you're basically talking about Wednesday or Thursday too? Is that what you're talking about?
Pretty much. They're more open. I mean, the second Wednesday is planning board, so that one wouldn't work. But
Did you send that calendar out today, or?
I didn't. I sent an email. It was early on just after you were all appointed.
And the RSU also uses this building on
That's
Wednesdays.
true. That's right. I forgot about Wednesdays.
Well, it's once a month.
Yeah.
Because they rotate.
They
correct?
rotate, and sometimes they change. So Wednesdays is a bit difficult.
So
that
Thursday
way.
sounds like a good option.
Thursday might be.
Yeah, it's a tough, it can be a tough night for me.
Yeah,
Thursday.
and
Yes,
it can be for
Thursday
Kayla.
I usually have a standing meetings,
Mhm.
but they
Mhm.
start at 5, so if we did remote, on my way home, I can tune in and pop in as I drive by. But that might be difficult for me, particularly
Winter, yeah.
for instance, this October, every Thursday I have a meeting at 5.
How late does the RSU use the building on Wednesdays?
It's hard telling the school board.
School board meeting?
Yes.
Would they be?
But they rotate, right? I mean, it's
They
not.
rotate.
They do. It's
And
every other week, so
and
it isn't locked
So it's about
in.
once a month. They're here on Wednesdays.
Roughly. Some months it
Yeah,
ends
so
up being
if
twice.
we picked
So
a
if we pick a day,
Wednesday,
they rotate around
I think you could work around that if you liked Wednesday better.
Or even, I mean, Monday, the only issue is when you have a Monday holiday, but we could work around those.
Mondays are a bad day for pretty much everything I've found. But for being a big creative energized meeting, Monday's kind of hard. I would vote for the Wednesday slot. I think it seems
Monday
like
would also be unkind to Sue.
just,
Yeah, but I wasn't going to say that.
That's why it's bad.
I
We
don't
have-
always work on Mondays, and I live in Richmond.
That's why it's bad. Sue's not in town.
Yeah.
Budget and Finance Committee, what days do they?
Well, generally Tuesdays
Okay.
in between select board, and that will begin in pretty much end of March, 1st of April.
Okay. So
Mhm.
I'm good for Wednesdays. I'm good for Thursdays. Thursday's not great, so I'm good for Wednesdays.
And I don't know if we've gotten the school's calendars yet. When we do, we put in their
Right
meetings.
now, on Wednesdays, the fourth Wednesday of the next couple months seems to be the most promising. It's open so far as I click through. The second and the third Wednesdays are occupied by Planning Board and the RSU.
I think we grab those Wednesdays would be my vote.
So looks like either the first Wednesday or the fourth Wednesday.
Does it look, well, I'm almost there, but does it
Okay.
look like the school?
Would it make sense, Sue,
Schedule is
to
in
put
yet?
together a proposed schedule for some period of time and have that, and we're gonna set the next meeting probably and have a discussion about that?
Oh, Melissa has gotten the school schedule at least for a
Yep,
while.
up to December,
Yeah.
the first and
You know,
fourth Wednesday or
like we do the
Yeah.
budget committee
Yeah, it could.
and selectmen have a schedule throughout the budget development and review and adoption process, which goes over a number of months. Maybe that would be something to think about.
Do they try to do it for the whole year, or they just take a chunk of time, like
A chunk of
quarter?
time, a chunk of time for them.
Well,
but
for their season.
For their season of activity.
But for you, you could book it for the year, and then you'd know. And you wouldn't have to worry about dates, you'd secure those dates, and although sometimes we have, despite our best efforts, we have some school issues, don't we, Sue?
Yes, because they tend to change their
But we can
meetings
try to work
occasionally.
around those and have a block for a period of time that you agree on.
But Kayla is right that the last Wednesday is available all the way through.
Is the first Wednesday available if we think through till the holidays? We don't want to meet the last Wednesday of November or of December.
That's true.
Potentially.
The first Wednesday of September is, and October, and November. Yes.
Yep,
I
and
just wanted to double check and make sure that wasn't the day after
Yeah,
the
that's
election.
why I'm suggesting that you pick a date for your next month and then have Sue,
Well,
and Kayla, she's pretty tuned up still on the schedule after all,
Yeah.
a year away or whatever.
It hasn't
She
been,
has-
it's almost been a year
Yeah.
since my.
So maybe
She
you
also
could
knows
put
where
together
it
a
is.
proposal that avoids holidays
Well,
and
the
avoids
first-
conflicts, and
So
then we
the
have
first one
The
does
first,
that.
the
pretty
first Wednesday
sufficiently.
does that from now to December. And then in December, or when it gets closer to December,
Okay.
maybe
Look
decide.
at it then.
Yeah.
But we could lock in the fall quarter right now and not have more emails for folks to chase. And if most of us are good with the, what did we say, first Wednesday?
Would first Wednesday work
Let's be
more?
done with that and move on to the next.
I agree with that.
I can make a motion to say first
So
Wednesday.
you're talking the 7th for the first meeting?
Yes.
Yeah.
That would
I
be the
can't
7th.
make that one, but that's the only first Wednesday I can't make. And if you want to go without me, I'll let you.
Only with your permission.
I'm kind of thinking the first big thing that this committee should address is a planner. Am I?
The first big external thing, yeah.
Yeah. Because I mean, if this were our September 7th meeting, what would our agenda be? I mean, what's more important right now?
It could be to review the prior plan.
And to talk about, you know, your thoughts about this whole process maybe, and what you're expecting out of it, because if you're going to put together an RFP, you're going to be asking the consultant to be responsive to, you know, a program that you're going to be, you know, implementing. So you might want to have a discussion about what you think it ought to be, look at some other RFPs maybe, and just have a general discussion amongst yourselves about what you'd like to see out of this process.
Right.
Just a thought, I mean.
No, but if we begin with the end in mind, in this case, the end being getting a planner, you know, what do we need to do before we put the RFP out? And what do we need to do before we hire the planner?
You have to have an idea of what you're going to do.
Yeah, exactly.
Yeah.
So if I think that's the first big item that we need to address, and so maybe if we spend our next meeting reviewing the plan, you know, what's in it, and we've all got a copy of it. It's on the website.
And a lot of it's going to be, the cost is going to be dependent on, you know, is the planner, you know, more of a facilitator, you know, somebody who is, you know, leads the group through these complex topics. Are you expecting the, you know, the consultant to do most of the work? Probably that would be unreasonable in some ways, and probably financially not, you know, something that would be feasible. But you, by the same token, a lot of the work is probably beyond the depth and scope of what we could do, because that's what these people do. So you have to have some sort of a balance. But make no mistake, the folks who were here last time know that there's a level of work for the committee people.
Yeah.
And so you got to figure that all out. What do you want from the consultant? I think a good way to do that would be to look at some RFPs and, you know.
In the bit that I looked at, as far as in general, and looking at some of the old forms and structures from when we had a state planning office, I mean, it would seem to me that we would discuss early on what part of it is boilerplate and what part of it do we want to hone in on that's specific to our community, and kind of meld those two together. But that would kind of be a starting point.
Exactly. There is going to be a lot of boilerplate and pro forma sort of stuff, but yeah, that's exactly it.
I mean, I think this document, to me, this document is a great start. I mean, all those categories, we're not going to probably drop any of those. I think we'd be updating. Some of them would be boiler, but most of those chapters would need revision and revisiting in terms of the current state of housing, for example, in Southern Maine.
Sure. When you guys worked on it last, I don't know that PFAS was even on the radar.
Right.
So that's going to be something new.
It was still legal. Yeah.
So if we did our homework between now and the next meeting and said, okay, everybody take a look at the plan, and, you know, great suggestion. I want to call you Charlie.
That's okay. Everybody does. Yeah, my wife.
Is Charlie your brother?
Yes.
Ah, okay. He was great. He really was. You know, and look at the plan. Okay, you know, is most of this still relevant? And so, okay, we need this. And what sort of agenda items we don't have
parceling out a lot of that work to the committee members, and then he's going to be synthesizing it and putting it into some kind of cohesive, comprehensive whole that will be hopefully something that the community will embrace. And we'll have hearings to find out about that. We'll, you'll present it in pieces and so forth, or maybe some other way. I don't know. We'll have to decide all that once you get somebody.
Yeah. I just having been through the process with outside of the municipalities, also quite a bit. I think ideally, what I think constitutes a good planner is somebody who's knowledgeable about the topic, whether it's municipal or just anything, strategic planning, and can guide us through the process and essentially put the document together. I don't think anybody here wants to do all the writing of it. But as far as reaching out to other stakeholders, I think that's ours. John might want to, have some interests that he wants to reach out to and willing to take that on. Greg might, Frank might. I mean, we've got some wonderful resources here from people, their backgrounds of what we could reach out to and the knowledge. So I think the committee itself can do that. The person who just kind of guides us along, keeps it flowing, keeps writing up the plan as we go along, and is knowledgeable about, hey, you ought to have this, and I saw this plan, and then another one that I did somewhere, something is I think what we ought to do. So I'm not trying to lead this, but I'm just wondering if that makes sense, that our next meeting, everybody's familiarized themselves with the plan. What is it that we really think would be good in a planner? The attributes, put them together, and then could you get us some RFPs?
Yeah, Sue said that at the outset. She has some already.
Okay.
She can send
Okay.
some out.
Yeah.
And I mean, we just started, or I should say Sue just started trying to identify planners. And so it's not, as I said, as easy as it was. She put something out on the clerk's listserv. We're contacting the councils of government, ours, our GP-COG, AB-COG, and some of the different, organizations like that. As I said, there's no state planning office, but there is a DECD, we can talk to them, and other agencies of state government that do planning. So I'm sure we're going to shake some planners out of the trees, but it's just not a thing as it was before.
Yeah. Are those land use planners in general, or were they land use planners that had experience with comprehensive plans? Maybe I couldn't get that specific. But
I couldn't get that specific just in doing searches. I've left messages with some of these folks.
Good.
I have had some clerks get back to me and let me know who they use to update their comprehensive plan.
Great.
One's in Cutler. I'm not sure we'll use that one. But maybe. There's one that, where was it? Was it York that used? No, there's a contract planner with AV-COG that also does Southern Maine Planning and Development. So I've got a few names.
Got a good list going.
Yeah, I've begun, and I did find that the Maine Office of Community Development doesn't assist towns in any way with the comp plan and doesn't have planners, which doesn't make any sense to me. But
When this was a state requirement, of course, people were in this business heavily, and so it's less. It's not now, and it's less of a business, if you will. But Chris had a great idea, and I think this is another option. And so I would suggest that we post an ad on the Maine Municipal Association, classified ads, and among other things. But what you see today too are you might get somebody who's left a municipal planning full-time professional position to start their own consultancy. He knows somebody really good who's done that. You might also find somebody who's a professional planner in a larger jurisdiction who would do it on a part-time, on a basis as an extra job, kind of thing. So there's some really great planners in Maine, but and then there's still the independent consultant type planners. So I think we're going to find somebody, but it's just a matter of getting some names together and getting the word out and advertising the right places, and we'll find somebody.
We'll find someone good. Yeah.
And the RFPs I found are fairly recent. They're from like 2021, some of them. So.
Yeah. And it may turn out that I'm wrong. I mean, there may be planners everywhere. I don't know.
That's good.
I don't have as much experience with this, so in terms of what a planner does for us, how much of a time commitment is it for them? Do they just meet with us on our Wednesdays, or do they do work outside to assist reaching out to resources? what level of commitment is it for them?
The second one and then some.
Okay, all right, thank you.
Yeah, it's a big commitment, and as Brad indicated, writing stuff up, doing research for you, you'll do some, and you'll assist to the degree you can, but it's a lot, it's the meetings and then a lot more.
Are there job descriptions that are available? And this is just to understand the full extent of the scope of their work. So when we're looking, I mean, I'm sure to a certain extent they'll have resumes and things, but it would just help solidify. Are there any job descriptions available that we have or have used in the past? Or
I haven't looked for that, but I can.
We can certainly get municipal planner job descriptions because I mean, basically the towns that employ full-time planners, they're doing this on an ongoing basis. What we're calling comprehensive planning, they're doing it on a day basis. So that would give you an idea of what planning people do, planning professionals do. You know, Kayla could get us someone from Portland, right? So you can see what they do. But anyway, you know, but this is a one-off kind of deal for us, and then we implement it. Hopefully, we have an implementation committee. I think that was referenced. The follow-up on this would be another committee that would help guide the recommendations of the plan to hopeful completion.
And what's the expected time frame that the planner would assist us with, or is that depends
The plan
on
would assist you during the time you're doing the plan, which would be the 2 to 3 year period.
Okay. All right.
And then the implementation phase, which I think some of you people are on before too, that would come after.
Okay.
Yeah.
As Dawn alluded to, not to get the cart in front of the horse in any way, and certainly getting the consultant planner is key to this, I would think, is the fact that there are department heads within the town that definitely are going to feed us information. I would recommend it sometime early on that there be some type of survey of the community, which would also help to direct us by finding out the issues.
Yes, we did a survey in 2014, I think, and so I think that's a great idea to do something like that again. And it's a lot easier today than it was, and so that's a really good idea to gauge community interest and to find out what values people have. Yeah.
What percentage of the year-round residents of Raymond do you have emails for?
We don't store emails in the town office for most. We don't store emails in the town office for most people. Though we do have emails for people that have signed up for the Roadrunner and compost bins and certain projects, but we don't, as a general rule, have email addresses for people.
Would the town have any privacy concerns if the committee were to ask the town to ask Sue, for example, to send out an email to everybody who had emails for?
No, there wouldn't be privacy concerns.
Okay. But it's a pretty low percentage is what you're saying.
Yes.
Yeah.
And it would be kind of targeted audiences because they signed up for specific things.
Yeah.
And it would be people who are already engaged with the town, usually.
Yes. Right. Your best bet would be to create such a survey and then put it out for everyone to do. So you would advertise that the survey is out and to where to go if they wish to complete it.
I recall, this is dating, so this is a while back, but I remember attending at town office. There was a meeting of, and it was just basically dispersed as general information to the community to come in and talk about what the priorities were in the town. I think what happened at that time is #1 was clean water, which was interesting as far as what was most important with those individuals that showed up. Once again, probably a couple of dozen people, but even a couple dozen beside us that are engaged enough to give an opinion about what direction we should be going, where they think the issues are going to be in the coming years. Would be helpful. But once again, that's a cart before the horse. Getting a planner to guide us would be #1 priority.
So I'm kind of thinking if we came here next month, looked at the plan and just some ideas. We have our RFPs, and what do you think, Don, is a realistic time from the time the RFP goes out? And do we mail out the RFP or
Yes.
we go through? Okay. So
we'd advertise its availability in places where planners might hopefully look for such opportunities. We would mail it out to known planners directly. So we'd publicize it to the best of our abilities, And you have to give a sufficient amount of time, because it's going to be, I think, somewhat of an undertaking to reply to the RFP once you see what it is. I would think
30 days anyway.
a month, yeah, anyway. And then you're gonna get them in. You're gonna have to have a meeting to go through them and decide who you'd like to interview. And then you're gonna start up interviews. So there's another month. You see how we get to deliberate municipal speed, all deliberate municipal speed. So I think your best case is probably, maybe the first of the year or something like that.
Yeah. Is there a requirement to use an RFP? I'm wondering, because did we use one? I thought
we did interview a couple of planners, and Rich floated to the top.
Yeah. That's my recollection too. We started, GP Cog had someone who kind of got us in the initial meetings, much like you're doing, Don. And
the other thing we had back then, I think we had Amanda Simpson too, right?
Yes.
So Amanda Simpson is now the Director of Planning Development for the town of Falmouth. So she was very helpful.
Yeah.
We had her on staff here in a different capacity. So I think she helped get things rolling too.
Yeah. And GP Cog doesn't do anything
Not
with
that,
planning
right.
any longer.
They don't do planning.
No, not at all.
Wow.
They become more of a transportation organization these days.
Yeah. All of the planning information they have on their website is from the 90s.
Wow. So, I mean, what's the downside of doing an RFP is not having a planner in place till January. And
well, you might do December, I don't know.
Yeah.
Yeah, but we're not going to get much done.
The upside is the planner knows what we're looking for. It's a broader section of people, rather than just 2 or 3 that we talk about.
The reason that you do it, I mean, there may be a way to short circuit it if you wanted to do it faster, but the reason that you do it is so you get a variety of, you might talk to 4 or 5 people, and you'd learn a lot about planning and how they approach it by talking to different people, So I mean, if you could select somebody, but that maybe would close some opportunities that you wouldn't know about if you didn't talk to people who are responsive to your RFP.
Sue, the RFPs that you're digging up, are they RFPs that towns have put out for general planning services?
No, for a comprehensive
For
plan.
comprehensive plan. So
Yes.
if we get 2 or 3 of those, we're going to have a template that will be spot on and adjustable to what we need.
Yes, you can pick and choose different paragraphs or different pages
cut
that
and
you like,
paste,
yes.
and
And I can paste them together for you.
And I think it's incumbent probably on the group to go home and before we come back for the next meeting to have a sense of the categories in the 2004 plan.
So Sue, can you send if they don't have the plan, can you send the plan electronically to everybody?
They already have it.
Oh, they already have it,
access to
okay.
it.
So can you send the RFPs to them ahead of time too?
Yes, I
so
can
they
send
see
that tomorrow.
We can do that kind of thing,
Yeah.
push things out to you electronically so you can see it before the meetings.
So we're coming to the next meeting well versed in what an RFP looks like, and everyone hopefully will have had a chance to read up on the current plan, and also with a sense, which I was hoping we'd spend a minute on tonight, which is which of these items are the hot burner items, because we obviously want to address all of these and maybe some new ones and maybe drop some out, but to me it seems like there's so much info in a comprehensive plan. There's got to be like 2 or 3 at most kind of key items that get rolled ahead. We're not going to roll all 10 elements out and succeed with all those.
Yeah.
But 2 or 3 big things, whatever they are, housing and economy or conservation and
my experience has been in preparing for numerous accreditations, evaluations, and inspections in healthcare. What an inspector told me once is, what you want to be looking at is what's on the news. So what's in the paper, what's on the news, that's what they're going to be looking for. So it's not that the other stuff isn't important, but I think that's one way to kind of identify. So I mean, I joke about PFAS, or you mentioned, John, housing. Housing seems to be pretty hot right now.
Yeah.
So it's those type of things, but.
Right. I'm just kind of, I mean, the way I would do this if I were trying to do it for our company is I basically would talk to people, in this case, talk to some other communities. Gray, I think, just completed one or is in the process of starting one. I think New Gloucester completed its. and I'm happy to do this. Maybe somebody would like to help me with it, but get on the phone and call a few communities. You know, when did you last update your plan? Who did you use as a planner? We're happy, and then send out.
That's what Sue's doing.
That's what I'm doing for you.
Oh, you're doing it. Okay. That would be
That's what I'd
great,
be
and then
down.
just send the RFP out to them rather than, you know, if we advertise the thing, you know, and we gotta wait however long before the publication of the website. I don't know, but I could see that just dragging on for 30 days, just waiting.
Well, no.
Well, one of the things I was going to say is while you guys are looking for a planner, one of the things you should be thinking about is what is your vision individually for the town.
Right.
Comprehensive plans are developed to direct growth and to affect the zoning ordinances for the town. And they're going to be that's the document that guides the town for the next 10, 15 years until we do this again. One of the comments I heard tonight from, was it John?
Sean.
Sean, was that he was on this committee because he didn't want to see Raymond turn into Wyndham. Well, comprehensive plans were developed to slow sprawl, because if you don't have controlled growth, you get it everywhere. And my role for the town is I'm code enforcement, zoning administrator. I've been doing it. I did it for Portland. I've done it for Wyndham. And zoning is the most important piece to direct growth. We have areas in town where we have 3-acre zones, we have 2-acre zones, we have 1-acre zones. We have commercial districts and residential districts. We have a shoreline zone. This comprehensive plan that you have did a great job. Raymond is a wonderful community. That's why I live here. It's probably why most of you live here. So I think that, you know, reviewing the plan, coming up with what your vision is, where you think growth should happen, where you want to see this town, where do you want to see it go?
You should be the mic, I'm sorry.
Well, I thought I was talking loud enough. You know,
You probably are for the committee, but.
I think, you know, I'm not a planner. I've worked with a lot of planners. Don was alluding to some of the planners I know that I worked with in Portland and Wyndham. Wyndham did a comprehensive plan while I was there. It's a great opportunity to get public participation, find out where we want to go as a town, and keep the ship floating in the right direction. Because this is a great town. We have some of the most precious mountains, rivers, streams. We have clean water. And I think that's what we all want. We want it for our kids. We want it for our grandkids. So I think it's a real important task that we have. I'm excited to be here, and I know you wouldn't have volunteered if you're not. So, you know, I didn't really want to say too much, but I think this is an opportunity for us to shape the future, and I think that's why we're all here.
Yeah, I would second what Chris is saying. Just real quickly, what I had jotted down was, this is from the Maine Communities Comprehensive Planning Committee 2005, and it basically just defined comprehensive plans are the legal underpinning of zoning ordinances, intended to ensure that the power of the zoning is not used arbitrarily, unfairly, and with attention to documented need. And that just seemed to me to be fairly succinct as far as describing what a comprehensive plan's goal is. It's the underpinning of our zoning ordinances,
Well,
legally.
I think it's part of it, but you know, we need to. I mean, for example, should the town be purchasing land for, you know, public use? When, you know, if it's in the plan, then when something comes up, you know, what does the plan say about it?
Sure.
Yeah.
But as you say, Brad,
and-
it's use, so that's the
Right.
word. It's nice we've got a liaison to the planning board here.
Right.
I mean, that's an excellent piece of resource.
Right. It goes far beyond, though, I think, Chris. It's an important part. If you go back to the plan that we had, when was it, 1990 or something, someone mentioned? Yeah. I mean, that one thought that the way to slow sprawl was 5-acre minimum lots out in the area. And Raymond became the fastest growing community in Cumberland County, in southern Maine, I think, wasn't it? We went from...
What time period?
When we did our started the plan in 2001, so the census from would have been, what, 90 to 2000?
Yeah, I think in that time period there was a lot of you know, proposed development on the boards, and a lot of it didn't happen. But you know, because with the recent you know, what had been sort of a housing boom. We saw things coming back, but now perhaps they're cooling again. But Raymond as to my knowledge, has never been the fastest growing. I mean, when you look at fast growing communities that probably would regret a lot of what happened, my hometown Scarborough is one. Gorham was the fastest growing town in the 80s, for sure. Maybe Scarborough in the 70s,
Right
early
now
80s.
it's Wyndham and Auburn.
It's Wyndham and Auburn. So it's not us, but that's good in a way, because, you know, we want to preserve the values that we have, but you can't have zoning that's, you know, discriminatory, as Peter, you know, outlined. That's a big part of it. But there's also, you know, there are other elements. You know, there's environmental protection that's unrelated to zoning. There's capital planning, which of course we do in a much better way than we did, you know, 15 years ago, 18 years ago. So there's all kinds of different elements of the plan. You'll see it when you look at the plan. But he's right. I mean, that's a big part of it.
Chris, it goes beyond zoning.
Oh,
For example,
I totally agree
bus
with you.
service was
100%
something that
agree.
we advocated for.
It's everybody's vision.
Yeah.
And, you know, whether
Can you go to the
it's-
podium?
I guess I should have sat at the table.
No, I'm totally in agreement. I just wanted to make the point that this plan is the underpinning for zoning, is how this all came about. But it involves, in the 2005 guide that he was referring to, I think it's 255 pages of guidance to the comprehensive plan, which we don't get from Maine State Planning now, but there's a lot to this, and I agree with you.
I mean, to get buy-in in the community too, this needs to be the community's plan, not the committee's plan.
Absolutely.
And if it's seen as the committee's plan, the community's, it's
Well,
just
that's
not
why
gonna-
as much
yeah.
outreach, I think Peter
Yeah,
hit that,
exactly.
you know, the survey, you know, having
Stakeholders.
periodic
Yeah, and we can work
sessions
on-
for a public hearing.
We're-
You know,
we're-
you're not, and no matter what you do, by the way, you're not going to get a universal agreement. You know, when this thing's done, hopefully it's something that, you know, people are going to embrace and think is a good plan and approve. But it may be bumpy getting there, and you know, people don't get engaged until they see something in the plan they don't like. Then they get engaged.
I think that's a good point. I think we're going to want to see both sides. We're going to see people that want growth. We're going to see people that don't want growth. There's going to be a lot of disagreement, I hope, in this committee, and then we come to a consensus. That's what a good committee should do, is disagree and then agree to disagree.
And then compromise.
And compromise.
Yeah.
Compromise.
I think John is on to something when he starts talking about the 10 areas. Looks like we're going to be spinning our wheels for a little time as we get this thing up and running. Maybe the next time we come back after reading and going through the comprehensive plan and looking at those areas, we can come back and talk about what areas we have interest in, or what areas people we know have an interest in, just to find out where people are. And that would be some place we could start some discussions. We can have some discussions before we hire a planner.
Yeah.
I mean, I think we should, you know, lay it on the table, what's important to us, what's important to the people we know in the community. It's a basis of a start.
Maybe, that's a great point. Maybe another exercise before you come to the next meeting would be to write down the 5 or, you know, 10 things that are important to you about Raymond.
Or maybe the top 3.
Top 3, okay,
So we
top
keep
3.
Keep it in a
Manageable.
digestible box.
Yeah, and pick 3
Pick
of the
3.
10 that you think are
Most
important to you and to the people you know.
And with that, we will have some overlap, but we'll probably cover all 10 to 12 chapters.
Absolutely.
And there's probably a couple chapters that aren't in here that might fit into one of the boxes, but
There may be some things that aren't in there altogether that are important now that weren't then. I don't know.
I think the important thing in a committee like this is you come and you listen to the ideas people put out, and if you don't walk away with a change of mind and what you walked in believing, then you probably aren't doing your job.
you're not doing your job. And the planner's great, but we're hiring her or him, and we want to give that contracted consultant a pretty focused scope of work, and with clear targets of what our priorities are, recognizing we got to hear the public as a big piece, and the planner would help with a couple good public presentation things where folks come up and pin the tail on the donkey, on the boards and stuff for what their favorite, most biggest needs are in the community. But yeah, we can be most efficient use of expensive planners by getting them a relatively narrower focus, not necessarily narrow, but focused scope of work. That one wants to spend most of your time on housing and land and or whatever, and not have him just or her go free range on the whole book.
I would say something I found delightful is section 1, which is history. Ernie Knight's, I don't know how we're going to improve on that, but maybe someone will have something to add, but it's certainly enjoyable when you read it. It really gives you the background of how Raymond came to be.
I can give everybody applications for Raymond Casco Historical.
There we go. You get at least a paragraph for that, Frank, in the new book.
You know, it would be interesting on your theme of top 3 is what are our personal top 3, but what do we see as the top 3 for the community? You know, not us, but ours plus, you know, what do we think Raymond thinks are the 3 top for here?
And I think to add to that too, from a personal perspective, there are things that we know we need to address. We will need to continue to address affordable housing. We'll need to have zoning be a major part of this, but I would love to have recreation be a part of it as well. So I don't want to set aside what we absolutely need to have. I don't want to risk losing what we need to have for the things that we would love to have, the things that are going to make Raymond, continue to make Raymond what we love about it, but may not be as or a little fluffier than affordable housing or education or something that we know needs to be on the agenda.
So that,
I think we have a charge.
yeah, I think we do. So we got RFPs coming. The meeting's going to be on that Wednesday, the 7th.
I believe it was the 7th.
So in 2 weeks?
So
Yes, roughly.
It is.
Wednesday the 7th at 6:30 here.
Mhm.
Wednesday,
September 7th.
And we'll come with 3 items that we think are important to the community. We'll have some RFPs to study. We'll talk about the plan.
Right.
It's good to me.
Do we want to have a target for run times on these eventful nights that we're signing up for?
The ZBA just did that. They said let's stop at midnight.
They went till 1:30 the night before that.
Is that local time or?
I think you want to have maybe a couple hours.
Yeah, I think they said no new items after 10.
Yeah, I don't think you want to go past 10 to begin with, but that's just me.
It's fine with me because I'll be in Arizona for the winter. It can be 3 hours after the time change.
6:30 to 8:30 is a pretty good run for a meeting midweek. I mean, we don't need to go to 9:30, do we? No.
Okay. No, thank you.
I think a 2-hour meeting. I mean, it'll focus all to be. It'll encourage us all to be focused in what we're saying and trying to get to common ground or areas that we need to debate further. But I just suggest a 2-hour.
And I think that's right. And I think the way to make I'm getting a sense you want to really get going and make good progress. The way to do that is to have the materials you need transmitted to you electronically between meetings so you can come in prepared and ready to go and make some progress. And we'll do our best to do that. I mean, we just need to know what you need.
So Sue, just to reach out, I just kind of have I downloaded this and basically it's the use map for Raymond.
Yes.
And the different, but I've got no way to know if this is the current. This is 2008. So are those questions we can just ask you?
That's something that Chris might be.
Oh, I might be able to
2008.
answer
Yeah.
Would you let mine go into the mic, sir?
I don't know what version you have.
It just says it's the 2008 use map for the town of Raymond.
Zoning map?
Yeah.
I think that's out of date.
Yeah, I know of a couple of amendments since 2008.
Yeah,
There was
some
an
of this has
overlay
changed.
district.
Mm-hmm.
Some of that's changed.
Yeah.
So a current
get you
use
a-
map
we
would
can get
be
you a
A
helpful.
current use map would be helpful, yes.
Yep.
If there's a need to go later than 8:30, we can always take a majority vote of the board to do that.
And the other thing, I mean, people have varying familiarity with the community. Some people have been here a long time, some people not so much. If there's anything at all that you think would be helpful, contact us. We'll send it to you. Any documents about the town history. I mean, the Ernie Knight thing, that's a great suggestion. There's all kinds of materials that you could review, or not. I mean, but, you know, it's, I think knowing something about history is important to maybe developing a path forward. But we'll provide whatever it is you want. It's individually. So, I mean, some of the old timers, like myself, and maybe not Frank and Brad or John, but we can, Greg, we can send it out to the people who are newer.
Well, and one thing, if you don't mind, I'll throw out is that we do have a sizable election coming up on November 8th. It's quite soon, but if the committee had anything they wanted to try and get out to the community, or do a straw poll type of
That's a great opportunity
thing
for
at
the
the
survey.
election, it is. 'Cause Frank has some experience with how many people will stop and talk at the
Absolutely.
election. He did that for the
Absolutely.
blacksmith shop.
Yeah.
But November's is potentially going to be huge, so.
When do you go south or west?
In December.
End of December. So you're here 3 calendar year end, and then back in May?
Be back in April.
April.
Yeah.
Excellent.
Quick question. How well do you know the town? And that's rhetorical. I mean, think about it. Would it be useful for us to take a tour sometime of the town of Raymond and see the
Yes.
hither and yon of it? Because
Yes.
Raymond covers a pretty
That's a
big
great
territory.
idea. That is a great idea.
And it's interesting to go from the tip of Raymond Cape to the gray Raymond line in North Raymond, and around the horn here.
And not to belabor that point, but as far as in Ernie's history, he talked about just the size of Raymond. And one of the things that interests me is just the topography. So, I mean, at one point, a few hundred years ago, I mean, we also incorporated Casco and part of Naples. Right. And they actually had to cut it down. So we are pretty big land-wise, but when you think about planning and zoning, we're all hills and lakes.
Yeah.
So as far as actually boulders.
So we have a rec bus. We have a town recreation bus. We can have our rec director, who has the appropriate credential to drive the thing, do that if you want to. We have a 27-foot Coast Guard patrol boat that we could probably get most people. I mean, the committee certainly. I think we get you on there, but so we can take a tour of the big lake. And but I mean, we've got, besides Sebago, we've got 5 or 6 other ponds. 5 or 6?
5.
5 ponds, 2 lakes. So, so if you're not familiar, that would be great to take a drive around.
Yeah, I love the idea.
Raymond is an amazing town. Once you get around it and start to see some of the things you get to see here, it really is an amazing place. Well worth the tour. And Don's right. You've got to take that boat trip if you haven't taken that boat trip around Sebago and to see.
Shoreline.
And right now, if you're following, and probably you are, the media, right now we have a unprecedented in my career and I think in Chris's as well, and violation that has happened on Sebago, and it is striking, and it will tell you why you need to protect the natural environment and why this process you're in is so important, and to have strong ordinances and to uphold them. And that's what we're going to do on this one.
What would you suggest for a boat tour, like a Saturday or Sunday or something?
Yeah, I don't know. We got to do it before it gets too cold, and we probably, I mean, we're probably going to need the 2 boat deal again, so we could do that. We could pull it together, and we could do Sebago.
And what, meet down at Raymond Beach?
Yeah.
Yeah.
Yeah, I think our boat.
We
We
had
had 10 on our boat.
10, but there's 3 crew members, so it's 7.
Yeah, so 7.
Yeah.
So we need to have a second boat, but we can do that too, I think.
Yeah,
So why don't we put that on the agenda, because September is probably going to be a great month for that.
it is.
and then we'll,
Even into early October, it's not a bad ride.
yeah. Yeah, no, that would be,
You can go goose hunting.
what's that? Yeah,
You can go goose hunting.
yeah. And then the bus tour too.
Yeah, the bus tour, that's no problem, we can do that anytime.
Right. We need a special driver for that, or?
Yeah, Joe has the school bus driver license or whatever the credential to do that.
Joe
I think
Bruno?
Nathan, no, Joe Crocker. We actually have if you don't know, we have now a full-time recreation director who's great. He's got excellent programming and he's working a lot with young people, but also he's working on developing programming for adults and senior citizens. I think that we could do a lot more in that area. There's the whole age-friendly thing. We're going to get this school here, so we're going to have an immense opportunity there. That's a big discussion, is what do we want to do with it? It's much larger than what the town needs for a town office. I envision that you could have adult education, you could have maybe some nonprofit presence there, you could have different committees and different organizations.
Community center.
Community center, the library, of course.
Voting.
Now we have the town library. The library is a town department. So Raymond's kind of on a roll moving forward, preserving the values of the past. But I think you alluded, I think, to the idea that we should be looking at some of the what you call them, fluffier things.
Fluffy.
Yeah, well, we're
Very
big
technical
right
term.
now. Right now, we're kind of big on fluffy, I guess,
Yeah.
if you want to look at it that way. But and that's what makes the community attractive and vibrant. If we're only attracting retirees and the only metric is what's the tax rate, I don't know if that's a sustainable and proactive way to look at it. And that said, I mean, one of the strong values of the town has been the tax rate. But I can tell you from the time here, 21 years, and the 16 years roughly I spent in Rockport, you can have both. You can have low taxes and great services.
And fluffy.
That's fine. Yeah, so that's an important point. That really is. I mean, what don't we do now that we might want to do?
What a difference in the village. I said, what a difference in the village.
Oh yes, that was done on a grant, a 50-50 grant, all deliberate municipal speed. It only took 7 years, but basically we went from a federal program to a state and back again a couple of times, but it's now done as of today, and I think it's great. And then, because the original project on 302 was one of the first ones I did with Frank's wife, and back then there were 3 women on the board, and they were very much wanting to move the town forward, and so we had the Route 302 development project, we had the waterline project, we did the public safety building, we did the first of the bonds for road improvements, so we did a lot of things. And now people look at those, even the opponents, I think, look at them and say, that was pretty good. And even some people say, who are opponents, I was always in favor of that. That's what happened. The sidewalk was very controversial. There's only been, to me, one complaint about the sidewalk from somebody who doesn't live there. So that's a real significant achievement for Nate and his crew and the contractors.
And from my perspective too, last I knew we still had a AAA credit rating, right?
We do.
That's
One of the few.
One of the few.
When we got it, we were one of 5 or 6, and we got it on the first try. It took Falmouth a lot longer than that.
Yeah, well,
We've always been better than Falmouth.
I'll just use an example. There's very few towns in Maine that have that, so that's pretty good.
When you don't succeed here, we send you to Falmouth to be the town manager.
that's right.
So are we ready to run over what I've captured as the agenda items for next time?
Good, go.
The obviously call to order, approve the minutes of this meeting, review the 2004 comprehensive plan, identify 3 items each that are important to the community and discuss the boat trip plan, and between now and then, Dawn and I will come up with dates that would work for the town and also with the bus tour.
Yep.
And have you interacted enough to consider election of officers next meeting, or shall we put that off another meeting?
We'll see how it goes and put it out there, and we can bring it off the table anytime.
Okay, yep, I'll leave it on then. And then I always put on the end, though you folks can change it if you want, I always have public comment, planning, comprehensive plan committee's comments, and an adjournment. Standard at the end. Is that okay with everyone?
Good.
So is this being broadcast live now?
Yes.
Yes.
So are there any public comments?
Well, it's being broadcast, but the only public right now is Mr. Hanson.
Well, he's not public.
Well,
Staff.
Well, he's staff, but he's also sitting in the public.
I have no comment.
Oh, so it's not public comments from people on Zoom? that-
It would be if
Could be
they were
on Zoom.
Zooming, but this meeting couldn't be Zoom because you hadn't yet adopted the remote participation.
There will, I mean, typically we don't see, you know, a significant amount of public comment, but sometimes, depending on the topic, you do, and so you can get a lot of good information that way sometimes.
Yeah, yeah.
Yeah.
And that does though lead me to a question with Zoom. I will set up a Zoom meeting for every meeting and send it out to the committee members. If what other committees are doing is if none of the committee members are on Zoom, then the meeting is only here. It isn't on Zoom.
Good.
Is that something you'd want to continue, or would you want to allow the public to come in via Zoom?
I think,
Go ahead, Brett.
yeah, no, I'm all in favor of as much input as possible.
I agree with that.
Okay. Yeah, it seems like that would make sense for this committee.
But you have to, and some towns have learned the hard way about controlling Zoom too.
Yes.
And we had to come up with procedures, policies to prevent something really.
Yeah, I
not
have the
good
ability
happening.
of cutting off video and sound.
Right, but we've actually seen a little bit of it here even,
Yeah.
so, yeah.
You post
Mhm.
a Zoom link for the meeting
Yes, it's
to
posted.
the on the Wayman website, just like the recycling committee. Anybody could jump in.
Yes. It's on the meeting on the calendar.
But they can jump into view, but if they're muted, they can't speak.
But you can.
They can raise their
you can
hand
raise your
within
hand
Zoom.
and participate.
That's correct.
So I would just suggest that we perhaps have that as an option, but maybe once we get our feet on the ground and get rolling, just so that we have a course and a speed, and as opposed to having it be public for the next couple of meetings when we're getting organized, I guess is my point.
You
Or-
can use
but-
that option intermediately, you know, when you decide that you're having a meeting that you would really like to have more public input than other meetings. I mean, we may find some of our meetings don't really need public input, and others we would want. So you can decide that per meeting, couldn't you?
Yes, you could. And you could advertise more that we're seeking public comment for this meeting, for instance, in particular. This is the subject we're talking about tonight. And we'll be able to put it on Facebook, on the website, on the sign out front, on the sign by the fire department.
But when it's live, anybody from the top of Pismere Mountain or maybe
Or
Kate
Hawaii.
could show up in a corner in the screen here and say, I think that's a great idea, or don't think that's a great idea.
No, they wouldn't.
They'd have the ability to raise their hand,
yes,
get
because-
acknowledged by the chair or whoever, and then they're on the screen and they're in the meeting.
Well, if the public comment, and I'm looking to you two for guidance on this, but if the public comment is at the end, why would the chair recognize them?
Not until
yeah.
their piece in the agenda. Right.
Right.
Right. Yeah.
Right.
Yeah.
But if they want to comment and you want to entertain comments while you're discussing something that's on the agenda, then the chair would recognize the people. I would let the chair know there's someone that's raised their hand that has something they want to say.
Right. But I like the idea of having the public comment, but maybe just having it at the end unless it's a separate,
separate
agenda
block.
where we're looking for the comment.
Dedicated block. Yeah.
Is there a way to do like a mailer for a survey to kind
That's what we did last time, was a mailer.
And it was
Can be
very
very
successful?
expensive,
But it can be, pardon? It was
Was it
fairly
successful?
It was fairly successful. I'm trying to think what the return rate was.
It was very successful as
Yeah.
they go.
Yeah, it was
Yeah, we
it was
had-
much
we had,
higher than they expected it to
We
be.
had Pat Murphy from Pan Atlantic do it.
Yeah.
You probably know him, and so,
Yeah.
yeah, he was really good, and so, it wasn't terrible. I mean, I think the cost of it ranged, I think the high one was about 20K, and I think Pat came back with about 13.5, and then I negotiated him down to about 10, the Raymond thing. And so it was money well spent for what we got out of it, I think. So it's not big money, not huge money.
No, but, you know, I wrote a lot of articles. I was looking at them the other day for the, whatever the newspaper was at the time. And, you know, we were out there all the time, and just letting people know the comprehensive planning was out there. We did neighborhood meetings. And we were, you know, you mentioned about the election. I'm glad you did that, because that was a great opportunity, as you know, Frank, to just get in front of people and have some conversations. And here's our survey.
An idea, if you were able before then to identify the 10 things that you think are important, let's say, and you had the ability to have somebody at the checkout with a single sheet of paper with 10 things on it, pick 3. Maybe people would do that.
Yeah.
They would, actually. That's how I found out about the Raymond Casco Historic Society. So that, and then that led to the voting of it too. So I thought that was very impactful.
So somebody would have to be manning that throughout the day, and you'd probably, yes, you'd probably get, good feedback, I think.
Absolutely.
Oh, yeah.
It would be great feedback.
Yeah, and there's probably going to be at least a couple thousand people go through there on election day.
Usually it's either the polls or the dump are the best people, but we don't have a dump. The best places to meet people. Talking about politics, those are the best places.
That would be a great start for us. It really would be a great start for us. We're getting feedback there.
So should I add to the next meeting as well, identifying what you want to ask the voters?
That's got to be simple, something they can do fast.
If nothing more than those 10 items, and ask them to pick 3 that they think are important. All they have to do is circle 3 of them. And you know, if we had 4 or 5 people working that day, we could hit almost every single one of them.
Yeah, the polls are open for 11 hours. Oh, no, I'm sorry, 13 hours.
What are they, Sue?
7 to 8. And not 7 p.m. to 8 p.m.
Well, if we didn't have, you know, enough people from the committee, maybe we could figure out a way. I could work on that to see that we get it staffed.
We might have some staff members.
I would work on that, but it would be better if we had committee people to the greatest degree possible. And you know, Frank's right. You got to have enough people so you can handle the flow, so people aren't inconvenienced.
Do either of you know roughly offhand, in person versus, I saw a ballot box in front of the town office.
That's absentee.
And mail-ins. What, roughly how that breaks down for Raymond?
Exactly, I do in a second, as soon as I get to my folder. All of those stats are on the website as well. And right now I have election statistics going back to, oops, and I'll go away. Going back to the 80s, in as much as I could glean from there. With the primary election, no, that was, why am I missing that? With the, let me say, with the presidential, we had 56% of the turnout was with absentees.
56% absentee on the presidential, she said.
56 absentee.
56%.
Wow.
Of 4,300 registered voters.
We had 1,799 absentees out of a total of 3,177
Do you think
cast.
a pandemic influenced that?
Yep.
Absolutely. Well, it has and it will continue to, I believe, because through the pandemic, it really has changed.
Yeah.
The pandemic made people more aware of absentee voting. They tried it for the first time, realized that it was something that was easy to do, and we're seeing higher and higher percentages of absentees. The prior presidential, let me go back to that.
There are other avenues, though. We could have a survey at the library. We can have it at the town office. So as people go in and do their business, there's one that they could fill out and return.
Yep.
That's what we need, is creativity of
Yes.
different places.
We should do that too.
Yeah.
Yeah.
Do everything we can.
Well, is the survey something that could go out with an absentee ballot? Or
No, it can't. That's not legal.
Okay.
It's a good idea.
But we can have an electronic survey that we send out and we advertise.
Survey Monkey.
The other thing that will be going out is tax bills. That hits a few households in town. And that we could potentially put a slip of paper in that said, we have a survey online, or whatever. And if you like, I could look into possibly SurveyMonkey, for instance. There's some
And the
online
Roadrunner-
surveys that could be
The
done.
Roadrunner page is what, once a month? in the
Once a month, we have the
Winnebago?
Roadrunner, you can put it in
Yeah.
there.
And that goes
So
to
we
every
can put
household.
things in there too.
We could
You
put,
could actually
Which
put the
gets to
survey
everybody.
in the Roadrunner.
Yes, you could.
we could put
Because we
this-
could use that space, that
She used to produce the Roadrunner.
2 pages that you have for the Roadrunner. You could actually put that in there, so you could just cut it out and return it.
Send it in or drop it off.
Send it in, drop it off,
Fax it.
whatever you would want. So that's another use for that, because
Yeah.
the biggest thing is about getting this out to people. Electronically doesn't hit everybody. Voting polls doesn't hit everybody.
Right.
No matter what you do, you will be missing a subset of people. So the more ways you can spread it out, the better.
And then, of course, there's social media too, and although people generally only pay attention to that when something bad is happening, but this, we do have Facebook as well, I guess.
put an ad in the Wyndham Eagle to direct people to a website, or tell them that they could pick
Well,
up one
the
of
road,
the
our
That's the
Roadrunner
Roadrunner.
is.
That's the Roadrunner?
It's in the, it's in the Wyndham Eagle
inside
once
of
a
it.
month.
Yeah.
But the Wyndham Eagle, great thing too. I mean, we should get an article about what we're doing, and it's a front page above the full story, I'm telling you. So we get that in the
And
in the
usually
Eagle.
free.
Huh?
And usually free.
And it's
Or
free, yeah, and it
cheaper.
goes to every postal customer. Now, what happens though, I mean, some people read that Wyndham Eagle and our Roadrunner, I'm sure, and when we used to produce it ourselves, and it was like a newspaper, there were people who really anxiously awaited for that to come out. And so there are people who get it and just throw it in the trash at the post office too. So that's a great idea. I mean, let's use the Eagle.
And to answer your previous question, Brad, the previous presidential was only 30% absentees.
So
And
that's a
then
big
we went
difference.
up to almost 60%.
That was 2000?
That was 16.
16 versus
16 was
20.
versus 20, yeah.
So the pandemic had a great effect and will continue to, I think.
Doubled it.
The percentages have remained high since then.
Is there anything local, anything Raymond on this ballot?
Yes. There's the Portland Water District Board of Trustees 5-year seat
Okay.
that's up this year.
That does not usually generate a big
So
turnout.
that's a big ticket item right there.
Yeah.
I almost forgot to do it. That's how big it is.
Yeah. But we don't have our own seat though, do we?
No, we have a shared
Shoreline.
seat with
Yeah.
With
Wyndham.
Wyndham.
Yeah.
And I'd never met our representative until I compelled her to go out on our boat trip to see the violation. She's nice. She's a nice person.
I'd say we got a pretty good list for next time.
Any reason why we can't adjourn?
There isn't. Well, we haven't had public comment. Are there any other comments from the committee? I'll entertain a motion to adjourn.
So moved.
Second.
Second. All those in favor?
Welcome to the August 30th, 2022 Zoning Board of Appeals meeting for the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I'm now going to do roll call. David Murch.
Fred Miller. Pete Lockwood.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Number 1, call to order. Number 2, approval of minutes of the July 26, 2022 meeting. Old business, ratification of findings of fact specific to the administrative appeal. Read notice of violation issued 1/4/2022 via B. Ratchin Esquire on behalf of Q Teams Inc. And the following public hearings on the following matters. Administrative appeal, read notice of violation issued 12/21/2021, Durant Excavating. And we have Administrative appeal, re-notice of violation issued 3/10/2022. Applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine LLC. Then this next one is actually number 4 on the list, but we'll be bringing it up. Administrative appeal, re-notice of violation issued 1/28/2022, Durant Excavating, specific to 28 Whitetail Lane. Then we have administrative appeal, re-notice of violation issued 1/28/2022, B.B. Ration, on behalf of Management Controls for 28 Whitetail Lane. And we have administrative appeal, re-notice of violation issued 3/10/2022, applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine, location 28 Whitetail Lane. Then we have new business, administrative appeal, re-denied business license, applicant Adam Nappy, High Wire Hydroponics. Then we have code enforcement officer communications, and then finally adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, their address, and their affiliation with the application, being it for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board is formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. So, Fred, Pete, assuming that you received the meeting minutes from Sandy, did you have anything to discuss with regards to those?
I do.
Okay, so I'll take a motion to approve those minutes from the July 26, 2022 meeting.
I'll second that.
I was going to take a motion, so I need someone to actually make the motion.
Oh, I motion that we accept the minutes from the last meeting.
I'll go ahead and second that. Okay. So any further discussion? All those in favor of accepting the minutes, we have to do a roll call vote. So David Murch, yes.
Fred Miller, yes. Pete Lockwood, yes.
All right, very good. So moving on to old business. Ratification of findings of fact. For administrative appeal, notice of violation issued 1/4/2022. Applicant Leah B. Roshan, Esquire, on behalf of Q Team Inc., location 18th Wood Road. This is something that got put on the table at the last meeting, so I need somebody to make a motion to take it off of the table.
David, can I just have a point of clarification on the procedure? Just
of course, yeah.
Business, yep. So I think I just want to clarify because I think there's a little bit of discrepancy I'm seeing now between the agenda and what I advised council of in terms of what we'd be covering today.
Okay.
Old business. So just to confirm, my understanding is we'll start as it is with finalizing the decision for the Q Team Fernwood appeal, and I've circulated the draft decision for that. Then we'll proceed to continuing deliberate the public hearing and deliberations on the Durant Excavating Fernwood appeal. Then we would also cover the Big Lake Marine Fernwood appeal, and then we would address the timing issue only of the Durant Whitetail appeal.
Correct. That matches this board's expectation. Does that match our other some expectations as well. Great.
And the application for 28 Whitetail Lane are essentially combined in the same document, and they are initially, going to be decided on the exact same issue, which is deciding timeliness. And so I think rather than make those arguments twice, it makes sense to just pick up what I see is the first new business item and fourth new business item together. Especially since we're only going to address timeliness as it relates to the excavating 28 Whitetail Lane application. Take those two up concurrently to start, and then address the Big Lake Marine LLC 18 Greenwood.
Seems to make sense to me. Stephen?
Yeah, I think it makes sense, and I think